Are we good to go? Okay. All right. Good morning, everyone, and welcome. My name is Sam Ellis, and on behalf of the Food and Agricultural Law Society, I am extremely excited to present to you guys today the first ever Cannabis in the Law Conference at Vermont Law and Graduate School. Cannabis law is a fairly new and developing area of law that tends to be a bit complicated, so we're really excited to provide you all with some new information coming out of the field. In Vermont, adult use cannabis became legal in 2018. However, sales did not start until this past October, which really sparked the idea for this conference and is why we are presenting it to you guys today. Our goal today is to provide information on the legal trends coming out of the cannabis field, and I would like to give a big thank you to the help and direction that we have gotten from the Center of Agriculture and Food Systems faculty, the Black Law Student Association, the Latin American Law Student Association, the Center for Justice Reform, the Native American Law Student Association, and of course the BLGS administration. Over the next few days, we will cover a fairly broad area of topics relating to the cannabis industry, including cannabis production, marketing and labeling, federal and state regulations, expungements, equity, and justice.
Hi, my name is Alyssa Shea, and I'm the other co-chair of FALS. I wanted to update you all on a recent change in the program. In regards to the moderator for the cannabis labeling panel, I'm excited to announce that our very own President Samala will be the moderator for that panel. His bio can be found in the updated version of the program online. I would also like to ask you, out of consideration for our speakers, that you refrain from entering or exiting the conference mid-session. Now I'd like to introduce Vermont's Lieutenant Governor, David Zuckerman, a longtime advocate for cannabis reform. Before he was Lieutenant Governor, he was a Vermont representative, a Vermont senator, and a longtime farmer. Please welcome the Lieutenant Governor.
Put the political side out. Stickers from campaigns, you know. Well, thank you, Alyssa and Samantha. I really appreciate the opportunity to be here, and I'm gonna figure out how to situate my computer so I can see it. It's a great honor to be here, and I want to thank the Food and Agricultural Society here at Vermont Law Graduate School for having this conference. I've spoken here a couple times. I've also worked with the society and folks from Vermont Law School, and specifically the food and agricultural arena on GMO labeling. Vermont was the first and only state to pass a GMO labeling law, which was going into effect and working well until it was overruled by the Obama and Vilsack Secretary of Ag. But that work between this institution and the State House helped craft a law that many thought could not stand up to court challenges, and it did. And so you're in good hands here with incredible professors, incredible research, incredible knowledge, and it's very helpful to those of us making laws, although I'm not a lawmaker anymore, to have that good resource. So thank you to Vermont Law School for that. I, of course, want to point out today is St. Patrick's Day. It's a different green, but you know, it's kind of fun to have that in the same moment. As was mentioned, I was an advocate for reforming our cannabis laws for about 20 years. First introducing bills around 2000. We did a medical law, I think it was about 2004, which went into law without the governor's signature. Then it was Governor Douglas. Another little quirk in our laws that allows, in this case, a good thing, that a law can go into effect without the premature of a governor's signature. We then expanded that law. It was a very conservative version. We expanded it in 2007 to make it a little bit more accessible. And then decriminalization passed in 2013, and then legalization with small home grow quantities in 2018. And of course, with decriminalization, it was kind of curious. You could have it, you just couldn't get it anywhere. So that led to the 2017 law, 18 law to be able to grow it yourself, and eventually in 2020, the law passed to allow retail establishments and cultivation and growing. So if you think about that, it was 20 years of work and 22 years until full implementation. And as I was chatting with a few folks out front earlier, I can tell you I used to lobby the ski industry and say to them, you should support this. If you want more skier visits in Vermont, while the only legal cannabis in this country is west of the Mississippi River, think about the New York and Boston folks who come north to go skiing and look across the 4 northern tier states of New York over to Maine. There's a lot of those folks who are going to go, bing, Vermont, if we had retail cannabis. They said, no, we have family ski areas. We don't want to promote that. I said, have you ever stood under a ski lift and looked up at those chairs and seen little puffs of smoke? I can guarantee you most of the time that's not tobacco. But they still refrained. In any case, to the law we have today and what has happened, there were some overarching goals, hoping to do things differently than other states, particularly to help make sure we didn't have corporate takeover and throw the legacy growers under the bus, as has happened in many other states, which then has almost sort of reversed the situation. People tried to get in and then got back out, and the underground market continued. We also wanted to make sure that we had social equity provisions. We have, as you know, thankfully in society, far more awareness of our past. Those who have been active in the cannabis world have known for decades that the initial laws to get rid of hemp in the 1930s were actually based on a racist message. The word marijuana itself comes from demonizing the plant by associating it with Mexicans and making a Spanish word for the same plant that everybody knew as hemp. And we know that in the 60s and 70s, the war on drugs was created to essentially tamp down both the civil rights movement and the anti-war movements, with incredibly terrible impacts on communities of color in particular. And so we want to make sure that our laws did not continue that, and if anything, would work to try to do some work to repair the harm that was done. So there are some social equity provisions with waiving certain fees in the initial application process and licensing fee. The first year, your licensing fee is waived if you're from an impacted demographic, but also the applications, of which there were many relative to the staffing ability to process them, they were moved to the front of the line. So there were a few different aspects to try to address that. I'm sure that in the next few days, 2 days, I guess, you'll be discussing many aspects of this system in greater depth. It's exciting for me to think about that while this market is being established and growing, that good minds such as those here and many of the you're going to have on your panelists are working hard not only to implement the law, but also to search out the ways that the law can continue to be improved. Because as many of you may know, there are certainly aspects of the law that are quite constricting in a good old New England puritanical way that to those of us who are familiar with the world of cannabis do scratch our heads at. But lawmaking is a process, and there are many people out there who, through either misinformation, 100 years of propaganda, and or some personal experiences and some legitimate concerns, wanted different safety parameters put into the bill, but some of them I think were a little bit overly constrictive. So to name some of those challenges, and by no means is this list exhaustive, we know that the testing regime is very rigorous. Every single harvest, every single product has to have a testing sample tested at labs, and that process, with only one lab in the state, can be slow, and then the state has got to review every single one of those. And so there's a many week delay, over a month, sometimes 2-month delay on approval of product. And yes, flower in particular, or flower can be kept in fairly good shape for quite some time. Time delay does degrade product. So we know that's been an issue. We have municipal opt-in provision. Typically, in a lot of laws, things are permissible unless a town or municipality says no. This is the opposite. So those hurdles in some communities are very difficult. We know that there's staffing shortages at the regulatory level. The state resources were not enough to get it started, but also, like every other business, there's a shortage. And so processing those papers has led to delays. With only one testing lab, that's led to delays, although I think a second lab is just coming on, and then the state also will be working on some testing. So some of these hurdles are being addressed. I would say cultivators, the growers, are what's called price takers in some parlance. And what that really means is that they're at the strength of the retail stores as to what their price can be. And I will say, as a vegetable, meat, egg, and chicken farmer who does some direct market and some wholesale, it's very satisfying to directly sell to your customer, both in developing a relationship, but also in getting a better price for the product. It does take more labor to sell to individual customers than a wholesale box, but you also get a better price. So hopefully, over time, we'll be able to open up some direct market possibilities. Whether it gets to the straight-up farm stand situation, that's probably a bridge too far at the moment, but maybe it's a CSA model with registered customers for individual farms, or maybe it's special permitted events like we have beer festivals on the waterfront in Burlington and other places around the state. What if there were cannabis festivals with those sorts of permits that the vendors could be the producers themselves? We also have rules on concentrates and manufactured products that some of which continue to keep the legacy market underground, and there's some real safety issues there, particularly in processing of concentrates for the producers and the risk there, but also on the consumer side, which either solvents or other mechanisms are used to produce the concentrates can really have health impacts on the end consumer, particularly. And then also, when you don't have the concentrates going through testing protocols, if the plants have been grown with certain chemicals, herbicides, pesticides, fertilizers, those also get concentrated. And so for consumer protection purposes, I believe, and many others believe, that concentrates should also be brought into the legal and regulated market and out of the legacy market. A few other challenges, and then I'll get into a couple of things that are working reasonably well. Starting a retail business is expensive. It's actually no different in this world than many others. When I started my small vegetable farm, we took on $500,000 of debt. Starting a retail store can easily cost $250,000. Not everyone has access to that kind of money. And again, when we're looking at the social equity and inequity issues, access to capital is a big burden for many folks in our communities across the demographics, but particularly in those that have been marginalized and economically disadvantaged through our systemic economic efforts of this country for 100 years. Well, for 400 years, honestly. And then the advertising rules are extremely restrictive. And for law students, one area that I think could be particularly interesting for you to explore is the constitutionality of the provision that in order for advertising to be allowed, it has to be shown that 15% or fewer of the observers of the ad would be minors or those under 21. Now, I learned this week in a little bit of my research for this conversation that what that comes from was the tobacco settlement, which was a contract agreement as a settlement that tobacco product marketing would have to be restricted to audiences of no greater than 15%. But that's a contracted agreement in a legal case. You know the terminology better than I do. But that is considered definitely a question with respect to free speech constitutionality issues. So A, it could be looked at from a court perspective if folks got really interested, but B, there's also discussions in the state to look at whether that number could be increased, whether it's to 30% or some other number that would be certainly more reasonable. Talking with some stores, they can't put sales posters up in the store if it's even visible from the window at the street, because there's this chance that someone could see that who's a minor. We don't have that on alcohol. We don't have that on many other vices. We don't allow sales, but that doesn't mean that you can't market. When I say sales, the actual sale of the product, not sales marketing. There are some aspects of the rollout that I think are going reasonably well. Supply and demand is not horrifically out of cycle. In some states, when this first went into effect, It was just demand was so high compared to supply that there were massive price spikes and so forth. So far, there's glitches, but we're not seeing the extreme swings that we saw in other states. We know that growth in sales has grown significantly month over month from the first 3 months of data. Looks like this will, from other states' data, probably continue for a few years before it then levels off at some happy medium. We do know that many people in the industry at all levels of production and processing are generally paid a relatively reasonable wage, certainly significantly over minimum wage. And in Vermont, I'm going to talk about housing and other things in a moment, because that's just a different part of our economic equation. But many folks are making, minimum wage jobs at convenience stores and other sectors of our economy, or $15 or $16 an hour, 18 maybe. But some folks in this industry are in the $20, $22 an hour, starting wage, which is, better than a lot of starting wages. It doesn't mean it's a full-on livable wage, but it's reasonably better, and I think that's partly the philosophy of a lot of people that are in this sector, just in the world of cannabis and the culture of cannabis, and we could go on to that for quite a while. Let's see. One of the pieces that was written into the law in Vermont was that a significant portion of the resources that the state collects through taxes goes to after-school programs, and we know that after-school programs are one of the best ways to keep kids and youth from getting into maybe less desirable directions. Idle hands, idle minds, who knows where they're going to go. After-school programs have been proven to be very good at not only keeping kids from maybe exploring arenas that, let's be honest, are not quite as either safe for their bodies, nor are their minds as developed to have judgment on quantities and titration as maybe and hopefully we all become as we get older. But also, after-school programs are social development, mental development, educational development in many areas that are really important. So increasing funding for that as part of the resource from this, I think, was a really good fit. Nationwide, according to the CDC, from 2011 to 2021, we've actually seen a drop of about 1/3 in youth consumption of cannabis in youth behavior surveys, with the question being, have you consumed cannabis in the previous 30 days to this date of this test? Literally, I think it was 23% down to 16% said yes over those 10 years. And nationwide, we've seen, I believe it's around 20 states, implementing cannabis legalization in some form or another over that period of time. So it's literally the exact opposite of what many of the naysayers and opponents of legalization, where they said consumption is going to go through the roof, younger going to use it more. Now, I'm not going to say that because the laws went into effect, youth are using it less. Obviously, there's a lot of reasons. This is not causational. But it's certainly a fascinating correlation that I think is important anecdotal evidence. So what could or should be improved as we go forward in the next few years? Because it is a nascent law, it's a nascent industry here in Vermont. Certainly, as I said earlier, with the testing facility shortage and staffing shortages, those are two areas where more rapid testing with the same accuracy, but just having more facilities or more staff able to do that testing will help products come to market faster. That might also produce some competition on the pricing, which would help some of the producers. Right now, a product test is $50 for a test, but it actually can be as much as $500 when you're doing full spectrum testing. So if you're growing 5 plants of a variety and you harvest those 5, you have to test that as a lot. If you then have the same variety and you grow it the same way, but you've got it on a 1 month later cycle, you're spending another $500 for the testing and another $500. So every product tested is pretty expensive, incredibly important testing. But with more facilities to test, the timing and the price will hopefully get better. We know many retail licenses and cultivation prices are still moving through the process. Could there be more support in staffing to make that happen faster? And also, are there other steps we can do with respect to the equity issues and barriers to entry? Maybe it's capital, low interest or no interest capital to those that don't have access to capital. There are efforts underway to remove some hurdles for direct sales of products. As I said earlier, how fast that occurs and over what timeline is a fairly political question. We could get into that later. I talked about marketing and maybe changing that threshold from 15% to a different percentage, but also if there's a store or a purveyor that has done 20 different marketing ideas, their main store emblem and all their different systems, and some number of those all pass muster. Maybe they can get an umbrella permit for a year and just get a review once a year of the signs that they've done, so that it's not a multi-week delay to offering a sale on a new product or a sale on a product that you want to move to make space for a new product, because the timeline on that is pretty absurd. And of course, I spoke about concentrates, and there is legislation looking at allowing for concentrates in higher levels, and that was one of the compromises between the House and the Senate a few years ago that hopefully now, with the evidence that the world hasn't fallen apart, we can continue to open up some of those doors. Some other statistics that might be of interest, and I hope this isn't too rambly, but I was told to give a background and maybe future, so hopefully it's of interest. In the first 3 months of data, October, November, and December of sales, we don't have January quite out yet, which is frustrating, but we've seen gross reported sales in the first month of $2.35 million, the second month, $3.8 million, third month, $5.71 million. So first to second month, that's a 62% increase, and second to third month, it's a 50% increase. But remember, percentages can be deceiving. It's actually a larger dollar growth in that second to third month. So I think it's still showing the sort of upward curve that, like I said, in 3 or 4 years will probably level off. But with respect to projections and also bringing that legacy market above board and knowing strengths of product and people coming out to buy in the legal regulated market, we're seeing real progress. I mentioned the CDC statistics. We are also not seeing yet, for the most part, the big business, it's too easy to say, the Budweiser version of cannabis takeover. And that was with very judicious intent of the legislation, of the licensing scales and sizes, the single license requirement as opposed to being integrated licenses and so forth. And I think that's a real success and something that Vermont hopefully will continue to hang its hat on. We've seen what's happened with the craft beer industry in Vermont. We are a destination. Anecdotally, I could tell you, I saw a random person in the State House, this is probably a month ago, and they came in because it was a Friday morning coffee hour that I hold, not this morning, and they came and sat down. I said, well, what brought you here? They said, well, we're going to Quebec, but we actively landed in Boston to drive through Vermont to go to Hill Farmstead Brewery and The Alchemist for Hetty Topper. And they wanted to tour through Vermont to go to Quebec City because of the beer trail and the craft beers. And Vermont, I think, has a real opportunity to do that with cannabis as well, with incredibly good legacy growers, craft quality cannabis that could also be a big tourism market. And let's see, I think there are also, let's see, I would just say overall, I think we are on the right path. And I hope we do create a more durable and quality market that will grow steadily with cultivation and retail hand in hand. I know there are some areas in the state, particularly the Southwest and a little bit in the Northeast, where there's still a dearth of retail facilities, but there are applications in the pipeline, and that should be hopefully remedied in not too long. And then I'll just wrap with a few comments about the hurdles that I think some of the industry is facing, and one of the biggest ones is staffing. I can tell you on my own business, my farm, right now, we have 4 year-round positions, and they're all vacant. I have seasonal help lined up, but I don't know that we're going to be able to farm this year because I happen to have this other job, and my wife and I are no longer in our 30s and doing 16-hour days. It's just not as feasible as it used to be. And I think both in the cannabis industry and in the regulatory part of the cannabis industry. Finding help and labor is a big issue. And this is where the broader topic of how issues are interrelated, and whether it's the web of life or the web of economics, are interrelated in that we have a housing shortage, we have a child care challenge, you know, one after another. I would argue we have a healthcare crisis, and we have for a long time. We need universal healthcare. You know, a lot of lower wage jobs, and I argue as a small business person, maybe I'm out of line with a lot of my colleagues in the small business world, but if we had universal health care, we wouldn't have as much turnover in our workforce. Because if you have a workforce that's often in their 20s, and as they get into their later 20s or 30s and start thinking about families, or their bodies start having different issues that you think you're invulnerable to when you're younger, you think, I need a job that provides health care. And small businesses don't offer that, usually. And so, or if they do, it's massive catastrophic care. It's not real health care. So these are issues that at the state level we need to address, and they're you know, fallibilities of the capitalist system. You know, we can build 1,000 more houses in Vermont. They're still going to be $500,000 unless we put affordability provisions on them. We are too close to the Boston and New York let's get out of town mentality post-pandemic, and I think probably for many, many years to come with broadband and remote economics, the supply-demand situation is not the only aspect of our housing dilemma. It's real, you know, fine, I'll say it, price controls. You know, if the state's going to put money into housing, or we're going to lessen our regulatory environmental parameters for building more housing, well, part of the price to pay is to make sure it's housing that everybody can afford, and it's housing that folks can get a first home and build their economic wealth, to go back to some of those legacy wealth challenges of our state and country. I want to thank you for inviting me here to speak again. And I want to mention, I forgot to earlier, I'll pass it out a little bit later, but I've got a clipboard with a newsletter sign up if you want a Lieutenant Governor's newsletter. It's electronic, so if there's too many, you delete them. It's not hard. But there are updates from the State House on different policy. And also I've got business cards there that you can take. And for those that are watching online, my Lieutenant Governor email is ltg.info@vermont.gov. And also you can reach out to my office if you ever want to visit the office. Part of what I see as my job as Lieutenant Governor is to be a bit of an ambassador for democracy. Some folks feel intimidated by politics. Some folks feel nervous to go to state capitals and the power that's there. And if I can help reduce those barriers to entry and help you advocate for either yourself or an issue that you care about, or someone else who you also care about that maybe doesn't have the time, money, or agency to advocate, I'd like to help you and help them navigate the system. So thank you for the opportunity. I appreciate being here. I don't recall if there's time or not for questions. If I used it up, I apologize. Is there a question at all or anything you were curious about that I didn't cover? Easy enough. All right. Well, I'll stick around for a few and I'll hand this stuff out. And then unfortunately I have to run because the Senate floor starts at 11:30 and I'm supposed to be the town moderator of that. So I need to get back for that. Thank you. Absolutely.
Okay, guys, we have a brief break. We're going to start our next panel at 9:55. In the meantime, please, please, please feel free to grab breakfast. It is in the hallway outside. And sign up on the sheet for the Lieutenant Governor's thing.
welcome to our panel of amazing people working in the cannabis industry. These are the cultivation insiders. My name is Fran Miller. I work at the Center for Ag and Food Systems here at Vermont Law and Graduate School, and I am excited to introduce you to these folks. Dr. Carly Farmer, way on the left over there, is currently the lab manager for Biodiagnostics Chemistry Lab. She's going to talk to us, provide some insight into cannabis testing. Marlena Tucker-Fishman is co-owner at Zen Barn Farms and the newly appointed Director of Environmental and Social Justice, where she advances the work of the Cannabis Equity Initiative. And Angela Payette, in the middle, is the co-founder and director of compliance at Forbin's Finest. And what I'm going to do is ask each panelist to just introduce themselves kind of briefly, tell us where in Vermont they're located and what their business is, what they do, and then we'll ask some questions. Marlena, do you want to start?
This was a setup. Good morning, everyone. I am Marlena Tucker-Fishman. As Fran said, I am co-owner of Zen Barn Farms, also the co-founder of the Cannabis Generation Equity Fund, and new exciting member of the Vermont Cannabis Retailers Association. Zen Barn Farms is located in Waterbury Center, Vermont. We're right on the Route 100 strip between Ben & Jerry's and the cider mill. So it's like, consider it your cannabis destination. We also have a great cannabis experience in regards to education when you first walk in the door. We're a dispensary, CBD shop, and cannabis education center. And we currently have an amazing cannabis fellow working with us in the marketing aspect of our industry.
Hi, my name is Angela Payette. I am co-owner and founder of Forbin's Finest, which is a Tier 3 cultivation facility, and Forbin's Reserve, which is our retail in Berry City. I've been working in the medical field for the last 20 years and 10 as a medical biller. Being in healthcare during the pandemic was a really challenging time, even in a non-public facing role. With the end of cannabis prohibition and the birth of the adult use rec market, my partner and I decided to change direction and follow our dreams of becoming cannabis cultivators. As the rules were still being written, it was a real challenge to figure out what tier we should apply for, where we should grow, and most importantly, how much it was all going to cost. We signed a 5-year lease on our 13,000 square foot warehouse in August of 2021. It was a bit of a leap of faith in that we had no real way of knowing whether we were going to be approved for cultivation in that space. The facility was previously a hydroponic lettuce growing facility that went out of business largely because of the pandemic, and we were able to take over the lease and the assets of the company. Being new to Berry City, we were received with welcome by the fire and safety folks once they realized that we were not the stereotypical stoners and that this is a highly regulated market. While things like zoning, banking, and insurance still loom before us, it felt like a really good place to start. And with the help of an amazing and trusted group of individuals, we are very close, I hope, to pulling it off. Our cultivation facility has 3 flower rooms with 360 plants in each room. Each room is in a different stage of the plant's life cycle. We harvest about 50 pounds of flower every 3 weeks, or about 75 pounds a month. After the harvest is cured, it is trimmed by hand and packaged in-house. We have purchased equipment to print, cut, and apply our labels. We have relationships with about 20 retailers all over the state, and so far, knock on wood, we haven't had any trouble distributing our products. And while indoor cannabis farming is admittedly not great for the environment, we are doing everything we can to reduce our impact on the environment. We currently have a condensation collection system, which we're able to reuse about 85% of our water. We have a rainwater collection system, which allows us to reduce our reliance on municipal water, and we've also developed a way to reuse all of our growing media. So in the end, I feel like we've really narrowed our footprint. We just signed a contract where we are partnering with a solar company, and while I feel like the law and the language is murky, I think legally we are able to say that our power is derived from sustainable sources. We opened the retail Forbin's Reserve in February after this year. this year, after a lot of market research in other states, we determined that vertical integration proves a wider path to success than the standalone retail or cultivation. We like to think of our retail like a factory outlet, a place for people to come and sample the full line of products, including the small R&D runs.
Right, thank you. Carly?
Hi, I'm Carly Farmer. I'm currently the manager of the chemistry lab at BIA Diagnostics. A little bit about my background. I received my doctorate in sustainable agriculture and food systems from University of Rhode Island, and then I went on for my postdoctorate with the USDA in Beltsville, Maryland. A lot of my research was focused on plant compounds and the use of those against parasitic diseases. Continuing on to BIA, I've been with BIA for almost 5 years now. BIA is a family-owned Vermont business and actually started in 2007 with allergen testing. So things like gluten, peanut, anything that you could possibly be allergic to. And now we are focused on cannabis testing, still allergen testing, GMOs, food authenticity, microbiology, all sorts of stuff. And then expanding further into nutraceuticals in the near future here. BIA is actually the Gaelic or Irish word for food, and happy St. Paddy's Day, by the way. And like I said, that started in 2007, and then we started testing hemp and cannabis products in 2019. We are state certified. We're also ISO 17002 certified and accredited. And so since we started with hemp in 2019, we just rolled right into the cannabis market here as THC exploded this past year. Thanks.
Okay, great, thank you. So why don't we start with you, Dr. Farmer. Tell us a little bit about what Vermont requires in terms of testing for cannabis, and what are the kinds of things that you are finding?
Sure. So right now, just to give you a broad overview of everything we test for that the state is looking for, we're looking at potency, which is your THC, CBD levels, residual solvents, pesticides, mycotoxins, heavy metals. We're also looking at microbials and pathogens. So these are all required at different stages of the process for different types of products or setups for people. Kind of my blanket statement for people that walk in the door and say, what do I need to test for? Is basically all harvest lots need pesticides and pathogens, and all processed lots need potency and moisture content. So there's a lot of ifs, ands, and buts and notes in what the state asks for, and I always encourage people to read through those because I don't know the specifics of whether you're organic or whether you were previously on an apple orchard. There are lots of different regulations that surround different situations for people. So it's kind of an open-ended question. You have to work through, what you need specifically for your operation. But the big ones are, like I said, pesticides, pathogens, potency, and moisture content.
And maybe just to follow up on that question for Marlena and Angela, how does that work from your end? Like how do you interact with BIA?
So BIA does all of our testing. I think it's also important to note that a harvest lot is defined as a group of plants that are grown within 15 days or planted within 15 days of each other and are harvested within 15 days of each other and have the same growing methods. But within each of those harvest lots, you can have as many process lots, right? So like this would be a flower room 1, but we have 6 cultivars coming off of each one. So each one of those now requires its own pathogen test and its own potency test. So there's a lot of testing involved.
Yes.
And from the retailer's perspective, the way that we interact with it is just having to make sure on our end all those batches and harvest lots are matching the flowers that's actually on the shelf. Even as you have new flower coming in, it might be from a different lot, even though it's the same grower, same strain, it could be a different lot. So it's just a matter of keeping track of all those fun lot numbers. But thankfully, too, one thing that I do like Or one thing that's different compared to when we had our CBD shop compared to now, with our CBD shop, most businesses as entrepreneurs, we consider it to be our baby. So anything that we produce, we usually register ourselves and make sure it's good. With the THC side, anything that comes to your shelf, you have to verify that it's registered, and if it's not, it's on the retailer to register it. So that's something different, and that has been a little bit of a challenge.
And just what happens when, first of all, what are the pathogens that are found, the contaminants, and then what happens when that is what's found?
Sure. So there's a lot of different contaminants I could list for days, but pathogens specifically, we're looking for Aspergillus, Salmonella, and Stec. And those are basically need to be not detected. So anything that shows up, it's essentially zero tolerance.
Angela, do you have something to say about that?
Not other than we have all of our products tested for that, for every batch, and for every harvest lot and process lot.
Okay. Okay, so let's move on to a little bit from the retailer, cultivator perspective. Can you explain what the licensing application process has been and what's your experience with it?
For us, so we hold two different licenses. We have the cultivation and we also have the retail. So those are kind of two separate animals. The cultivation came first, and the application process itself through the CCB website was actually fairly intuitive. It wasn't very hard at all, but gathering all of the pieces of information to submit in for the license, that was kind of tricky. And, you know, things like zoning and all the other stuff, the banking and insurance, it's kind of it's not insurmountable, but it's definitely very difficult. We had to have not only the city and the state fire safety, the electrical safety, and I can't even remember who else signed off in order for us to get our certificate of occupancy. And you can't get your license until you have your certificate of occupancy. So even though your building's like 85% there and you're waiting for one electrician to come and fix one thing on a part that doesn't even affect your grow, you still can't do it. So there was a lot of hurdles in that regard to try to overcome, which were timely and costly. But in the end, we got there. We made it.
You got a license.
Yes, we have a license.
Marlena?
Yeah, I would second everything that Angela said. The licensing steps are fairly easy, and in that regard, it makes it misleading because what you have to do to actually be able to operate and open your doors is a whole another board game, if you will. Especially like considering like the regulations for security. Our security alone was like $20,000. So if that application came with some funding attached to it, that would be great, especially, and not just like the funding there, but actually highlighting the businesses or applicants who are equity and economic empowerment, so the people that want to actually support the industry can fund it, because it's a steep pocket. And those that are most affected by the war on drugs that need to be accessed in the industry don't have those pockets. But there's people that want to support it, but need to know that we're out here, and that leads us to a whole nother thing around marketing, too.
Maybe talk a little bit about the equity part of this whole process, the licensing process, funding process. Seems like a good time to do that.
Yeah. I'm going to be vulnerable. The main thing about the equity licensing process, there were great things around it, like waiving certain fees and whatnot, but there also were certain triggering things, like the equity interview that you have to do. I don't even know the other person on the other side of the phone, and they're asking you to share your trauma stories or your experience from the history on the war on drugs. It's like, all right, you're going to attach a therapist with that as you're making me resurface all these things. So that's something, like, all jokes aside, that need to be considered, because our staffing, majority came from the legacy market or were veterans and have PTSD and all these other things. And that mental health needs to be a part of this industry, too. I forgot the second part of your question.
I was just asking how it plays out in the licensing process in Vermont, how taking into account equity considerations plays out.
Yeah. Yeah, I'll add one other thing, because you just reminded me. There was a word in the application that myself and other equity applicants, thanks to etymology and Google and collaborators, we figured out it was a word that we had to pretty much verify or prove that we are African American, Latin American, whatever our ethnic background was to qualify for equity. And that also, like, we had conversations around it for a week, like, why? First you have us share our story, and then we have to prove again that we are who we say we are, not just from a signature on a paper like normally in my social, but another level. So it's like, those are two things that I would definitely change in the process, because I don't see how it made any huge difference besides the impact that it had on the people that were applying from that background.
While we're on this, are there other things that you, in your experience, see ways that it could be improved?
I do.
Take notes.
Yeah, so it's the education, like right when you first walk in our door, the way we operate, we don't ask for people to take out their ID. They're hit with a terpene exhibit, different signs and books and ways to stimulate their senses and knowledge to remove the stigma around the industry. And then two, letting delivery would be a good way. Kudos to all the manufacturers who are running up and down Vermont to deliver, and if they're not able to, unless as a retailer we buy a certain amount, we take on that cost, where there's people who can't afford to open up a storefront, but currently have vehicles that they could fit up to drive and be able to deliver these products and make it easier on the retailers and the manufacturers and the cultivators.
Do you have anything to add, either of you? No? Okay. Thank you. Okay, so let's talk a little bit about banking and insurance and those kinds of things that those industries are like, wait a minute, this is still a federally awful drug. You know, how has that process been, and what are the barriers, and how do you see that could change?
Banking has been a nightmare, an absolute nightmare. And not having access to loans and financing like other businesses have puts you in a really vulnerable position, because then you're relying on private financing, which typically comes with a really high interest rate and equity, which isn't normal in most other industries. So that's definitely frustrating. And just finding a bank that will work with you. There's only a few in the state of Vermont. We started with Vermont State Employee Credit Union when we were just CBD, and we told them that we were going to transition to cannabis. They said, fine, just let us know when you do it. And then part of the licensing, we had to submit a letter from our bank saying it was a cannabis-approved bank. We thought we were all set. So we called our bank, asked for a letter, and they're like, oh, no, sorry, this account can't be used for cannabis. We're like, oh, even though you told us we could, like 6 months ago. So we had to kind of pivot, recreate the wheel, and find alternative banking. The second banking source we tried was Dama. They're from out of state, and they had a cash management plan where they encouraged people to put up to $15,000 in a FedEx envelope and have it sent to them. Right, I can't get FedEx to deliver my Chewy boxes on the regular, so I don't really know if I would trust them with $15,000 of my hard-earned money. So, that being said, we said no to that, and then we ended up with Vermont Federal Credit Union, and I have to say, I have never been happier. They are great to work with. The fee schedules are crazy, but they're not nearly as crazy as some of the others. I know Vermont State Employee Credit Union was charging 1.5% and $1,500 a month for the privilege of owning a bank account for a store. Just for the privilege of opening an account. There is no other industry that gets treated that way. I find it very discriminating and very frustrating and costly.
This is the least favorite part. But thankfully, I have to say, like, Vermont Federal Credit Union is great, and I have a husband that researches and then double researches and then researches one more time. So we honestly haven't had too much issues in that regard I know that some dispensaries were having issues with not being able to take debit and having to switch to cash only, but thankfully, we haven't had that issue. And those of you that need another system, FlowHub has actually kept it up and running. So we're cash and debit.
Our retail store is just cash only. We do have an ATM on site. The merchant fees are over 3.5%, where it's normally like 1 to 1.5%. So for every $10 you take in, not including the tax that you have to pay, you're paying $3.50 of that just to your merchant. So for us, it doesn't make sense to do that, although the argument can be made, excuse me, that your overall tickets are higher when you do have a debit card or credit card system, but for us, I'm not willing to give merchant services 3.5%.
Yeah, there is that, and there is the other option too. My husband also holds names for me, but there's this one setup where you can, it's pretty much acts like a direct debit where it doesn't end up charging a fee. It just, what's the word?
Cashless ATM.
There you go, cashless ATM, where you don't end up having to do the fee. But another way too, like it does act like an ATM and charge that $3.50 fee, but at our register, we have a roll-up for equity. So it rounds up to the nearest 5. So you can either keep that or give it to the equity fund, which funds programs for educating those most affected on the war on drugs from the ancillary side, seed to sale, to help access the industry.
Yeah, so BIA as a lab had been with a major bank for years, long time as an allergen lab. And then when we opened in 2017 with hemp and cannabis testing, they actually dropped us and did not give us an explanation as to why. It didn't come out till like months later that was the reason. That's because we were testing cannabis. So we ended up having to find a local bank that works with us. So.
Yeah, please.
So earlier I had addressed that we have labeling equipment in our facility. So I applied for the equipment because it's technically a lease, it's fairly expensive. Got all through that process and they were totally fine with us taking the equipment. Once they found out we were cannabis, they refused to lease the equipment to us. So then I created a new LLC with a separate tax ID, with the same name, same social security number, same address, and it was approved. So now I own 3 companies, Sugar Leaf Label Company as well.
And these are the things you have to do to get around.
Yeah.
Okay. I'm going to move on to some compliance questions. So let's start with packaging. What are maybe just, if you guys could say briefly, like, what are the regulations and what is easy to comply with, what is difficult to comply with, what could improve?
So first of all, no plastic. So it's good, I get it, it's good for the environment, but it also makes it really difficult to find child-resistant or child-deterrent packaging that is non-plastic. So a lot of people are moving towards these craft bags, which are good, but still, if you want to display your product, I don't know that a craft bag is the most or best way to do that. So that's definitely something we've struggled with. In addition to what has to be listed on the label, the warnings and the warning symbols have to be a really specific size and a specific font. I think it's like 0.10 font, and you're only allowed 3 different font types, and all the colors have to remain the same. So that takes up, like, I would say 75% of your label. So if you want to have product descriptors on your label, you're really limited to space and what you can put on it. And that holds especially true for things like vape cartridges, which are really small, or concentrate packaging, which is even smaller than that. So I haven't actually manufactured any of those products, so I'm not sure how that's actually being done, but I can see that that would present a very big challenge.
I always tend to see the bright side. As a retailer, it's nice to see all the creative packaging on the shelves. I did have, on the flip side though, there was a lot of products that were delayed because they were trying to figure out their right packaging, like especially the beverages. But Yeah, that was really a challenge for people. For us, transitioning from the CBD to the THC, we had packaging that was allowed for our CBD products, but not allowed for the THC. And then you don't want to be ordering different packaging, so then you just start to do both, and it's what to do with the ones that you can't use. One of the things that we decided to do, and what's been helpful to cultivators, is that we do deli style, which is bulk flower. People can just buy by the bud, stimulate their senses, and then we put it in a compostable bag.
And in terms of product safety, is there any issues with packaging that you see?
We're, what is it?
Or deli style.
We don't actually see the packaging side of things. I think the most, connected to packaging I am is when I give a result and that result ends up on a package. There aren't any regulations around packaging. I mean, I'm sure they could, in sense, bring in, some types of contaminants. So I'd be interested in testing packaging, but it's not anything that's regulated or required right now.
One thing I do want to add too in regards to packaging, it's kind of ironic because we have all these sustainable packagings, but then everything has to have all these other labels on it, even the exit label, then of course your warning label that's necessary, and then you have to keep it coming, keep it coming, keep it coming. If there was some way just to have everything just all there on the package, just like when you buy from your grocery store, and then we have all the tracking still on the background and in our files, that would be, I think, more sustainable.
We've fortunately been able to work with a great graphic design guy who was able to fit all of it on our label. So the only thing on our packaging is the label that we apply ourselves, and that's got all of the harvest data, all of the process lots, and all that information. But that is tricky in itself because that means you can't make your labels until after your product is tested, and then there's a window of time where your product is sitting because you're waiting for labels to be made, which is why we decided to do it in-house.
Right, so it ends up being double labeled. Angela's has to go through all that, putting on that labeling on there, and then as a retailer, we have to slap an exit label over that beautiful packaging. Yeah.
What's the exit label?
The exit label says all that stuff, what the percentage is, their lot number, the manufacturer number, all the repeated information is on there. And it goes over such a lovely package.
Talk about waste. Okay, one other question. Are there like best practices that you have implemented in your operations that you could share with the group here?
For us, for the cultivation side, whenever we take in new genetics from other companies or other states, we always have it tested for pesticides. You can end up in a real pickle if you take genetics from another location and don't test them and then put them out into the market and then discover that they're riddled with pesticides. So I think that is one of the things that we do well, best practice in terms of just keeping our products safe and just keeping the fees down for testing. And because the last thing you want to do is have 360 plants of a contaminated product because you didn't have it tested from the onset.
What was the question?
Best practices
as
a retailer?
Yeah. One gray area in regards that I feel that in testing, and then I'll answer that question, is if something goes out from a retailer that's already been tested, signed, sealed, delivered, and approved, and then it goes out to a customer, and then that, whatever the customer has had, then comes back to be tested. Anything could have happened to that product at that time once it goes out. So there needs to be some way to address that. In regards to best operation practices, I feel it's kind of like what I mentioned earlier about when someone first walks into the door to educate them. Also in regards to staffing, having people from the legacy market and those most affected by the war on drugs as a best practice as your cannabis guide. And if there is a challenge to that because there's a steep learning curve in that area. So don't just not hire them, but also create programs that provide that education to those people so that they can access the industry, and that's something that we're doing as a best practice. Yeah, and allowing people to stimulate their senses as they come in and being able to really see the product, learn about the different aspects of it besides the percentage. And the testing is a great way to do that because we get this nice, beautiful display of the terpenes and all the different cannabinoids that are in there, and being talking to people about that.
Time for questions? Questions from y'all? Speak up a lot. Up.
So your comment on vertical integration and zoning, can you stretch that out? And I'm a town planner, zoning administrator. You know, often we have these land use categories, and then you come in and say, in order for me to be a success, I have to have my hand in this cookie jar, this cookie jar, this cookie jar. And as the bureaucrat, I'm trying to put you in these silos, and I'm not able to do that effectively because you're going across, you know, a broad spectrum of economic activity. From your point of view, what could be done on our side to better help you?
That is a tricky question for me to answer because I don't really know the backside of like how your process works. You know, I mean, we submitted our zoning application in Berry City in the very beginning of December of 2021. And it wasn't until February, the end of February of 2022, that we were actually received our zoning letter. And so my understanding is that most zoning and planning approvals happen at that level. Our application was brought to the city mayor, to the city attorney, and to the select board before they would figure out how to classify us. And technically, we're zoned as a greenhouse. And the greenhouse is an establishment where crops are grown or fish are raised entirely inside an enclosed structure. It may have facilities for packaging, processing, and storage of products. It may also include a retail shop as an accessory that primarily sells products produced on the premises. So I thought that was very interesting because A, we're indoors entirely, right? So greenhouse kind of, I feel like, lends itself to the like outdoor market, right? Yeah, it was just kind of funny. But legally, we're not allowed to be considered ag. I don't know the mechanics of that or the laws surrounding that, but I do know that ag comes with a lot of exemptions that they didn't want cannabis to have, essentially. So for example, I know that if you are zoned as ag, you can do your own electrical work without a permit in the city and things of that nature. So I don't know if that goes back to the whole stoner stigma, like extension cords and you know what I mean? But I think that's probably where that came from.
Mm-hmm.
So in terms of how you guys could do it differently on your end or what could be improved, I can't really speak to that because like I only see my side, you know?
Other questions? All right, thank you all so much. Thank you so much, you guys.
We have about like 15 minutes before the next lecture will start. Okay, everybody, we're going to start our next lecture. I would like to introduce Genevieve, and she will be talking about energy regulation and consumption in the cannabis industry.
Hi, thank you, Alyssa, and thank you, Sam, and all the students who have worked so hard to organize this conference. My name is Genevieve Byrne. I'm a professor of law at the Institute for Energy and the Environment here at Vermont Law and Graduate School. And I'm also the staff attorney for our Farm and Energy Initiative, which is a collaboration between the Energy Institute and the Center for Agriculture and Food Systems, also here at Vermont Law and Graduate School. We're funded by the National Agricultural Library, and so we really look at issues sort of at the intersection of energy and agriculture, and cannabis cultivation is one of those issues. What I'm going to talk to you about today is sort of, how we are starting to regulate energy consumption and energy management among particularly indoor cultivators. And I also want to talk about sort of what can we learn from that as we think about decarbonizing the electric grid more broadly and requiring private sector businesses to do things like consume renewable energy. Next slide. So this slide just gives you a little bit of sense of what I'm going to be covering today. I am going to try to pack a lot of information into a relatively short time period. We are about to be publishing a report. You can see the little cover page on our slide, Energy and Equity in Cannabis Cultivation. This will be available on the farmandenergyinitiative.org website. And so I'll be touching on some concepts today that we're going to be exploring in much more detail in that report, and that you can please go download if I pique your interest with what I say today. So I'm going to speak a little bit about how much electricity cultivation is really consuming. We have a bunch of different estimates on that. And think about what regulating energy in cultivation means, both for social equity and for energy equity, which have some similar considerations and some different considerations. I'll talk about the 4 categories of sort of energy regulations that we have found in our research across states that have legalized markets and local governments within those states where the local governments are allowed to sort of separately regulate cultivation facilities. And then we'll sort of return to questions of equity in energy management and sort of what it means to subsidize sustainability in a fair way when we are making requirements about sustainability. Next slide. So to just kick us off, and I'm sorry this screen is a little bit smaller than I thought it might be. These numbers might be a little hard to read. But how much electricity does indoor cultivation really use? There's a market research firm called New Frontier Data that has been trying to answer some of these questions among lots of other questions about the cannabis industry. And their most recent answer is that regulated cultivators used 1.1 million megawatt hours in 2017. I know that's 5 years ago at this point, right? So these numbers have only gone up since then. If we think about what does 1.1 million megawatt hours mean, that represents 0.03% of all United States consumption of electricity. 60% of that was used by indoor cultivators, and perhaps surprisingly, a little over 30% more was used by greenhouse cultivation. Greenhouses are not, do not use zero electricity when it comes to cannabis cultivation. There are fans, there are irrigation systems, there are still lights, there are all kinds of things that still end up using electricity in a greenhouse. We are going to focus in on indoor cultivation, however. That New Frontier data study found that 54% of their respondents cultivated exclusively indoors. That was up 12% from the prior year. And only 11% of their respondents cultivated exclusively outdoors. So indoor, whether we want people to be cultivating indoors or outdoors, we really need to be thinking about indoor cultivation because that is where this is primarily occurring. A separate 2021 study found that 80% of emissions from indoor cultivation are due to sort of specific indoor cultivation practices. So 80% of those emissions would go away if we moved that cultivation outside. And that's because we have high-intensity lights inside, we have HVAC systems inside, we have sort of really significant climate controls that use a lot of electricity. I have a chart on the screen, whether you can read it or not. It's sort of a range of estimates, a range of conclusions about energy usage in the cannabis industry, going all the way back to 2004 and most recently in 2018. The really early studies of how much electricity this industry is using were coming up with numbers like 1% of all US electricity consumption, which is a huge amount of electricity, up to 2%, 3% of US total electricity consumption. As we have gotten better data, and part of that is in fact requiring cultivators to collect that data and to report that data, which is one of the things I'm going to be talking a little bit more about. I think realistically that number is a little bit lower, though we still don't actually know. We still don't have comprehensive comparable data across the entire United States about not only what are regulated cultivators using in terms of electricity, but then, how do we add in or measure unregulated cultivation as well, which is another enormous amount of electricity usage. We made some calculations based on the data collected by New Frontier data, and when we tallied up the math, we found that all indoor cultivation would be about, all regulated cultivation would be 0.03% of US electricity consumption, so that's significantly lower than maybe the 1%. And that if you add in unregulated cultivation, that number would go up to 0.11%. Now, that's only a tenth of the 1% estimate that we were seeing 10 years ago, but it's still an enormous amount of electricity. Let's talk about the amount of electricity that the entire state of Vermont uses is 0.14% of all US consumption. So also a tiny amount, right? You've got to think about Texas and California and New York and Pennsylvania. We have states that use enormous amounts of electricity. But, even at these smaller numbers, we're talking about the electricity consumption of an entire state, even a small and relatively energy efficient state. So, one more fun fact, another study proposed that if Colorado were to convert all of their indoor cultivation to outdoor cultivation, the state's emissions would reduce by 1.3%, which is comparable to eliminating the coal mining industry in Colorado. Again, still a relatively small industry in Colorado, but 1.8% of their emissions. So, you know, the comparisons we can draw here mean that if we don't do something about the electricity consumption of cannabis cultivation, then we are sort of putting more negative externalities of additional electricity consumption out there into the world. Next slide. So unless these facilities are powered entirely by clean energy, they are a new major source of emissions, and that's a problem. They're also a new burden on our already overburdened electric grid. When we talk about grid management, electric grid management, are the utilities that are serving areas with known cultivation facilities have reported higher incidence of blackouts and equipment failures, needing to replace transformers in areas where they have cited a bunch of cultivation facilities. Whether those failures are solely attributable to the cultivation facilities, I think, is a question mark in my mind. But anytime we are adding a new major electric load to the grid, we are certainly putting a burden on that infrastructure. Climate change. Massachusetts did, you know, all of the kind of planning and administrative and subsidizing work to convert 130,000 streetlights from conventional high-intensity lights to LEDs. Massachusetts says that one single huge cultivation facility erases all of those emissions reductions. So all of that time, all of that money put into making the state more efficient, it, you know, disappears a little bit if we're not doing that for new sources of emissions, new sources of electricity consumption. Also, cost of energy. When utilities have to go get extra electricity, go get extra energy that they were not sort of expecting necessarily to need to supply, costs go up. Utilities have to plan for their sort of peak load, the peak electricity demand on the grid, and they have to ensure that they have electric capacity available to meet that peak demand. And a lot of the costs of electricity overall are affected by that peak cost. And so when we're adding new major sources of electricity consumption, we run the risk of sort of increasing the peak load on the grid, increasing those peak costs, potentially needing new capacity, potentially needing to make new infrastructure investments by the utility, which doesn't just increase costs for the utility, it actually increases costs for all ratepayers in that service territory. And to cultivators as well, because the more electricity you're buying, the more electricity you are paying for, right? So it's also a business line item for the cultivator. Next slide. So I want to pause here to talk about equity in the cannabis industry more generally. And I think that's something that you're going to hear more about over the course of this conference. But as many of us know, Black, Indigenous, and people of color have been the most harmed historically by the criminalization of cannabis. And the state licensing programs that are allowing legal cannabis cultivation really are gatekeepers for who gets to participate in the industry. So the rules that are made by the cannabis control boards, the cannabis licensing boards, really determine who gets to participate and in what ways and what rules they must follow if they participate. And those rules are going to have compliance costs associated with them. The more compliance costs we have, sort of the more barriers to entry into the market we have as it gets more expensive to get that license. Many state licensing programs have actually created additional opportunities for what is generally termed social equity applicants. I have one just definition of social equity applicant from Illinois up on the slide. I don't need to read the entire definition, but these state definitions often reference people that have been arrested or convicted of a cannabis offense during a time of criminalization, a person that has lived in a geographic area that was disproportionately affected by the criminalization of cannabis, or someone in their family, their other community. And so what we're doing, or what states are doing, are things like fee waivers or expedited applications, reserving a percentage of applications for social equity applicants, creating funds, which is incredibly important, social equity funds to help provide financing and low interest loans to these applicants, to help with business costs, startup costs, compliance costs. So that's all good, but when we then switch back to talking about energy and energy regulation, the social equity programs are not always sort of aligned with or thinking about compliance with energy regulations versus just getting the license in the first place. And so we've sort of seen some holes in the disproportionate impact of energy regulations sort of becoming another barrier to entry into the cannabis market. Next slide. So as I said, energy regulations designed to mitigate the environmental impact of commercial cannabis can actually create additional barriers to market entry by imposing increased costs on license applicants. Many of the same people who are and have been historically harmed by the criminalization of cannabis are also underserved by clean energy and energy efficiency programs. If you can see the little orange banner about energy burden, is something we talk about in energy equity. This is the percentage of household income that goes towards energy costs. If you earn less money or if you pay higher electric bills, that's going to increase a household's energy burden. Black, Hispanic, and Native American households all face a higher than average energy burden. We're not talking about residential consumption here, but the same ideas apply, right? We don't want to overly burden or place additional burdens on people who have already sort of been failed by our clean energy incentives, by our clean energy programs, our energy efficiency programs. That's social equity. We also have energy equity when we talk about the relationship between the cultivation facility and other ratepayers in the service territory. So let's consider grid upgrade costs. So when we interconnect to the grid a new major facility, the poles and wires, the transformers, may not be sufficient to serve that customer. That means that we might need upgrades to the grid to serve that customer. We have seen some states or localities sort of make rules that the cultivation facility is responsible for paying all of those costs and paying all of those costs upfront. That's fine if all of those upgrades are in fact only and solely benefiting the cultivation facility. Some grid upgrades only benefit one customer, others are really gonna benefit a much larger range of customers that are sort of all on that line that kind of needed an upgrade anyway. And so we want to be careful about what we call cross-subsidization, about making the cultivation facility pay for upgrades that are actually benefiting a wide range of ratepayers, or alternatively, making ratepayers pay for upgrades that are really only benefiting that cultivation facility. Two, it says regulated electric utility rate guideposts. So these don't apply here really. We're not talking about regulated electric rates when we're talking about what energy management obligations are we placing on cultivators. But if we were talking about regulated electric rates, we use the words just and reasonable, which means that the rate must be fair both to the utility and to the ratepayer, and not unduly discriminatory. And that means that we want to treat similarly situated customers similarly in terms of the rate that we are charging them for electricity. So this sort of leads to the question for me, are cultivation facilities being treated the same or similarly to other interconnecting electric customers of their type or in their class? And next slide. This is mostly food for thought. If the answer is no, we're not treating them similarly or fairly, then we might actually rise to the level of having constitutional concerns about what we're doing. States have a legitimate interest in reducing greenhouse gas emissions from the electric sector, but singling out cannabis cultivation for improvements that we don't require of other cultivators or other high-demand electric consumers could invite constitutional challenges. The 14th Amendment of the Constitution prohibits states from creating legal distinctions between persons based solely on differences that are not related to a legitimate government objective. So if some cannabis licensing regulations are singling out cultivators for electricity management obligations that we're not requiring of other similar cultivators or other similar high-demand electric users, then, and other customers actually in their customer class with the utility, then that might be an equal protection issue. I'm not saying it is an equal protection issue, I'm saying it might be an equal protection issue. Let's also talk about regulatory takings. When we do things like, say, cultivation facility, you have to go buy renewable energy. We're not saying everybody has to go buy it or every individual electric customer has to go buy it, but because you are a cultivation facility, you have to go buy renewable energy. And it is a condition of your permit. Is it a condition of licensing that you do so? Then we're getting into the area of what we call a monetary exaction in permitting, in licensing. Another example of that would be, hey, residential developer, yes, we will give you a permit to build those houses, but you need to go pay money into this wetlands mitigation fund in order for us to approve your permit. That's another kind of monetary exaction in a permit licensing process. So when we have those, the Supreme Court has found that the government has to demonstrate an essential nexus with a legitimate state interest, and the permit condition has to be roughly proportional to the impact of the proposed development. So it might constitute a regulatory taking if cannabis licensing regulations do not fairly or proportionally allocate the burden of emissions reductions amongst contributing electric customers. We'll sort of return to these later, a little bit later when we dig a little bit more into the specific regulations that we're talking about. Next slide. So, what is it that we are requiring of cannabis cultivators? We found 4 categories, essentially, of energy management obligations. And right now they are green, yellow, and red across the top because I think that the yellow ones bring up some fairness issues, and the red one brings up a lot more fairness issues. Indoor, outdoor, and greenhouse production rules are green because while we want to certainly promote outdoor cultivation, I don't think that the same equity issues are arising in these rules as in the energy management rules. So below each box, I just am giving you a range of the different requirements that states and localities are placing on cultivation facilities. We have a lot more detail about all of these in our report with examples that you could go look at. Starting with how we produce cannabis. Some states ban outdoor cultivation entirely. Some leave it up to local governments to make that decision about whether or not you can grow indoors, outdoors, or in a greenhouse. Some states, like Vermont, are expediting or promoting outdoor cultivation, and many, many states are putting additional security requirements on outdoor cultivators. Planning, reporting, and benchmarking, this means we're talking about energy planning. So as part of the licensing process saying, how much electricity are you going to need and for what, and where is it going to come from? Do you need upgrades to the grid in the location where you're planning to put your facility? What utility is in that service territory? What capacity do they have to add you in a low-cost way? So the range of requirements, energy planning might be a part of licensing, reporting might be a part of licensing, reporting might be a part of their annual renewal or relicensing, so looking at the electricity use you sort of planned to have and then what did you actually use. They might require reporting and tracking of greenhouse gas emissions, and in some places we're starting to have online platforms available to help with this, which is good and makes everything easier. Moving over to energy efficiency, HVAC and lighting are really where we're seeing these efficiency requirements be targeted toward lighting and HVAC systems. Some states are compelling consultation with local or state energy efficiency programs. So, in order to get your license, you actually have to go talk to Efficiency Vermont and have to meet with them and figure out what you could do for your facility, and maybe even tell us why you're not going to do those things if they were suggested to you. We're also starting to see standardized and approved equipment lists, particularly for lights. We have the Design Lights Consortium, which maintains a kind of list of efficient lighting that is used in indoor horticulture. Some states are just starting to reference that list as you can use anything on the Design Lights Consortium list, and then we'll call you in compliance with our lighting regulation. And some states are involving energy efficiency utilities, which are slightly different, or actually significantly different than energy efficiency programs, but in ways that we probably don't have time to get into right now. Moving over to renewable energy consumption, some states and localities are requiring cultivators to procure or buy some portion of renewable energy. Others are in fact requiring that that renewable energy be generated on site, on the same site as the cultivation facility. Others are requiring the purchase of carbon offsets or other offsets for some portion of the electricity consumption of the facility. And some are requiring the use of 100% renewable energy for cultivation facilities. So, what does this mean for equity, and how worried are we about fairness in these categories? Next slide. I've grouped together, I skipped over outdoor growth. We want to promote outdoor growth. Every ounce of cannabis we grow outside is much more energy efficient than the cannabis that we are growing inside. But as I said before, a lot of it is being grown inside, right? So it's worth trying to fix this problem as well. Are energy planning and energy efficiency requirements effective? That's probably a good question, right? If we're going to require them of people. Yes, I think they are. Cultivators, utilities, and regulators all can better understand where their electric demand is coming from and how it can best be met with either, reduced energy. Efficiency, as we say, is our first fuel. If we can not use any energy at all, that's better than using any. Or if we're still using energy, how it can best be met with low cost and low carbon resources. This also allows cultivators to measure improvements. How did this energy efficiency upgrade actually affect us? It's nice to see that from year to year if you're making those investments. And it's good for utilities as well, because if we're doing things like requiring on-site renewable energy, when the utility can integrate that into their planning, it can actually help the utility save money as well, because they may be able to avoid expensive investments in new capital infrastructure. Are they equitable? Is it equitable to ask cultivation facilities to do this whether or not we are asking other industries or other private sector businesses to do this? I think the answer is mostly yes, particularly as long as sufficient compliance support is available, and I think that's really the key to this category. Compliance with any kind of regulation really takes time, labor, and expertise. For major energy efficiency upgrades, that's also going to require significant upfront capital investments. They often offer long-term savings as you use less energy, but they're expensive right off the bat. So we need to make sure that legal, financial, consulting, and technical support is available, and no interest, low interest loans are really crucial here. A lot of efficiency incentives come in the form of rebates. You can't take advantage of a rebate if you can't pay the cost first, right? So we have to have financing available if we're going to have this kind of obligation, and we don't want to be negatively affecting people that are already facing barriers to entry into the industry. When we think about, do we make other people do this? Well, kind of, yeah, we do, right? We have building efficiency standards for when we go build a new residential building. We have appliance efficiency standards. We are more and more integrating requirements for energy efficiency into the private sector. If I still have a sort of equity question about this, it's that the benefits of these regulations from an environmental perspective are not limited to the cannabis industry, right? And so if we are sharing the burden of climate change, if we are sharing the burden of mitigating climate change and decarbonizing the grid, what's good for the cannabis industry may in fact be good for all kinds of industries that are using way too much electricity in inefficient ways. Next slide. Moving over to renewable energy consumption. When we require cultivation facilities to use renewable energy, is that effective in reducing emissions and mitigating their environmental impact? Yes, it is. Making people buy renewable energy is certainly a way to clean up their energy profile. It reduces fossil fuel consumption, it reduces greenhouse gas emissions, and in fact, over time, it might make it cheaper to run your cultivation facility. If you have on-site solar, you can often sell, electricity back to the grid and offset your own electricity consumption if you have excess generation. And requiring renewable energy consumption, or particularly on-site renewable energy generation, can lower sort of the overall burden to the electric grid. When we have generation really close to load and they're sort of well matched, that's good for grid management. Okay, is it equitable to ask this of cultivation facilities? My answer is probably not, and maybe it should have like a ... question mark after that versus a period. But when we think about clean energy mandates, you've probably heard things like, Hawaii commits to 100% renewable energy. Vermont, who knows raise your hand if you know what a renewable portfolio standard is. Okay, a couple. So that's what that is. Hawaii commits to 100% renewable energy. Who has to comply with that? Your electric utility. Load serving entities are the ones that we put this compliance obligation on. And why is that? It's because they are best positioned to clean up the supply of electricity across their entire service territory. And in fact, generally, these obligations are met through trading, buying and selling improvements out across a whole regional grid area. So when a Vermont utility wants to comply with Vermont's clean energy standard, it can actually buy renewable energy certificates from out of state. It can trade with other utilities. So it's a much more flexible way to get to clean energy. Utilities, who are generally the ones who have to comply with these obligations, might target specific customer classes that are particularly inefficient or particularly high demand users. They might provide an industrial incentive. They might provide a time of use rate to certain customers. They might provide subsidies for battery storage for certain customers. But we very rarely regulate the electric consumption of individual businesses. If electricity is available for purchase from the utility and can be delivered on the grid, businesses are not generally told that they might be fined for using that local grid mix instead of using renewable energy. I kind of think of it like as if you're driving a car, right, and you might have the most efficient car you can have, and then you get up to the gas pump and we've got 3 different qualities of fuel, and you're sort of told, well, even though, that lower grade fuel, the 87 is available, you're not allowed to buy that. You have to buy that first level, tier 1 fuel instead, or you are going to face a penalty. But only a very small subset of electrical customers is going to face that. be cannabis cultivators. Not equitable does not mean unconstitutional, but it could mean unconstitutional, as we've looked at before. Here, we're sort of talking about equities between cultivators that we're placing a very heavy burden on in terms of clean energy development and consumption, and other ratepayers or similar electric customers who are not asked to purchase clean energy and for whom doing so is voluntary. Next slide. So let's go back to social equity for a minute. Strict energy regulations are inequitable when only those with existing resources can afford to comply with them. Michigan is one of the states that allows local governments to set strict energy standards that can be different from those set at the state level. Ann Arbor requires 10% of a cultivation facility's energy consumption must come from on-site solar. Bay City, applicants might be required to prepay all costs associated with energy infrastructure needed to meet their anticipated load. Grand Rapids, cultivators must complete a whole building energy audit and meet specific lighting efficiency standards with proof of compliance due at the time of municipal licensing. So you actually have to do all of that before you even get your license. While Michigan offers fee reductions to qualifying social equity applicants, it does not have a fund. It does not have a fund available for financing to help cultivators comply with these local energy standards, or it also does not have a dedicated energy efficiency utility or other program offering significant incentives to cultivators across the state. So this is a serious barrier to entry, right? If there is not enough compliance support available, it's incredibly expensive to put in an on-site solar array, especially when cultivators in the next town over do not need to do so. Not only that, next slide. Why are we only talking about the cannabis industry? Just kidding, we all know why. The licensing process provides a regulatory hook for adding these obligations onto cannabis cultivators in a way that we don't have the same regulatory hook for other businesses. You know, if I'm growing lettuce inside in indoor horticulture, even in a huge facility, you know, state business licensing is going to apply, local planning and zoning is still going to apply, environmental permitting is still going to apply, but, well, depending on whether you're agriculture or not and what state you're in and all kinds of other things, but at least you do not have to go get a very special, specific, and expensive lettuce cultivation permit that comes with its whole own host of requirements attached to it. All indoor horticulture, according to the USDA, consumed almost 6 million megawatt hours of electricity in 2017. We already said that regulated cannabis cultivators consumed 1.1 million megawatt hours approximately. So that's about 18% of all indoor horticulture. If we are so worried about energy consumption in indoor horticulture, why are we leaving out 80% of it? Is that equitable? Is that reasonable? Is that rationally related to the state or local interest in reducing greenhouse gas emissions? These are question marks in my mind. Let's look outside of indoor horticulture. Data centers potentially account for about 1.8% of electricity in the United States. Some data centers, some states are targeting data centers for energy efficiency improvements, but again, there's not that special license required that kind of provides that regulatory hook for placing obligations on them. They are not subject to state and local regulation of electricity consumption, right? It's really, I don't have a problem with putting energy efficiency standards on businesses. I think we should do much more of it. In fact, I think we should do it in the cannabis industry as well. I just think we shouldn't just do it in the cannabis industry. When it comes to requiring people to consume renewable energy, again, if we're talking about huge consumers of electricity, yes, cannabis cultivation, and also not only cannabis cultivation. So if we thought about applying these kinds of regulations much more widely, we have more people thinking about how to solve these problems. We have more research and development occurring. We have more economies of scale. We have costs coming down faster. We have emissions going down faster. We have climate change mitigation happening faster. More people involved, more solutions, more environmental improvement. Where would we do that? We have the cannabis license. We have business licensing at the state and local level. It would be a fight, but perhaps the time has come to not say these regulations are unfair, we shouldn't require them of the cannabis industry, but to say these regulations are probably needed. Let's not just apply them to the cannabis industry, but apply them much more widely to all kinds of businesses that are using way too much electricity way too inefficiently. Next slide. And I think we have some time for questions. Again, we talk about all of this much more in our report, Energy and Equity in Cannabis Cultivation. You can download that from the farmandenergyinitiative.org website off our cannabis page. And I think we have a few minutes for questions. Yes.
This is kind of an observation. I thought it was very fascinating, your discussion of 14th Amendment rights of the cannabis industry. And I think, here in Vermont, here in Vermont, we have a bit of a field day for the regulators because our industry is very fractured. Mm-hmm. We have built into the system a one license rule that keeps businesses very small. It was intentionally written in part to avoid regulatory capture. I speak as the person who helped write it. So I think there's going to be more overreach from that perspective, here than perhaps might be possible elsewhere, because there's not really anyone well-funded enough to push back in courts the way that you would have to. Just an observation.
Mm-hmm. It is an interesting observation, right? I have not seen this case arise, right? I don't have this case to point to. But there are cases where ratepayers have brought equal protection claims about their treatment as a category of electric customer that wasn't all that different from another kind of electric customer, and yet they felt was being treated differently. And so, I feel like the next part of research, right, is potentially walking through some of those analyses and seeing, how aptly they apply here. Other questions? All right, well, thank you so much.
Okay, everybody, we have another break until 12:20, so enjoy lunch. It's going to be right over there.
Good to see you. My name's Rod Smola. I am the president of the Vermont Law and Graduate School. I was not originally slated to be part of this event, but I have been recruited as a stand-in. But in the words of the great Smokey Robinson from his classic song, Tracks of My Tears,
I'm waiting with bated breath for this.
he may be cute, but he's just a substitute. But my fellow panelists are not substitutes. They are the real experts. And so it's my pleasure to introduce all three of them, and then I'll invite them to share some opening thoughts with you, and then we can have, to the extent that time permits, some questions and critique. So I first want to introduce Timothy Bryan Fair, who is a graduate of the law school here and who is currently a partner at attorney at Vermont Cannabis Solutions. Next to him is Will Reed, the founder and CEO of Canna Planners. And next to him is my colleague, Professor Jared Carter, also a graduate of our school, formerly the leader of the First Amendment Clinic at Cornell Law School, and now among the faculty members who teaches First Amendment law and related issues here at the Vermont Law and Graduate School. So welcome all of you. Thanks for having you. And Tim, I think we've decided we'll let you lead us off.
I get to start. Well, hello everybody. Thank you, President Paul. Appreciate that. My name is Tim Fair. I'm the founder and managing partner of Vermont Cannabis Solutions. I'm also the owner of Rojo Wholesale Distribution. We're a wholesale cannabis company. So it's kind of interesting to be on a panel about packaging and labeling, seeing it from kind of with both hats. One side, we're looking at the regulations, trying to counsel our clients what is acceptable, what is not acceptable in our nascent market here. On the other side, it's practical. We're trying to figure out what to do for our packaging. And I think one of the challenges here, first of all, the state-to-state patchwork of regulations in cannabis. Well, let's look at Massachusetts and see what they do. Well, how they've interpreted certain rules and certain regulations, very different than how New York is interpreting them, or Maine, or Nevada, or Colorado, or Vermont. Packaging cannot appeal to children. Well, what does that mean? And these are a lot of the challenges that we see within this. There is some black and white rules. Packaging must include certain warnings. Most states have adopted a state-specific cannabis adult use symbol, which needs to be included. And those are the easy ones. But when we get into areas such as logos cannot be cartoonish, they cannot appeal to children. When we start to get into advertising bans and restrictions, I think this really implicates a lot of areas of law, specifically the First Amendment, and I think Professor Carter is going to be speaking on that in a little bit here, which really creates a lot of open questions. And the last thing we want to do as attorneys is counsel our clients in a way that gets them a nasty letter from the CCB. The last thing we want to be doing as a packaging company and a wholesale distribution company is packaging and distributing products that are out of regulation, especially since we're also the attorneys, so really bad sign. So, I think this is an area in which, there's a lot of fear at the beginning of any adult use market. It's brand new. This is a substance that's been demonized for almost 70 years. There's a lot of stigma attached to it. And the initial impulse, I think, especially on the part of those who may not be as educated on cannabis, is we need to protect people. Well, if it's going to be legal, how do we protect people? Well, the first way we protect people is we cover it with warnings. It works with cigarettes, which actually are pretty dangerous. So let's do that with cannabis as well. Let's make sure it clearly said this is dangerous to children, and this is dangerous to pregnant women, and this is dangerous if you drive. And so then we get to a point where our entire packaging is nothing but warnings. And that's not really conducive to a market. So when it comes to labeling and packaging regulations, yes, there are some common sense regulations that do need to be in place. But I think as a whole, we need to take a look at what has been put out there, particularly here in Vermont, and decide if it's really necessary. Do we need as much regulation as there is? Is it necessary to take a look at every single logo out there and spend days or weeks sometimes trying to decide if it is appealing to children when it's being sold in a store that you can't walk into unless you're 21. My kind of putting it back out to the audience is, understand these regulations. If you're interested in cannabis law, it's a heavy regulatory area. Know the regulations, look at the regulations, and question the regulations. Start to look and see what makes sense, what is reasonable, and where is that line, and what might cross that line into a little bit of absurdity.
Thanks.
Will.
Cool. My name is Will Reed. I am the founder and CEO of Cannaplanners. Thanks to President Smalo for being such a cute substitute. Always happy to sit on a panel with Tim, and good to meet you, Professor Carter. So I founded Cannaplanners back in 2015. If you live in this state, you are aware of a company called Dealer.com. Yes? Yes, okay. Cannaplanners is Dealer.com for the cannabis industry. So we ostensibly just create tons of websites for specifically cannabis companies. We then market them through digital marketing services, namely search engine optimization, which, if you don't know, just means we write content all day long, every single day, until we die. And then we optimize that content so people like you, when they're searching for where to find weed near me, or whatever product it is you want to find, that our clients show up before people who aren't our clients. Also included in that is email marketing. So we are in charge of communication on behalf of our clients very frequently, sometimes up to 10 times a week, for one client. And we will craft those messages, talk about whatever deals that that dispensary is having, that sort of thing, market products through email. Another part of what we do, it's a smaller part of our business, but it is substantial, is creative. So we create brands, we create packaging, and then we apply those brands to things. So packaging, signage, store uniforms, you name it, cars. We've put a brand on everything. So when it comes to having these types of discussions, I'm all for it. I think it's healthy to, as Tim alluded, it is not uncommon for regulation in an industry, specifically this industry, to be very overbearing at first because of the 80-plus year war on drugs that we are still in the middle of, but are coming out of in terms of cannabis regulation and legalization. So we work in every legal state in this country, which is something an employee of mine just alluded to me like a couple weeks ago. So we work in every single legal state, which for us, because we're not attorneys, can become a little confusing because, as you all know, the regulations are different in every single state. While the the themes of regulation are fairly consistent, marketing to kids, warnings, whatever, the details are where it gets complicated, and in terms of running my company, can sometimes become just complex in making sure that we're advising our clients creatively and strategically on the right moves. So I'm not an attorney. I do rely on lots of attorneys to make sure that we're not putting our clients in positions of liability. So I'm very anxious and happy to be here to talk about my experience nationally, outside of Vermont, and how that's impacted kind of the moves we're making in Vermont. Just for context, I think last year we launched, and last year obviously was busy for us because legalization, because the marketplace was just about to open. And this is just off the top of my head. So last year I think we launched in this state alone 25, maybe less than 30, more than 20 cannabis brands. I think we designed probably 300 or 400 Vermont cannabis products. And I think we launched maybe 40 websites in the state alone out of 85 nationally. So it was a busy year for us in Vermont. And it's still picking up. So I'm thankful to all of you for having me here, and I'm eager for this discussion. Yeah.
Great, thank you. Before I begin, I just want to, by a show of hands, is everybody in here 21 or older? Can you raise your hand if you're 21 or older? Okay. I'm actually going to need you to all show me your IDs, so please hold up your ID showing that you're 21 or over, because what I'm about to do is show you this. Does anybody know what that's a picture of?
No.
I haven't drawn one since high school study hall inside my calculus book.
As the resident creative here, that is an amoeba.
Okay, so this is an amoeba, and what does it say?
It says, buy marijuana here.
Buy MJ here, and then at the bottom, just for President Smallow's sake, so he doesn't get heartburn over what I'm advertising here, it says, just kidding, I'm not really selling marijuana. Here's the point I want to make with that, and it's pretty simple. Under the current regulations in Vermont, in order to advertise, and I'm oversimplifying a little bit, but in order to advertise, media outlets and advertisers have to prove that no more than 15% of their audience is under 21. So you all can decide whether I approve that or not. I didn't actually make you show me your IDs, but that's, in a nutshell, part of the regulatory framework for advertising the sale of marijuana in Vermont. Now, you might say, what the hell does that have to do with the First Amendment and the Constitution? And you wouldn't be wrong for asking that question, because typically we think about the First Amendment protecting, right, political speech, free exercise of religion, the Establishment Clause, right? Petition the government for redress. That's sort of the core of the First Amendment that we think about and learn about in law school. But in fact, the U.S. Supreme Court has said that the First Amendment applies to certain types of commercial speech. So I don't know whether this was commercial speech or not. The Supreme Court has given us a definition of it, but there's serious questions, I think. And if I was advising the state of Vermont on this issue, I would raise these questions about the constitutional implications of regulating marijuana cannabis industry advertisements. So what has the Supreme Court said about this? There's a famous test, maybe you all have heard about it in con law or First Amendment law if you've taken it, called the Central Hudson Test. Anybody ever heard of that? Show of hands. You don't have to show me your ID this time. You can just raise your hands. So under that test, the court looks at commercial speech to determine whether or not it is protected by the First Amendment. Because, of course, if it isn't protected by the First Amendment, then states are pretty free to regulate advertising and labeling as they wish. So what the court said is that to determine whether or not the First Amendment protection for commercial speech, right, the freedom of speech applies, we first need to determine whether or not the speech, in other words, the advertisement. Am I yelling into this? Because I'm not used to microphones. Okay.
You're passionate.
I'm passionate. We first need to determine, I'm not cute though. I think we're stunningly handsome, not cute up here. But you first have to figure out whether or not the First Amendment applies, and you look at whether or not the speech is either misleading or unlawful, right? Whether it's promoting an unlawful exchange in commerce, or if it's misleading, right? And the idea behind at least the misleading piece is we have a wonderful history in this country, right, of snake oil salesmen, selling some elixir to cure every ailment that there is. And the court says, well, that's not protected speech, right? You can't mislead consumers. But it's also said that speech proposing an illegal transaction or unlawful transaction can also be prohibited. And so the reason that's a really important issue here is because what do we know about cannabis in the United States? It's, okay, all right, rock on. That could be true. Not only that, but legally speaking, what do we know? It's prohibited where?
Federally.
Federally, right? It's a controlled substance. So does that sound unlawful? Right? I don't know. On the other hand, what do we know about it in Vermont and how many other states?
2 adult use at this point, I believe.
20 some odd states. It's lawful, right? In fact, I have a property in Burlington, and I went in to check on the smoke detectors for my tenants. and she was growing plants under a light in the house, which was a little bit surprising, but it's lawful. So I don't pay the electric bill. They pay the electric bill, so I'm okay. But the point is, there's this real question, I think, at that first step of the First Amendment constitutional protection for commercial speech is whether or not these advertisements are advertising something lawful or unlawful. And there isn't, because this is a pretty emerging issue, there isn't a lot of case law that's on point. There's been 2 cases that I could find that deal with this specific issue regarding marijuana advertising, labeling and advertising. And they both reach different conclusions on whether or not, of course, right, it's the common law, that's what's fun about it. They both reach different conclusions on whether or not marijuana advertising is in fact protected by the First Amendment. Montana Supreme Court, which is near and dear to my heart, and I clerked out there for a little over a year, and I love them, but I think they got it all wrong. They found, and I'm a First Amendment guy, so I'm all about broad First Amendment protections, if you can't tell. But the Montana Supreme Court, in a case, I forget the exact name, but so-and-so versus the Montana Control Board. The Montana Supreme Court found that because cannabis is unlawful at the federal level, we apply that principle, and under the First Amendment, at that first step in the Central Hudson analysis, we find that it's an unlawful act, right? So the advertisement proposing an unlawful commercial transaction. And so the First Amendment doesn't apply. And Montana had a blanket ban on marijuana advertising. Out in Washington state, they had a much more nuanced regulatory regime, and that went all the way up to the Washington State Supreme Court. And they found, in a First Amendment and Washington State Constitution challenge, they found that, in fact, the First Amendment does apply. And they pointed to some important dicta from the First Circuit and the Ninth Circuit that said as much. And I won't get into the details now because I'm mindful of the time. But essentially, the Washington State Court reached the complete opposite conclusion. It said, First Amendment does apply. This is commercial speech. It's protected. It ultimately upheld the regulations under the other parts of the Central Hudson test, which are, does the state have a substantial interest? This might sound familiar to you all. And does it directly advance that substantial interest? Does the regulation directly advance it? So the regulation was upheld, but it said the First Amendment applies. So I think there's some really interesting legal questions under the First Amendment here that we just don't have the answer to. And certainly if I was a lawyer representing the state, I would want to walk through and explain what the possible downstream risks are of any regulatory regime. The Vermont Constitution also includes, under Article 13, free speech protections as well, which the Vermont Supreme Court has said are coextensive with the First Amendment, so provide at least the same amount of protection. So lots of fascinating issues. I'm not really selling amoebas, but I appreciate y'all hearing me out, and I look forward to the conversation.
I want to throw one more thing out there, too. When we talk about advertising, what is advertising? Some is pretty clear. You put a commercial on television. You put a commercial on the radio. Here's my store. Come here, buy this. Okay, that's pretty cut and dry. But what about walking by a window display of a store? The Vermont Cannabis Control Board has determined that is, in fact, advertising. If anybody on a street can see through a window and see a cannabis product, that's advertising. Yep. All right, well, maybe. We recently had a client who was told that an Adirondack chair in the shape of a marijuana leaf in front of their store was advertising. Wait a minute, hold on here. Something, a concept like that is packaging, advertising. Are you advertising a product for sale, or are you identifying a good and distinguishing it from the goods of others, as Vermont trademark law states? So I think that, in this conversation, not only are we looking at what can the state legally do and what is taking it a step too far in terms of regulation, but also the very definitions of what we're regulating. What is advertising? Is an Instagram post advertising? Is an Instagram post of a growing plant with no more information advertising? How broad a net can be, thrown out there? And I know the Cannabis Control Board would like the broadest net possible. I think it's, on us, both as consumers, as attorneys, and as citizens of Vermont, to question that and to say maybe that net's being thrown a little bit too far. Just an idea.
I had a thought, but Tim just said exactly what I was thinking, so I almost don't need to re-articulate that. But I think it's okay. That's why I have you here. The ambiguity, I'm looking at this, obviously I'm concerned with the legal ramifications of everything that we as Cannaplanners, a creative and digital agency, do for our clients. But really, because we're not attorneys, the real world result of what I see, just anecdotally, is confusion, because a client will come to me and say, you know, we want to advertise in 7 days. You know, why are the bars able to and we can't? Why can we be advertising? You know, why are we held to a different standard? And this boils down to lots of other things. You know, actual manufacturing compliance. You know, the actual physical packaging that a company uses. Why are we holding small Vermont businesses to a way higher standard than, you know, a national CPG company that also lives, you know, here in Vermont, creating actual plastic waste. So I think that the ambiguities surrounding a lot of these regulations, they for sure need to be cleaned up, but I think they're right now at the risk of, you know, mom and pop shops. There's one MSO now, there's two. There's three in the state now that I can think of off the top of my head. Right, another vague definition. So my point is there are way more small businesses in Vermont than there are large corporations in this industry right now, and perhaps that'll change. I have no idea, but the fact that we're relying on mom and pop to figure this all out is slightly ludicrous, and I think that it's not at all helping further the industry, because it's continuing to kind of perpetuate stigma. And what I mean, so my company has a mission statement, if you'll allow me. The mission statement of Cannaplanners is, we are here to normalize the emerging cannabis industry through creative design and strategic digital marketing solutions. It's literally written on our website, verbatim that. And what does that mean? So because of the war on drugs, because of war on drugs, really, just everything being underground black market, there's a perception that has been contrived over the better part of 100 years about who uses marijuana, how it's used, why it's used, all of those things. And part of the responsibility, I feel, as a company who is at the forefront of this industry, and as a Vermont company at the forefront of the Vermont industry, is to do what's best for the state of Vermont. And that is to create brands that are responsible, to help grow brands that are looking to grow responsibly, and facilitate that as best we can. So the ambiguity does not make that easier, right? So especially when it comes to subjective things. So Tim touched on, you know, marketing towards children. Now, I, as you know, the founder of a creative agency, have a pretty good understanding of what that means, but it's entirely subjective to me, right? I'm not using cartoons. We're not using, I mean, really, it's cartoons. Like, it boils down to that. If you're not using cartoonish design, you're pretty much in the clear. However, and we were talking about this just briefly a moment ago, but in Maine, there was a case, there's a company called Seaweed & Co., and their logo is a line drawing, which just means it's a line, right? It's not cartoonish, but it is a line drawing of a mermaid. It's not The Little Mermaid. It is not a Pixar with huge eyes and, you know, bright colors. It is just an icon of a mermaid to represent this company. Is that marketing to children? In my subjective opinion, absolutely not. And furthermore, when it was brought to the CCB, the company won. You know, it wasn't being marketed to children. They decided, but it was a costly. It was a costly venture for them to figure this out. They almost had to pull all their product. They almost had to pull all their packaging. They almost had to rebrand their entire company, which I can tell you would cost them tens of thousands of dollars, probably more. So it's all to say that the over-ambiguous regulation of an emerging market is not furthering the market. It is going to keep it down. It is going to keep it looking amateurish, and it is going to keep it looking unprofessional. So I just thought
Especially if it's ultimately unnecessary.
And one thing I would just, it's great hearing you two as sort of industry insiders, and I obviously come at this from the perspective of, you know, the jurisprudence around the First Amendment. And when I hear you talk about issues around what's the subjective meaning, is something vague, it, again, I'm sorry everybody, brings me back to that central Hudson test, and thinking about how would a court deal with that. So let's assume that the First Amendment does apply, that this is advertising lawful activity or not unlawful activity. Then the court looks at, well, does the state have that substantial interest? And presumably the state, and I think the laws set forth that interest being, you know, health and safety, children, et cetera, et cetera. So let's just assume for the sake of argument they can meet that. Well, then it becomes this issue of tailoring, which is where I think some of these questions from folks in the industry come in, right? Is it sufficiently tailored to that interest of protecting children or preventing, you know, whatever the specific interests are? And then you look at the regulation, and the court's going to figure that out. Is it directly advancing whatever that substantial interest is, and is it doing it in such a way that it doesn't go beyond what is necessary, right? And so courts are going to look very carefully at the specific words that are used and determine whether or not it meets that test or not. Of course, you don't get to any of that if the First Amendment just doesn't apply. So there really is that threshold issue. But all of these things that you all are flagging from the industry perspective, I think are things that would be very relevant to the courts in this context.
So let me throw out a thesis and get the reaction of folks here. It seems to me that the industry ought to orchestrate a perfect challenge case, and that your odds of winning are overwhelmingly high. So let's just think it through. If I were advising the industry, this would be my pitch. And I could easily be wrong, but let me give you my pitch and then you tell me what you think. First, on the threshold gatekeeper issue, are you advertising a legal product? My pitch would be that the right analysis must be that there has to be an alignment between the sovereign imposing the restriction and whether the product is lawful or unlawful within that sovereignty. And there's actually precedent on this issue dating back to the early days of commercial speech doctrine, when, as now, abortion was legal in some jurisdictions and illegal in other jurisdictions. And one of the earliest commercial speech cases involved advertising by abortion providers in New York, projecting that advertising into Virginia, where abortion was not legal. And the Supreme Court, in that early landmark case, upheld the rights of the advertisers. But let's take a test case in Vermont or any other state. If cannabis is legal in the state, my argument to the Vermont Supreme Court would be, it doesn't matter whether it's legal or not in the federal government. The federal government is not the regulatory body here restricting this advertising. At least that's not the law that we're being prosecuted under. We want declaratory and injunctive relief saying you can't use the Vermont law, because the Vermont law comes from a Vermont sovereign and that activity is legal here. Now that's Jared's first point. Can you get over the threshold gatekeeper of Central Hudson? Once you do, it seems to me almost certain it's a winning case, because advertisers always win commercial speech cases today. Then that's because of Justice Clarence Thomas. When he entered the Supreme Court, he changed the dynamic. The court had been dominated in commercial speech cases by the thinking of Chief Justice Rehnquist, one of the most famous conservatives on the court. His landmark decision, La Posadas de Puerto Rico, reasoned this way, and I bet many legislators today reason this way. The reasoning was, here's the case in a nutshell, it's a simple case. Puerto Rico had casino gambling. back in the day when the only places that had casino gambling were Las Vegas, Atlantic City, and Puerto Rico. Puerto Rico did not want citizens of Puerto Rico to go to the casino because it's bad for you. You lose your money, you break up families. It's a vice. Gambling is a vice. But they wanted people from the mainland to come to Puerto Rico as tourists and to gamble. And so they forbade advertising by the casinos inside Puerto Rico because they didn't want to encourage consumption, but they were fine advertising in New York. The Supreme Court upheld that in a famous decision by Chief Justice Rehnquist. And the reasoning was Puerto Rico could ban casino gambling entirely. If it could ban casino gambling entirely, it could take the lesser step of allowing the gambling, but not advertising about it. And this also became kind of nicknamed the vice exception to the First Amendment. What's bad for you? Smoking, cannabis, drinking, gambling, all these things are bad for you. The government can ban the bad stuff. If it can ban the bad stuff, it can say, we'll allow you to do this, but we won't let you promote it. Well, here's the important thing. When Clarence Thomas came onto the court, he came onto the court as a robust promoter of free speech for advertisers. And he changed the dynamic on the court. He converted other conservatives and liberals. And the big giant case involved Vice, vodka. It's a case called 44 Liquor Mart versus Rhode Island. And the Supreme Court overruled La Posadas and overruled the idea of a vice exception and overruled the idea of trying to reduce consumption by manipulating advertising, and instead said it should be an open marketplace and the government should not make these paternalistic decisions. That has gained enormous momentum over the years. And one of the cases is a Vermont case, a case involving pharmaceutical detailing, the gathering of data about the prescription habits of doctors. And the Supreme Court, in a very powerful decision, struck down Vermont restrictions far more mild than anything that the cannabis industry is coming to. And finally, just very quickly, to the extent that the government would put all the eggs into the children basket, we don't want kids to smoke too early, right? If that's the argument, it's a loser. Because that's true of beer, that's true of vodka, that's true of anything like this. And the government loses these cases. And so I think you get a good juicy challenge. Maybe you do this 15% thing, which is, I think, a walking First Amendment violation, all right? You hire some good lawyers. Jared's right there, all right? And half these students will join you with the research, and you get a test case to strike it down. I'll let you fight me back.
I have the retainer agreement right here, President Small. Anybody that wants
Take a credit card.
pro bono, my friend. First Amendment's important. Anyway.
Questions from the audience? Mm-hmm.
7 VSA 861 subsection 2. Advertisement means any written or verbal statement, illustration, or depiction that is calculated to induce sales of cannabis or cannabis products, including any written, printed, graphic, or other material, billboard, sign, or other outdoor display, other periodical literature, publication, or in a radio or television broadcast, the internet, or in any other media. That means that when my bud tender tells a customer at the store, this product is great.
Yeah.
That is an advertisement. Now, not only does that advertisement have to be subject to, all the rules around, 15% and not appealing to children, the law requires licensed cannabis establishments to seek pre-approval from the Cannabis Control Board for any advertisement. Every time a bud tender opens their mouth in my store, I need to call Bryn Hare, the executive director of the control board, and ask, Mother, may I?
Get a response in 8 months.
How is this constitutional?
Or even more important of a question, how is it possible? How is it actually possible? Why are we, and I don't have any skin in this game. Please. Oh, I know. I know. Yeah, it's not a slow process because there's 2 people doing the job. Well, whatever, there's 7 people doing the job. But it's the exact, the purveyors at 802 Spirits don't need to do that. The purveyors, people at Champlain Farms don't need to ask permission to sell cigarettes before they sell cigarettes. So I think part of this confusion is I think we're going to see anecdotally, and this might be again, I'm not a lawyer, so this might be the wrong thing to say at a conference in a room full of lawyers, but there is maybe an attitude of just throwing one's hands in the air and saying, and waving them like they just don't care. But mostly being frustrated because these are people who want to grow their business. These are people who are trying to engage with customers. Dave's bud tenders are trying to create relationships. That's really that's all business is, right? Creating relationships and being restricted in doing that simply because of ambiguity around what advertising means. Now, I'd ask you, and I'm sure you have it on right next there, is the definition of advertisement in cannabis in the state of Vermont the same definition as advertisement for anything else? Wow, that's crazy. So we don't even have a definition for advertising that is consistent among industry. So I would say that would be a very logical place to start and make sure, again, I'm talking about standards, making sure that we're holding everybody in the state to the same, at least a similar bar, right? Because all these mom and pops who have sunk every dollar of their savings and maybe a little bit of investment cash into starting a business are now being, potentially held up for weeks at a time to have packaging approved, to have, is signage above, is the Flora sign when you turn the power on and the light hits? Okay, so why? It's the same thing to me. Hearing you explain it to me is frustrating. Like, to me, I'm going to say it again for the you in the back. Not a lawyer, the son of a lawyer, so I can hang with you guys, but not a lawyer. And if I'm trying to start a business and you're explaining to me the difference between a sign on my yard and a sign affixed to my building, I'm going to strangle myself.
And let me ask you this, a pre-approval process. So we need to submit this to the Cannabis Control Board for approval. We then have the chair of the Cannabis Control Board go on VPR and state publicly that the board's not going to approve any submissions of advertising. So in effect, where does that leave us? Right. And I think there are some very serious questions, and there may be some resolutions.
And just for the edification of the students, pre-approval requirements are prior restraints. Prior restraints are presumptively invalid under the First Amendment. Unfortunately, there is a line of precedent suggesting that prior restraint law does not apply to commercial speech. But there's a lot of chaos and division among the courts on that, and many federal courts have said maybe prior restraint law doesn't apply with full force with regard to commercial speech, but the procedural safeguards emanating from Friedman versus Maryland do apply. And if you were to apply the procedural strictures, which require clear standards, consistent application of the standards, immediate judicial review, 4 weeks is, in my view, certainly unconstitutional. So challenging the pre-approval requirement might be a fertile place to go. For a long time, many states had a similar pre-approval requirement for lawyer advertising. You had to submit the copy for your advertising to the state bar before you could do it. Those were challenged in a lot of instances, and most bar associations have backed off that rule for fear that they are losing propositions under commercial speech doctrine. But I think that that pre-approval requirement could easily be another vulnerability.
And I would just add a couple things. One, anecdotally, the impact, I think, of these regulations, as I was coming in today, I bumped into a former student, an alumna, and who was here with her daughter, who was under 21 years of age and can't attend, conceivably. And you know, that's obviously hugely problematic, particularly when you're talking about important policy issues like this. And whether that's an accurate interpretation of the regulations or not is in some ways beside the point. What I would say, though, it's important to point out, this is not to say that a state cannot regulate cannabis advertising. It quite clearly can, even if the First Amendment applies. But it's going to have to meet those additional requirements of the Central Hudson test. And it's got a fairly heavy burden to show that there's a substantial interest and that this is sufficiently tailored to directly advance that in light of what the regulations are. So Dave, to your point, I think if you could, if you get past, and I think you would, that first question of, is this lawful or unlawful activity, then I think it becomes pretty hard for the state to meet that tailoring burden based on my understanding of the regulations at this point. But that's not to say they can't regulate. They certainly can.
Reasonable regulation.
Yeah, and the preference in First Amendment law is through disclaimers or warnings. So a cancer warning, disclaimers, that sort of thing. If reasonable, those typically get upheld. But to the extent that the state interest is reducing consumption, that's not going to do it. I think the only state interest, in my view, that would have some traction would be preventing consumption by children. But even there, it seems to me,
it's impossible.
The state would likely lose.
It's impossible because, so one of the regulations that we have implemented always, so just so you know, so I try to hold our design team to the standards basically of the FDA in terms of transparency, descriptions, that sort of thing. So there is a bar that we try to set creatively and in terms of just how information is presented to consumers that we like to hit. But on the digital side of things, we have something called an age gate. If you've ever been to a cannabis website and it asked you if you were 18 or 21, depending on what state you are, and you said yes, that's the extent of that due diligence, right? As long as you hit
every minor.
Yeah. Find me a minor who doesn't know how to find anything on the internet, okay? That requires them to prove their age. You see where I'm going with this. So the 15% rule is completely unenforceable because how are you, like, it's impossible for us to, even through analytics, even with the release of Google Analytics 4 in the coming months, there's not someone standing over every internet user's shoulder checking, actually physically check. There's no red velvet rope and a bouncer to check that ID. So age gates. Age gates.
Real effective.
I kind of trailed off there, but my point is the enforceability on all of this, especially in Vermont, as all these regulations are enforced by the Department of Agriculture, which is, one guy, and not, I don't know, what's the Vermont alcohol?
Department of Liquor Control. Or
Department of Liquor Control, which is a team of many, many people who are able to actually enforce a lot of these things.
Other questions from the audience?
I drove all the way here for this. You better have questions.
Tim, I think you said you worked in tobacco as well. Can you kind of explain just some of the labeling regulations in terms of tobacco and how you're seeing it kind of come through in cannabis as well?
Well, we don't work with tobacco, but I was using that as an example of, yes, there are warnings on cigarette packs, and that is reasonable. It is reasonable to put a warning on a cigarette pack. What you don't see is a cigarette pack covered in warnings on the front, on the back, on the top, on the bottom. What you don't see is a blanket restriction on advertising cigarettes at all, anywhere, ever, under any circumstances. And cigarettes are far, far more dangerous, far more addicting than cannabis. And I think I was speaking to that in terms of the arbitrary nature of the regulations that have been placed on cannabis. We have in our society deemed that as an adult, adults are allowed to make poor decisions. To an extent, if you choose to smoke cigarettes, I think everybody in here is well aware of the health consequences. If you choose to drink alcohol, I think everybody in here is well aware of the health consequences, and a warning label to remind people of those health consequences. That's an example of reasonable regulation, reasonable restrictions, reasonable warning. But when you take it to such an extent that where it becomes a de facto complete ban on advertising, a complete ban on growing a business, on letting people, adults who wish to use your product, know where they can simply get it, that exceeds, what's permitted by case law, our Constitution, and just common sense.
See a hand up here?
Hi, I'm Andrew Marshev. I'll be moderating the next panel, but I had, maybe it's too simple a question, but I'm just curious, would swag be considered advertising? Like if you wanted to sell a hat with your business's name on it?
When the CCB considers an Adirondack chair in front of a store advertising, I would say there's a good chance that could very well be. But I think the question is an excellent one, not too simple a one, when one shows the problem. And that is, we don't know. Right. Is it? Maybe. Maybe not. Are you going to risk a sanction? Are you going to risk getting fined by the CCB for advertising because you sold a hat? If a 16-year-old is wearing a hat from your dispensary, are you now subject to sanctions because a minor has a hat from your store? I think that, with the current climate, there's a lot of concern that could be a real issue.
Thank you.
So maybe the last question to ask is, to what extent is this an attractive area for young lawyers to consider as a career path?
I would say, in my experience, there's two different types of lawyers. We'll get your question, absolutely. I'll do this real quick. One that really likes clear, bright line rules, likes precedent, likes to be able to look and get an answer. Those people are going to hate cannabis law.
Is that because cannabis makes things blurry, or is that because the law is somehow?
Exactly.
Yeah. Let's have the last question here.
Can I answer that too, though? I have an answer for you, President.
Yeah, good.
So I'm going to look at it from an entrepreneurial standpoint, because that's sort of the thing that blows my hair back. It's not necessarily the, So I would say if separating the actual legal ambiguity of all of this, is this a good idea to pursue this as a career path? I would say entrepreneurially, absolutely. There is so much opportunity, as you can see in how confused we all are up here as people who have been running actual cannabis companies, me for going on 7 years. There's a lot of opportunity to guide not only clients in doing the right thing, but helping to shape this industry and what it turns into. And I think if we boil it down even more simply, like, we're trying to create an industry standard in this state. That to which we hold our tourism destinations to, our craft beer industry to all of those things are important aspects of the identity of this state, and cannabis has been maybe in the shadows, but it will be a huge part of the future of the state in terms of employment, tourism, all of these things play into it. People love getting high. I can say that with absolute certainty. That is a non-subjective statement. So as we're thinking about this question, is this a good place to start practicing law? Well, if you care about your backyard, if you care about these sorts of issues and how they are going to impact the future of the state, and you're an entrepreneur who's excited about being challenged, yeah, jump in. Don't even think twice about it.
Okay, last question.
Yeah, thank you so much for this panel today. And my question was, this conversation makes me think about the e-cigarette advertising to children and all of that, and how it might relate to cannabis and kind of the comparisons that can be made.
So there's the vape tax, right? Which is, I don't know off the top of my head, 90%, 92% of 92% of the product price is taxable. And this is not, I think, going to be sorted out in the next. This is an example. That's a great question because it's a perfect example of how we can, find an issue, find something that's clearly ambiguous or something that was intended to, do something else, and then is lumped in with cannabis. So. Seeing, that's actually, I feel like, the first thing in terms of redefining regulation or rolling back regulation, however you want to put it. But understanding that existing regulations don't necessarily apply to cannabis, but also because cannabis is for sure its own thing. But that there is a consensus that this huge tax was meant to curtail teens buying vapes, right? To make it unaffordable for people to buy these products. And Tito Byrne of the Byrne Gallery and a whole, I'm sure you've been involved with this, a whole other group, a whole bunch of other business owners have been really hard pressed to fight that tax as it applies to cannabis.
So that ends our time. Please join me in thanking Tim, Will, and Jared.
Well, thank you so much.
Thank you very much for having us.
We're going to take a quick 5-minute break, and then we will move right into Mr. Ben Gelt.
Great job, guys.
Okay, we're gonna go ahead and get started on this next lecture. I know that was a little short, but I wanna try and stay on schedule because that last one ran over a little bit. So I'm excited to introduce to you guys Mr. Ben Gelt. He's joining us from Colorado. He is the board chair of the Cannabis Certification Council. Mr. Ben.
Hey, y'all. My name is Ben Gelt. I'm here today. I live in Denver, Colorado. I've been in the cannabis industry since 2007. Hey, do you guys mind going in the other room? Looking at you. I'm really shy. I'm here today to talk about certifications in the cannabis industry, challenges and opportunities. Let's go to the next slide. So I wear many hats. As I just mentioned, I've been in the cannabis space since 2007. I started way back then with a handful of different clients, including what ultimately became the University of Colorado Toxicology Lab, where I did public affairs work between, I think that was like 2009 and 2014. And through that work, I learned quite a bit about how Colorado and then other states were dealing with public health, environment, consumer safety, and the like as it pertained to their regulatory structure. In the course of that time, I co-founded a nonprofit that was originally called the Organic Cannabis Association, which then later became the Cannabis Certification Council, references the council there. So we're now the Cannabis Certification Council, and I just put a little bit about us. So we're a national nonprofit focused on educating consumers and industry on sustainable practices and standards. I'll get a little more into that. Some things that we've done, there's an event that we've done, I think, 7 or 8 years now, the Cannabis Sustainability Symposium. You can just go to cannabissustainability.org and learn more about that. We are not going to be doing one this year, so don't get too excited and ask me where it's going to be or when this year. But we will be bringing it back next year with some amazing partners, including the state of Colorado, the state of Oregon, probably some other states, and another awesome nonprofit called the Resource Innovation Institute, which I highly recommend if you're interested in sustainability. Among other things, we've also published a living document called the Cannabis Environmental Best Management Practices Guide. We're actually, I think, about to publish another version of it. It's a living document. It covers sustainable practices and operations for all phases of the cannabis industry, so cultivation, manufacturing, retail, delivering, distribution, et cetera. Some other things that we've done at the council years ago, we published a pesticide-free certification. I can tell you, had zero market traction. I'm really good at selling stuff, and I could not sell that. We've also developed and have about 85% of the work done for another certification called Organically Grown Cannabis, and we'll get into that as well. Next slide. All right, so we're gonna just jump right in, apparently. So there's no shortage of options out there in the cannabis world to get certified. I'm here representing a group of many, many others. There's literally hundreds of people that have been involved with the work of the council over the years, maybe, I don't think more than hundreds, but lots of hundreds. And we've identified dozens of them, several dozen. Next slide. So yeah, here's a small smattering of them, and feel free to contact me after. I can send you a link to a web page with maybe 12 or 13 of these listed, and like I said, there's dozens. So just on this little slide, you've got public, private, and NGO, because I didn't have room for nonprofit. OCAL right there in the center. Is anybody familiar with OCAL? I wouldn't expect a group of people in Vermont necessarily to be so. It's the state of California official organic program for the marijuana industry. So there you go. The state of California has created their own organic sort of regime for cannabis. It's had very little traction. I don't think I could get, Clean Green, I don't know if they're on there. There's one called Clean Green that I would say is the market leader in terms of traction. We'll get into the efficacy and quality of the standards. I love I really do love the people at Dragonfly Earth Medicine. They're super kind, very knowledgeable people about biodynamic cultivation, outdoor growing, et cetera. But it gives you a sense of the kind of span of options that there are out there in the market, everything from a state-regulated, supported thing to something as sort of ephemeral as Dragonfly Earth Medicine. Sun and Earth is one that I also love to note. It's a regenerative organic standard, and I would say in terms of quality of standard and what would be ideal on this planet that we're living on, Sun and Earth is the North Star for cannabis certifications, in that it's a rigorous program, it's a real, there's real depth to the technical programming, and it's an ideal thing to do all of our agriculture in a regenerative fashion. Now, I can tell you that one specifically is backed by the Bronners. Many of you may be familiar with Dr. Bronner's, the soap and other beauty brand product. They've been great supporters of the council as well, but we frankly had to part ways with their support at one point because they wanted us at the council to go down the path of regenerative organic certification, and we felt very plainly and continue to feel that the addressable market for regenerative organic certification is pretty much nil. The preponderance of cannabis cultivation, whether licit or illicit, is indoors. The cannabis consumer strongly prefers indoor production. There's a huge delta between the value of outdoor production and the value of greenhouse production, and then another delta up to the value of indoor production. There's a whole other problem that I'm not here to talk about with the economies of scale and the amount of capitalization that's gone into indoor production, which just, it's way too much, you guys. The industry is in a really bad place. If you live in California, Colorado, Oregon, Washington, Michigan, or really anywhere where you've had time with the regulated market, you've seen what's effectively a saturation of all of those markets with supply. You've seen all of those suppliers invest mega millions into their facilities. And in a lot of cases, they're now seeing something like, in Colorado, like $200, $300 a pound for a product that in most cases, in a really great case, maybe costs $500 or $600 a pound to produce. So for those of you who didn't catch that, that's $200, $300 at market, when it costs you maybe 2 or 3 times that to produce it. So good luck calling that a business. That sounds like a really expensive hobby to me. But I continue, part of the reason that these guys exist, that we exist, that these kinds of concepts exist is to drive additional value, added value to a given product. So next slide, please. The benefits. So the benefits of certification, right? I just kind of touched on it. How many people here prefer organic fruits and vegetables over conventional? Show of hands. Small, okay. I would think it would be higher in Vermont, but most consumers will say that they prefer it. There is a delta between, of course, what people say they'll do when it comes to spending more money and what they'll do. But when you look at organic certification in particular in any market, in North America or Europe, there's a huge premium. Typically anywhere from like 55% to 110%. You can see like eggs and those sorts of things when you get into the various things that they can have associated with them. You can get some really expensive, like $10 for a dozen eggs kind of stuff, and there is a market for that. For cannabis, it's our theory, and it has to be a theory at this point, because could we go back a slide? There's this alphabet soup, and again, this is just a tip of the iceberg kind of picture. There are dozens more logos that I looked at and thought about cramming on here, but it just felt like too much. Nobody's been able to crack the code of how do you add that value. And I think, is there anything that stands out to folks about what's here? These are all organic-like certifications. Is there anything that stands out to you all? How about the fact that the word organic is not there? Let's go 2 slides. The challenge. Call it what it is, I say. As noted, there's an alphabet soup of certifications and offerings in the market. None of them say organic. OCal, Clean Green, Sun and Earth. There's a new thing out there called the Cannability, which is being backed by some pretty serious money in Chicago, looking to essentially create the Good Housekeeping seal of approval for marijuana. Next slide. The opportunity. Someone will figure this out. Consumers will have an opportunity to force producers to create products that meet higher standards, organic, sustainable, fair trade, et cetera. So again, we know just from going to the supermarket, there's an organic section in the produce aisle and there's a conventional section. You don't have to ask anybody where it is. Right now, if you go into, how many people in this room have been in a dispensary? Show of hands. Okay. Has anybody seen an organic product in a dispensary? Has anybody seen an organic claim? No, that's interesting. So many states have specifically regulated that you cannot make organic claims. The state of Colorado, for example, said that you cannot make organic claims unless you substantiate it with the Attorney General's office, which is really difficult to do. Attorneys General are not actually set up to deal with agricultural issues like that. You would think that maybe the Department of Ag would have been the place where you have to substantiate it. In any event, there's this massive opportunity to start labeling these products as such. Can we go to the next slide, please? Oh, I'm out of slides. Let's go back to the alphabet soup slide, if you would, please. So again, getting into the challenges and opportunity of certifications in the space. The big problem to date, in my view, is not a lack of standards that have been developed. We've got, I think, a couple more back. We've got this huge alphabet soup of groups that are putting things out there. The issue is that none of them have created what is known commonly as a trust seal, which is that none of these things are household names. So again, even without any kind of, without a budget, without some sort of regulatory structure, most of these groups are just out there doing this thing on their own, either as a private business or a non-for-profit. The state of California, for example, is doing it as a state. The state of California has no money to put into this. So at least for us at the council, the decision that we made was to go ahead and do a standard called organically grown cannabis. We're taking some risk by doing that. There's some risk that the federal government will come down and say that you can't say organic on a package. There's some risk that a state may come down, ask 100 consumers, what does clean green mean? You're gonna get a bunch of I don't knows. You're gonna get a bunch of, maybe it's a cleaning product. You're not gonna get very many people or anybody that's gonna say, oh, that means that it's organic like marijuana. So you just, there's just a dearth of education out there. I apologize, you guys. So again, in our view, the opportunity here is to start labeling things as they are. The other sort of challenge with trust seals is having the depth behind it. So many of these groups, when they're private entities, and I'm not going to name names, but a few of these groups are private. There's some semi-governmental. You have to kind of vet what the interest is. So when you have a private group that's, say, maybe backed by a lab, are they looking to then funnel business to their lab operation to then drive revenue for a different business that they own? If you have a state, how are they going to promote it? If you have a small nonprofit, how are they going to promote it? So again, our feeling is with cannabis that there's this huge opportunity to go ahead and start labeling things as they are. There's also a very well-structured and well-known process for creating certifications. These are public processes. If you go to our website, cannabiscertificationcouncil.org, typically in most advanced or what are called mature, I think generously, mature markets, you see that there's huge price compression, which I talked about earlier, right? The price of a pound is way down. I saw this week that the price per gram in Oregon is now averaging about $4 at retail. So if you're a business operator, you're under huge pressure to find ways to become more profitable to reduce costs, to raise revenue. And again, we perceive certification as a pathway to doing that, potentially without having to alter your operations. If you're already growing organically or if you're close to it, these may be pathways to then highlight to consumers that you've got something different that they're willing to pay more for. I'll just pause here. Does anybody have questions, comments, observations so far? I feel like I've kind of shot through a bunch of stuff. No? Okay. Up front.
Hi there. I'm Ben Verotti. I teach here. And full disclosure, I think I'm technically a member of Dragonfly Earth Medicine, which operates as a collective.
Right.
And is they're true believers.
Yes,
in
they
their
are.
cultivation methods. I'm wondering, really, for the first time, how much of this issue about getting buy-in has to do with federal prohibition and the idea that if you're an MSO, you just want to build your own brand. You don't really have any incentive to say, oh, we're certified in one way or another, because you want people to be thinking like, oh, we're WANA or whomever. And if you're operating in a more regional market, it seems like maybe there's some similar challenge. Like, I'm wondering what size of a market you need for certification as a marketing tool to really be effective. Is this large states like California? Is this large municipalities? Where does it kick in?
It's a good question. I mean, I do think that part of the challenge is how fractionalized the marketplace is, in that every state is an island and there's no ubiquity. You know, he mentioned, I don't know if people are familiar with WANA. They're a pretty dominant gummy brand. There's also not a really dominant flower brand in the country, right? You might look at cookies. I don't know if people are familiar with Jungle Boys. They're starting to kind of come out of the illicit market in Southern California. They're doing a branding deal right now in Florida. I think the answer is that actually the fractionality or fractured nature of the market is not as big of an impediment in this instance as it is in, say, standardizing your business operations for a cannabis enterprise that's in multiple markets. I think in this instance, the bigger challenge is that there's been, to date, no market pressure. Consumers, functionally today, the way that consumers behave with marijuana is they want the cheapest, strongest product available, and they want it to be maximum convenience. So, and this is what all the data shows. One of the speakers earlier mentioned New Frontier. I work with them. There's a group called Headset that generates a ton of data. I work with them. I realized I totally skipped over kind of what I do now. I'll back up to that. The point is, the way consumers are acting, it's like if they went into liquor stores with the same mindset, people would be going into liquor stores asking for the cheapest Everclear available 100% of the time. And we know that's not happening. So I think that the broader challenge is market education. Consumers don't know what they don't know. Market maturation, right? You're still seeing a proliferation of not just brands, but also mediums, right? Like you have transdermal, sublingual, gummies, candies, brownies. That, you know, people are coming up with new ways to consume cannabis like every 5 minutes. And again, a lot of the race, technologically speaking, with that derivative product creation is controlling the onset. So WANA has a fast-acting gummy that's become very popular. We think that different products like extended release and other things that you see with like medicine and other product categories will start to exist here as well. Again, I think the consumer behavior at this time makes it very difficult for an operator to really say, I'm going to pursue organic because I think my consumer cares that much more about quality. If an operator is paying attention to the data that they're seeing at their store, they're seeing that consumers care about potency and price. So I don't think that small, medium, large market is as much of a challenge in this instance. I do think that entering into a small market like Vermont with an offering like Dragonfly, like you're in, or what we would eventually push at the council, organically grown cannabis, might be easier, only because the market is smaller and my ability to communicate both directly to consumers and to producers in a ready fashion might be greater because I need a smaller megaphone and I might be able to drive around and like hit a high percentage of operators. So it's a really interesting question, but yeah, I think in this instance, the bigger issue is that the market isn't there yet. So again, one of the fascinating things about the cannabis space is it's not like we regulated it and suddenly there was a market, right? People were smoking weed way before anybody legalized medical or recreational or anything else. So you also are overcoming, in this instance, a very well-established consumer behavior of kind of taking what's available. And so that kind of history now leading into a regulated space where there's now suddenly a proliferation of what's available, I think is part of the connection of why people are going to strong and cheap. Because they're saying instead of, well, I just get to take whatever the person that I meet or shows up to my house or however you were doing it in the past, you just have to accept it. Now you've got some optionality. So people want to save money or they want something cheaper. They're not quite there. But again, I think the other problem is, what is Dragonfly Earth Medicine? What is OCal? What is Clean Green? So if you're a consumer in Portland, Oregon, and you show up to a store and say, I want organic, maybe the bud tender will know that Clean Green is an organic-like certification. But I think, you've got to make things really easy for people. So again, our tact at the council has been to say, we're going to go ahead and call it organic, organically grown cannabis. We did test this out. So in our process of developing the standard and sort of kicking tires on it internally, we found 2 different CBD products, both in the Northwest, that were making organic claims, and submitted complaints about them. And what we got back from the USDA was, yes, these are valid complaints, these are inappropriate claims. However, one of the letters in particular, because we tweaked the second one after the first one, because we were looking for some feedback on what if you say organically grown cannabis. And essentially what we got back on that second letter was, as soon as you say cannabis in connection to organic, the federal government is going to go like this. They're not going to see it. The primary way that you violate the making the Organics Act, there's all this stuff that was created in 2002, which created the U.S. Organic Program, was watered down pretty quickly in 2004, blah, blah, blah. The short version of all that is you can't go around making organic claims without participating in that program, without like some very like clear caveats and delineations, one of which would be to have cannabis included in the word, which the USDA does not currently oversee. So once you include cannabis in the designation with organic, they say, we believe that they no longer see it. So we believe that we wouldn't have any problem from the federal government with the producer getting an organically grown cannabis certification. We also believe in the same breath that in certain markets, Washington State, for instance, potentially California, that those regulators might have a problem with us saying that. But we also, frankly, bake that into our planning and thinking. I'm very good at marketing and PR and communication. That's really what I'm good at, is this. And to us, the state of California, the state of Washington, or even the federal government for that matter, sending a cease and desist letter and saying you can't make this organic claim is an opportunity to put out a press release saying, whichever jurisdiction doesn't want to have consumer transparency and safety and doesn't want to have businesses being successful and able to market appropriately to their consumers. Any other questions, comments?
Thank you. So I'm curious, you were talking, kind of making the analogy between walking into a liquor store versus walking into a dispensary and the education piece. And obviously, alcohol is something that it has been legal in the United States for a very long time, so there's been maybe more time for that education piece to mature. But in your opinion, and I see you're kind of already raising your eyebrows, what's the education piece that's missing for cannabis for consumer consumption?
Sure. The reaction about alcohol, it's so fascinating to me. You know, I travel extensively around the country and also internationally. So I'll just back up for a moment. I will answer your question. So I mentioned I've been in the industry since 2007. Currently, I serve in multiple capacities. I'm in a licensed manufacturer, processor, and research and development license in Washington State. I'm in several cultivation and vertically integrated licenses in Colorado and Michigan. I advise companies coast to coast. I serve as an advisor at a national law firm called Greenspoon Martyr. I also serve as an advisor for a state and federal lobbyist based in Boston called Rasky Partners. And then I have many of my own interests. So to answer your question, what's the delta in education? I mean, it's massive. One, we know that alcohol is corrosive to the individual body, and I think pretty easily argued, you know, societally, not a great thing. I often, and particularly in the last couple of years, have begun to wonder what alcohol would look like if we had ended prohibition in like 2015. You know, I recently, for a client in Denver, had cause to look at the liquor license map for the city of Denver. I've become very familiar with the cannabis licensing maps in many jurisdictions where you basically see cannabis you know, zoned into industrial corridors, heavy commercial corridors, very isolated. Alcohol is ubiquitous. There is a liquor license in the city of Denver like every 10 feet. It's stunning. There's so much of it everywhere. So what's the difference? Like, you know, societal acceptance, the war on drugs, reefer madness, all of these things where we in our society have chosen to essentially criminalize certain types of behavior and not others. And I think that, you know, those decades and really like a century plus of doing that type of social education where drugs are bad, you know, Nancy Reagan, I don't know how many people are in their 40s like me and remember all that stuff in the 80s. You know, we've just had it beat into our head. Like, who remembers the, you know, this is your brain on drugs in the frying pan commercial? Like, does anybody believe that today? Like, and you know, the notion that, you know, cannabis has been lumped in with heroin and cocaine and like other drugs that have a more corrosive effect on the body and mind, right? These are all massive challenges in the broader fight to sort of destigmatize marijuana. I think other drugs, certainly in Colorado, we've now, last fall, we passed an initiative to essentially, right now it's pretty crazy. Right now in Colorado, technically you could have like a dump truck full of MDMA and not be breaking the law. We decriminalized and essentially created a mandate to create some sort of commercial regime for psychedelic drugs. So the anticipation is that psilocybin, magic mushrooms, will be the sort of first thing that comes into the market with a regulated structure. But ultimately, like the language of the ballot initiative says all of it. So getting back to the education question, there's so much there. Going back to certification specifically, I think the delta is frankly so big that unless someone takes risk the way that we're proposing taking risk with what you call a certification, that we'll see a continued sort of gap because consumers, they need guidance. There's all kinds of stuff out there in the marketing world and the consumer packaged good world about how to train consumer behavior. And there's all these techniques that people have to do it. And you know, some of the panels today have talked about the restrictions on advertising. Like, these marijuana businesses are kind of walking around with one hand tied behind their back. And that's just from a regulatory perspective. They're also not profitable, right? Like, I talked a little bit about how overcapitalized the industry is and how much the price is compressed. That's a huge problem. They also have massive tax burdens because of the war on drugs. For anybody that's an operator, you've certainly heard about 280E. This is a provision of the tax code that was actually promulgated in the early 80s as part of the war on drugs that has effectively kept the industry from being profitable because of the incredibly high tax burden that retailers carry. Retailers of marijuana typically are looking at like an 80% tax bill, whereas if you're like 7-Eleven, you're at like 10, 15, 20%, depending on how crafty you are. So the amount of education that's needed broadly is just like so massive. The good news is that, you know, states like Colorado and Oregon and Washington, the ones that kind of led the way with cannabis, are also now starting to lead the way with some of these other, what are being referred to as natural medicines or entheopathic medicine, with like psilocybin, ayahuasca, MDMA, these other kinds of substances. And I think that broadly, these kinds of actions will help to defray some of the effect of the war on drugs and some of the effect of the culture that we've created. But listen, I was in Chicago last month at a conference at a nice hotel for a cannabis conference, and I walked outside the first night and there was a guy, like a well-dressed gentleman, slumped on the side of the building, covered, you know, he'd vomited all over himself. He had a circle of friends standing around him laughing at him. This is how we treat alcohol. So, you know, it's gonna take a lot of concerted effort on the behalf of a lot of people to, frankly, create more stigma around that type of behavior, which is so bad, right? If it were my friend, I wouldn't be standing around laughing at him. I'd be worried about him or questioning myself, like, why is this person my friend who can't control himself? So there's a long way to go. More questions, please. None? Well, I think I'm going to leave a little early then. Thank you guys for listening to me. I really appreciate your having me here.
Okay, everybody, we have another 10-minute break before our next panel.
Hello, everybody. Welcome back in person and digitally online. We are in the third panel of the day. I'm Andrew Marshev. I'm the fellow for the Legal Food Hub here at Vermont Law and Graduate School at the Center for Agriculture and Food Systems. The Legal Food Hub is a project that connects attorneys and farmers, food entrepreneurs, and related nonprofits with attorneys who are willing to work pro bono. So if any of you attorneys, Vermont practicing attorneys in the audience, please feel free to contact me. We're recruiting new attorneys. It's great work. And that is where I'm coming from as the moderator. I don't have any cannabis law experience, but I am a Vermont practicing attorney in the agricultural space. And we are honored to be joined today by Tim Fair, Dave Silberman, and Dave Mickenberg. Am I right? You're both Daves? All right, great. I just want to make sure.
Either one.
Or David. All right. Well, maybe that'll help us distinguish for Dave and David. And there are some of the first practitioners of cannabis law in the state. And so I'll let them give a more in-depth introduction to themselves and their practice. But it's great. We're lucky to have some of the pioneers in the state in this particular area of law. So thank you.
Hello again.
Go ahead, Tim. Yeah. Oh, sorry.
Hello again, everybody. For those of you who weren't present at the last panel, my name is Tim Fair. I'm the co-founder and managing partner of Vermont Cannabis Solutions. I'm also a partner in Ojo Rojo Cannabis Wholesalers. I think one of the most interesting aspects of cannabis law that I've seen since I've begun this in 2017 is how fast it has expanded. We do have a bar association. When I began, I'm a first member, I think in 2016, there were about 200 members. It was the National Cannabis Bar Association. This year, I believe membership exceeded 800, and it is now the International Cannabis Bar Association. It really is an incredible area of law that gives you an opportunity to practice in more areas than you ever thought possible under one roof. And it's been an incredible experience.
Everyone, my name is Dave Silberman. After 20 years of practice as a corporate lawyer, both at a large law firm in New York and in-house out of California, I started a solo practice, Silberman PLC, focused primarily on cannabis law. I've helped a few dozen entrepreneurs get their licenses. I'm also a co-founder of Flora Cannabis, Vermont's first adult use cannabis dispensary in beautiful downtown Middlebury. And I'm pleased to be here. Looking forward to talking with you all.
And thanks for having me, David Mickenberg. I am a partner at a law firm, Mickenberg, Dunn and Smith, which has been around since 1982, and got involved in cannabis law and policy in 1997, and then have been involved primarily on the legislative side of things, but since 2006 have, 2006, 2007 had represented sort of fledgling cannabis businesses, and then in the last few years represented multiple cannabis businesses in Vermont, and happy to be here, and thank you all for coming.
Thanks to the three of you for your introduction. So I think what might be helpful is if you want to give a little bit of a overview of how you entered the particular cannabis law, which might also give us a little bit of history in terms of legalization in the state and sort of the precursors to it with the CBD industry. Yeah, well, same order, maybe, yeah.
Prior to my existence as a cannabis lawyer, I was actually a litigator, primarily criminal defense and family law. Around 2016, I already started seeing myself get a little bit burnt out, especially on the family law. And at the time, the Western experiment in legalization was well underway. And what I was seeing was cannabis law firms start to pop up. Hoban Law being one of the early ones I was following. And I realized that this is what was going to be coming, what was going to be coming to the East Coast, what was going to be coming to Vermont. And at the time, we had just, started talking about hemp and CBD. It was before the Farm Bill. But, when 2018 rolled around and the Farm Bill legalized hemp and CBD at the federal level,
That was when I made the switch over to cannabis law, and we started here in Vermont. I think we were the only cannabis law practitioners in 2018. I had my colleagues telling me I was going to be disbarred, I was going to be arrested, I was going to be subject to federal charges. A lot of
Because of this, or because of other things you did?
You know, and it was interesting. It was, I think, my old boss and a lot of people kind of looked a little side-eyed. But we gave it a shot, and we started out with the hemp and CBD industry, helping people establish some of the very early CBD companies here in Vermont, which was amazing to see, and help them navigate the minefield. And then over the last few years, we've transitioned from CBD and hemp into adult use. This past year, we have submitted somewhere in the neighborhood of 160 adult use cannabis applications for Vermont businesses. I formed somewhere in the neighborhood of 250 Vermont cannabis businesses, which is funny since 5 years ago I didn't even know what an operating agreement was. You know, you have to learn a lot. You have to be willing to expand your area of knowledge. What you're good at, cannabis law encompasses so many different areas of law in your day-to-day practice that it really is essential to be able to pivot quickly, understand that you're not going to know everything, understand that there are not always going to be clear answers to everything. A lot of times it involves speculation, taking an educated guess at what's going to be coming down the pipeline, looking at other states, but not looking too closely because of the patchwork of regulations. It's a lot of fun. It's a lot of fun, I gotta say, but it's certainly not for everybody.
I started getting involved in drug policy work in 2015 as the legislature was really starting to think for the first time deeply about legalization. And I just started showing up at the State House as a concerned citizen, offering feedback on legislation and making contacts. And, you know, one thing led to another, and, you know, people are asking me to help them write legislation. That's great. So, you know, there's pieces of this law that we're dealing with that blissfully I wrote. So I like those pieces the best. In 2020, after we passed Act 164, shortly after that, I left my in-house gig out in California I was telecommuting to, and really focused on my private practice, my solo practice at Zuckerman PLC, which now, I think last year was about 70% cannabis work. It's been interesting making that transition from sort of being involved in the pushing for legalization and now helping entrepreneurs deal with the mess that we created. It's generally fine. But like Tim said, it's a very varied practice where you're touching many, many areas of law. I never thought that I'd be, you know, trying to understand what the Division of Environmental Conservation's rules are. But, you know, now it's important for cannabis businesses to, you know, have good advice on whether they need indirect discharge permits and things like that. So you'll get to learn all sorts of things that you never thought existed. You know, it's fun in that way. It's a challenge every day.
Yeah, all of that and and more. Yeah, it's funny. Tim mentioned 2016. Prior to 2016, there was a question in Vermont as to whether lawyers could even represent cannabis businesses. I remember being on the phone with Bar Council and others, scratching my head about whether what I was doing is gonna, as Tim mentioned, you know, am I gonna lose my license? Am I gonna go to jail? Lots of questions. And we should just frame all of this within the context that everything cannabis businesses are doing in Vermont, all the activities are illegal. They're illegal federally, you know, and so that presents a lot of challenges for attorneys and representing folks and how to navigate those waters. So it wasn't until 2016 when the rules of professional responsibility came out with a guidance memo. I think it was a comment 14 to Rule 1.2, which said definitively that lawyers in Vermont could represent cannabis businesses. And that was a relief for many of us. But like that issue and all the issues that we deal with representing businesses, it's always through the lens of an examination of what state law says, but also considerations of federal law, and how you advise your clients on those issues are very difficult. And so those are waters that, as Dave and Tim mentioned, you sort of feel your way through with guidance from case law, from other states, from ethical opinions, but they are important waters to navigate and to be thoughtful about and to advise. In the advisory from the Supreme Court, basically they were saying, like, you have to advise your clients on an ongoing basis about the continued illegality of cannabis on a federal level. And until that changes, it's going to be an issue that as lawyers we have to think about. Now, that being said, cannabis is such a large business. We've come so far, sort of nationally and growing in Vermont, but we've come so far that it as a legal and business issue has been entrenched in our culture on some level, so we can sort of rest a bit easier. But as lawyers representing clients, there's issues that sort of ethical issues, professional responsibility issues that come up frequently. I'm happy to elaborate on those as we talk about this stuff.
And so I guess one question I had, and I think this might apply mostly to Dave, but as the title of our subtitle of our panel describes, that we're focusing on transactional law, is there any difference that any of you have seen between practicing transactional law, writing operating agreements, forming LLCs for businesses that aren't cannabis related versus businesses that are? And something that, and how would you say that to some of the law students that are maybe learning this for the first time?
I'll take a crack at this. Operating agreements, for example, for LLCs in the cannabis business are not that different from operating agreements in others. I mean, you want to, when you enumerate the powers of the entity, you want to enumerate the fact that, when you say any lawful purpose, that includes commercial cannabis activities that are illegal under federal law. So things like that. And you have to think about the particular, regulatory, restrictions and how to address those that you wouldn't have to deal with in setting up a non-cannabis business, including in your subscription agreements and offering memorandum and whatever. But I think the most important difference that I've encountered in working in the cannabis industry in Vermont versus working for other industries is that there is overall a lower level of business professionalism among the clients that you will encounter as a lawyer in the cannabis industry. There's a lot of folks, I don't mean that as an insult, there's a lot of folks who have never run a business before, and there are folks who have run a business but in an unregulated way, and for the first time are trying to follow rules. And so that, I think, is the biggest difference in representing cannabis businesses that I've experienced, is trying to help folks come to grips with the reality that they're operating in, that they can't just do whatever the heck they want, that they have to really take rules seriously, and that they have to know what those rules are.
It's really funny you mentioned that. Over the last 3 years, I've actually developed 3 different operating agreements. I have one for Vermont farmers who do not like documents, but they need something. I've got my kind of middle of the road for most small businesses, and then I have my out-of-state client, 29-page extensive. And it's true, because I think Dave really hits it on the head. You're working with a lot of people without a lot of experience. A lot of them have a natural aversion to lawyers. They have a natural aversion to regulation. They don't want to see contracts that are 35 pages. They're used to doing things on handshake deals. We can't do things on handshake deals. So being able to adapt to your client, understanding their level of sophistication, and their needs, even if they don't maybe necessarily understand their needs, and then being able to address those in a way that they will agree with and get. And, you know, that can be a challenge too, because it's not, one size does not fit all in this industry. And that's an important thing to keep in mind.
From my perspective, I've done some transactional law, but I'm generally not a transactional lawyer. So one of the most important things for me and the clients that I'm representing, cannabis clients, is the scope of representation. So going into the interaction with the client, having them very clearly through a written document, understanding exactly what you can and can't do. And sometimes that's hard. And those boundaries, clients want more or expect, well, you're my lawyer, yes, but let's review what I'm your lawyer for. And so that's a really important thing, because especially as new lawyers, you want to service your clients in every way you can. Some attorneys can do that. They acquire the skills, and that's great. And I have more of a specialized practice. So I think really laying out the expectations, I think attorneys get in trouble when those expectations aren't clear and people thought they were being represented to do a 39-page contract when in fact they're being represented to do X, Y, and Z. And so a lot of clarity on the front end about what the scope of your representation is going to be, I think, is really essential to managing those expectations of clients so that you don't run into issues on the back end.
People think, you know, they look at doctors and they understand there's podiatrists and there's brain surgeons and there's cardiologists. They don't get that with attorneys. They think, you know, oh, you're a lawyer, you know everything. And I think that's an incredibly important point to make, is that we don't know everything. And sometimes you just have to tell your client, you know what, I can't do this, and I'm going to need to refer you to someone else.
Yeah, and that's tough because, you know, I find that I'm very selective in my client selection, and, you know, I really form relationships with them. These are professional relationships, but I do end up caring about my clients and caring for the success. So when they come to me with a new issue, and it's something that's really outside of my wheelhouse of the practice area that I normally live in, it's very tempting to say, well, okay, I guess I'll help you with that, but you might not be really able to, you know, if you don't, like, I can't help my clients with litigation. I can maybe advise a little bit on early strategy, but I'm not a litigator. And it's very tempting to sort of just dive in with your client and do the work. But, you know, I would just encourage, you know, you folks who are just beginning your careers to figure out what your strengths are and not get yourselves in trouble in that way.
Yeah. Just a thought as Tim and Dave were talking, another area sort of, I think, tricky waters, especially with, there's a lot of businesses that are interacting with each other, and you may be representing businesses that have business relationships with each other. So in terms of defining both your representation agreement, but also being able to navigate issues around conflicts as lawyers, again, back to the sort of rules of professional responsibility. Those are important issues to think about as you're bringing new clients, as clients are coming to you. Not that you can't do it, but what happens when a conflict arises, and how do you resolve those conflicts? I remember Dave and I were talking earlier, when you take the professional responsibility tests before the bar exam, you know, your inclination is to say, no, you can't do this because it appears like there would be a conflict or something. And in some cases that's true. But oftentimes the rules allow for resolution of those conflicts through independent counsel and waivers of conflicts and things like that. But thinking about it, and you know, Vermont's a small place. There's a limited number of businesses, and many of them could be interacting with each other. So having the thoughtful conversation about how conflicts arise, when they arise, and what you do with them, I think is really important in terms of avoiding problems between your clients. Hey, I thought you were representing me on this, and this guy's doing this, or this person's doing that, and you know, and those are hard and difficult and uncomfortable conversations to have. So thinking about them on the front end, I think, is a really important thing to do.
And David, does that connect with your government relations work?
Yeah.
I mean, if you want to talk about, because that, I don't know how many law students are sort of aware of that distinction, but yeah.
Yeah, a lot of my work happens in the legislature, working on a variety of laws, not just cannabis laws, but a variety of legislative proposals and laws. And also my cannabis work happens on the sort of regulatory level too. And yeah, I actually navigate those waters by having very few number of clients, which makes it easier for me. I don't know how Tim does it, but those are important, and those conflicts can arise in a legislative and regulatory process. So, you know, a lot of what we do is interpreting what the Cannabis Control Board puts out for guidance and regulations, helping to shape those and have those conversations through public interaction. But there could be proposed rules in which, you know, it's really good and advantageous for one of your clients and really bad for another. And figuring out how to resolve those conflicts in both the sort of legislative process and regulatory process is the same as if you're having conflicts of two parties in which they're in litigation with each other. So there are ways to do it. I do it mostly by very clear transparency about these issues and with clients, and again, scope of representation, and also just as things arise, making sure that we're keeping clients aware of the potential for conflicts and resolving them appropriately if they do come up. But the way I manage it mostly is having very few clients. So
We've had to, you know, we adopted, and this is a great one, Andrew and I, my law partner, when we first started this, foresaw that issue. And we've incorporated into our engagement letter, we will not initiate litigation against another Vermont cannabis company. We have just worked with so many at this point that there's no possible way we could do that. We offer mediation, you know, we'll work with ADR, any type of trying to sit down and work things out. But all of our clients up front know that should there be a conflict which cannot be resolved, you know, informally, that we are unable to represent either party in litigation, which kills me because I love litigation. But it really was kind of our bulwark, our you know, cornerstone of conflict avoidance. And we do, you know, we do a lot of transparency. We'll often draft contracts between two of our clients, and we tell them, you know, we've had to take a policy. We cannot advise either of you whether this is a good provision or a bad provision. We're scriveners. You come up with an agreement. We will draft that agreement as the two of you have, you know, put it toward us. We recommend that you both have this reviewed by another attorney, but we cannot tell either one of you, this is a good deal, this is a bad deal, this is a good provision, this is a bad provision. You know, and we've had to use a lot of transparency. We've had to, you know, and to date, it works pretty well so far. People get it, especially in the beginning when there was just simply nobody else offering these services. But conflicts are incredibly challenging, especially when it comes down to, you know, two of your clients are applying for a retail license. Thank God we don't have a limited license system. There's some case law out there, but that would have been a nightmare. The fact that we have an open system, anybody who applies for a license, any qualified individual will be granted their license, that has helped a lot because people are not competing over the same license. But we've even had a few of our clients leave us because, well, you know, another client opened up a dispensary near them. And, you know, there's not much we can do about that. Everybody has a fair shot. We try to help everybody who comes in our door. But conflicts are definitely something that we are constantly aware of and keeping an eye out for.
Well, maybe not entirely connected to conflicts, but it did make me think of another question that I have written down, which is, so Tim and Dave, you both have businesses separate from your law firms that are cannabis related. How do you manage the logistics and sort of the interests and some of the day-to-day stuff of those two different businesses that you are owners of?
Yeah, that is really tricky because, you know, so I'm on the phone with a grower client of mine, and he has questions about compliance with the regulations, and we're talking, and then he asks me, oh, and by the way, I have, you know, 5 pounds of do-si-do, and, you know, do you want it? It's $1,500 a pound, and I want to say, fuck yeah, $1,500 a pound, that's a deal.
but I can't because, I'm representing him. This is a phone call that, we're having that I'm billing him. So it's very important as I'm talking with my clients with whom I may also then have a business relationship with to make sure that there's a clear line and, say, okay, fine, you want to talk about that, we got to stop, right? Just pause for a second, recognize that the attorney-client relationship has ended, and now we are talking as, potential rival businesses, and that's very tricky. I personally have tried to solve that problem primarily by having my clients call my business partner to talk about, store stuff, and call me when they want to talk about their business, as opposed to mine. So that's kind of the cleanest way to do it, but it doesn't always work out. So you do need to be very clear when you're in a position like me and Tim, when you're talking to a client, what hat you're wearing so that they are not, accidentally giving you some proprietary market information that you should only be using for their benefit, because you can't take, as a lawyer, information that your client gives you and use it for your own benefit, even if it's not to the detriment of the client. Right? You can't use it for your own benefit. It's not your information. So tricky, very tricky.
That's exactly right, and we've done the same thing with Ojo Rojo. We're a little bit different, because we're service-oriented, whether it's VCS, Vermont Cannabis Solutions, offering legal services, Ojo Rojo offering packaging and distribution services. We're both service businesses, but we have a clear distinction, and I have had to cut myself out from day to day on our wholesale distribution and packaging company for that exact reason, so that people know they're talking to their lawyer. And when they start asking questions about, oh, well, can you do some distribution or some packaging? Well, you know what, why don't you give Christina a call on that? She's got a separate office, we got separate, but it's a completely and totally separate company. And that really is a necessity. And we've even worked, on the VCS side, we've gotten other wholesalers licensed. I would never turn somebody away because I happen to have an interest in another wholesale company. This is what we do. We are here to help anyone and everyone who comes through our door. Sometimes you grit your teeth a little bit, but that's the reality. We can't share information. We can't share emails. We can't share phone numbers. We can't share contacts. There is that separation that maintains. This is the law firm. This is confidential information. This is where you come when you need an attorney. If you're looking for those other services, you can give our COO, Christina, a call. She can help you with that. She has the prices. She has the information that you'll need for that. And again, in the 4 months we've been running both, it's been effective so far. But you're absolutely right. And you need to make sure that your client knows who they're talking to and what hat you're wearing. It's a great way to put it.
So on a different topic now, the question that I had that I'm curious about is, since it's a relatively new industry, relatively new practice area, how much do you find that your work is educating people, whether it's clients or legislators, or sort of getting people up to speed about what the law is, what the dynamics are, what the gray areas are? Like, how much of it is it just teaching people?
100%. Yeah, I mean, it's really, there's a lot of complexity here. I'll just speak from a sort of a government relations side. The intersection between what's happening from a business, how a business is operating in this market versus how legislators are viewing the market, it's a difficult thing. And translating to legislators who have their own interests. Yes, they have an interest in this as a policy from a criminal justice perspective, from an equity perspective, from a racial justice perspective, all of those things. There's a reason, from a consumer protection perspective, they have reasons why they took the step to, Vermont was the first state to legalize cannabis through its legislature. And so they have their perspective. Translating business owners, cannabis business owners' perspective into this policy debate can be very hard, and it requires a lot of education. So it's pretty fascinating to see sort of what's the cliche, that to be flying the plane as it's being built, and that's kind of what we're doing with this. This entire industry is statutorily created and regulatorily created. So all the rules and the laws come out of that process. And there's a lot of discussion that has to happen about, okay, you may be interested from a political and policy perspective in passing this provision, but what does that mean practically on the ground for businesses? For instance, there was a policy decision to have a cap on the percentage of THC in solid concentrates at 60%. And there's a lot of, some people say that's important, that we don't have, high THC products in the market and all of those things. To translate the difficulty and the complexity from a business perspective on how to comply with that is hard. And then the question is, do legislators even care? I mean, there's a real thought. I mean, I don't think the legislature is there just to prop up cannabis businesses and the cannabis industry. But there is something too, if you're going to create this system, to allow it to function well. So I think education and having real honest conversations about the policies that are being created are essential. And this industry, it's interesting, every year in the legislature there's sort of technical correction bill for agriculture, there's a technical corrections bill for alcohol, there's a insurance bill, there's all these bills, and we're going to see that in cannabis every year. We just saw one passed out of committee yesterday, H270, which is a House bill, which is doing sort of technical corrections. So this is going to be an evolving process, and having business owners and their representatives having those honest and open discussions, educating legislators about the impact of the laws that they pass on the businesses, on the industry, and on consumers. And that's just another, as we go through this, just one, the consumer voice in all of this is an interesting issue. I don't know, businesses would say they also represent consumers because it's their customers, but having the consumer voice in the policy argument and the consumer voice in this business discussion, I think, is something which will emerge, and it's an important voice to have at the table.
That's great, thank you. I'm trying to formulate a question because I'm interested about the aspects of, because I think it's important for students to hear about what the day-to-day is like in terms of what your practice is. So maybe we'll start with that, and maybe I'll come up with a follow-up. Like, what's your day-to-day work look like?
You want me to take it? I often find myself a zoning attorney, which is interesting because there's 251 towns in Vermont. Like, I don't know how many of them have zoning law, like zoning bylaws, like 150 of them, and most of them are kind of similar, but there are important differences. And so one of the first things I do when a new client comes to me is look at what their zoning situation is and ask them, where do you live? What zone are you in your town? Let's look up your bylaws. Let's see how we can make this work for you. Because so I'll give you an example. I had a client recently come to me. He wanted to do an indoor and outdoor grow. But he wanted his outdoor grow to be in like a hoop house, so no lights. But like a roll-up window, just to extend the growing season a little bit. And he lives in the town of Sunderland. And so I went to the Sunderland website, I pulled up the zoning bylaws, and I started looking at like, okay, where can we squeeze this in? So I find out what zone he's in, and I see he's in the most restrictive zone, their rural residential zone, where you can do very little, but you can do what's called a home occupation. And home occupation, okay, that might fit. So we look at the definition of home occupation and we see in Sunderland, you're allowed to use a minor portion of the dwelling. Oops. That means he can grow inside his house, but not in his yard, because that's not in the dwelling. And I see that kind of language, and about a quarter of the towns that I've looked at have that kind of language. Others, talk about anywhere on the property. So, a dwelling or an accessory building. But if it says a dwelling or accessory building, what if you're just putting plants in the ground? Is that development at all? So you have to look at the agriculture definition. Now, the state has said that, that for zoning purposes, as a default, growing cannabis is not agriculture. But some town zoning rules define agriculture differently, independently of state law. And they say that, growing any crop is agriculture and exempt, so yay. So it's very specific to the town they're in. And, you know, I never envisioned myself doing zoning work, but here I am. So I guess I'm a zoning lawyer. I mentioned Division of Environmental Conservation. That's another one that we have to deal with every once in a while. Fire safety, which is not really so much law as it is trying to stay on good relations with your local inspector and make sure that they, you know, are not being too much of a hard ass. So there's a lot of like massaging egos. There's, you know, just dealing with a lot of different government agencies. You want to deal with your town in a respectful yet forceful manner. I find not forceful like, you know, going around like threatening people, just letting them know that you know what the law says. Because often the local zoning board, the development review board, zoning review board, doesn't know what the law is. And there are a bunch of volunteers, you know, doing this on a part-time basis. So it's important to stand up for your client and be strong in that way. So the short answer to that, and to wrap this all up, is that really we touch everything. If you envision yourself as a corporate lawyer in the cannabis space, you're going to be doing a lot of sort of non-traditional corporate work.
I come in the morning, first thing I do is look at the CCB website, see if anything's changed, see if they posted any new guidance that, you know, expands their definition of the rules. That's a big thing. Day to day is being informed of the regulations and any potential changes. David had mentioned that, you know, the legislature does make tweaks. The rules were written, and then there were amendments to the rules that were promulgated. Guidance is issued that kind of tweaks or defines the rules maybe slightly differently than common sense would think. So staying abreast of what is the current regulations, what is currently acceptable and not. At home occupation, I kind of smiled at that. That's been our window into a lot of zoning. Sometimes we'll even break it down to home occupation and home business and home industry. They have different levels of what you can do. You know, and that's with licensing. Coordinating between state agencies. This is specifically in Vermont was one thing I don't think they ever, when they were creating this framework for legalization, nobody really consulted with any of the other state agencies. So the Department of Health, for example, was never included and has completely and totally zeroed out any involvement with cannabis. They won't inspect cannabis edible kitchens. They won't certify them. You cannot get a Department of Health certification in a kitchen where THC products are created. You have the Department of Public Safety and the fire department and the fire marshal, the distinction between public and private buildings for inspections, and trying to coordinate all of this with a lot of people who don't know the laws. I guarantee you, the head of the, Landon Wheeler, the head of our fire marshal, did not know the cannabis laws when we began this process. Most zoning officials, as Dave mentioned, did not, and some of them still do not know. There were towns that passed laws about where you could put a cannabis business that were in direct contradiction to Vermont state law, where we had to kind of very gently let them know that what they are doing you can't do. And that, you know, coordination between state agencies working to try to get an application through as far as the application process, that's a full-time job in and of itself. Then we get down to trying to introduce the concept of contracts to people who have always done handshake businesses, working on, you know, investment agreements, why you just can't go around asking anybody for money for your business, CC reporting requirements. You know, there's so many different aspects. There's so much different regulation, and so many people, especially here in Vermont, you know, what's so great about our industry is how mom and pop it is, how small business oriented, how, I mean, David helped write this law, and it was crafted to support the small guy over the big guy. Well, the problem with that is the small guy doesn't realize everything that is encompassed in starting a business. So getting people up to speed, educating on business matters, educating on regulations, that's a huge part of it. Trying to, you know, get people from the unregulated to the regulated market, that's a huge part of it. A lot of it is client control. A lot of it is working with your clients to get them to understand, and maybe not understand, but accept regulation and why they need to follow this regulation and why this regulation is there. Working with them on 280E mitigation strategies, especially for retailers, a huge component of this. You know, they're upset they got to pay taxes. When they find out they can't take standard business deductions, the ones who know what business deductions are, that's a whole nother ball game and conversation. So it really, it's so much fun, but you never know what it is. Every morning you come in and it's going to be something different. Whether it's putting out a fire, whether it's getting through a hostile zoning board, whether it's getting CCB to acknowledge that this regulation isn't exactly what they say it is. It's never a dull moment.
So 280E being part of the IRS federal tax code.
Yeah, I think our last speaker spoke a little bit about it. It was a tax code that says plant-touching businesses can't take standard business deductions. He neglected to mention the origins of 280E, which is actually a pretty funny story. Back in 1979, there was a cocaine trafficker in Florida who was nailed for Al Capone laws, violating the tax code, tax evasion. And he was penalized somewhere in the neighborhood of $2.8 million in penalties and unpaid taxes. He turned around and made the argument to the tax court that, well, if you're going to make me pay taxes on my illegal income, I can deduct my speedboat and my henchmen and my firearms and all the expenses in my drug smuggling operation. And the tax court was like, yeah, you kind of can. To which Congress immediately went the next session and passed 280E, prohibiting any involvement with any trafficker of a Schedule 1 or 2 controlled substance from taking standard business deductions. The law sat there with dust collecting on it right up until the late 90s. And the IRS brushed it off for the very first instances of medical cannabis dispensaries in California. And it's been a cash cow for them ever since. It's horrible. It's the only industry subject to it. It is, in my mind, discriminatory and should be abolished, but yet it tools right along. And there have been a lot of companies who have gotten bit very hard by it.
The upshot of 280E is that if you're planning especially in a retail business where the deductions are most impacted, you should really factor about a 50-55% federal tax rate on your true net income instead of the 21% corporate tax rate.
And that's with a good mitigation strategy.
Yeah, that's you got to really track everything.
What we'll do, one of our strategies, just so you guys know, a good practice tip is to split a store into a CBD and hemp half, and then a adult use half, or a glass shop and then a dispensary, because then the owner can at least deduct half the mortgage or half the utilities to time spent.
If the CBD side is independently a profitable business.
100%. Different books, different payroll, different everything.
But it has to be a profitable standalone business. So if you've got, 5% of your sales in the combined business is CBD. You
can't sell one t-shirt
95% is THC. The IRS is not going to let you disaggregate that. So you really do have to be truly an independently profitable business on the non-THC side. So that's a very tricky one to pull off.
It works best if you have existing business beforehand.
Yeah, absolutely.
So 1Ls and 2Ls in the audience, take note, tax law can be really exciting, actually.
Yeah, that's a new one for me, too.
But David, we want to hear your day-to-day before we move on to questions.
Yeah, I think Dave and Tim mentioned a lot of things. I think it's really about helping clients to understand and to manage expectations and to understand that the government, from my perspective, that the government, legislators, the CCB, other policymakers, their central concern isn't the success of your business. They are there to implement this law as the legislature has put forward and as the Cannabis Control Board has promulgated regulations. The board has, I think, done a great job and has committed to having successful industry. But when clients, and I should say also informing clients and helping them understand the mentality and the stressors on legislators and the Cannabis Control Board. And while there could be frustration, and also what's in their control and what's not in their control. For instance, we have clients who, banking is a huge issue. Right now in Vermont, banking for many folks, especially those without deep pockets, is really cost prohibitive. We've talked to banks where it's the fee on just a depository account alone can be $1,000 a month, a fee. $1,500. Some people say it's a percentage, 1%, 2% of your deposits. But just the idea that just to have an account, and to get a license, you need an account. But just to have an account, you have to pay $12,000 a year just to And our law says that you can't pay your taxes in cash. And yet, because of issues, because of federal illegality, many folks, dispensaries and other places, they have to take cash because they can't process credit cards. People have tried to figure out ways around that in terms of sort of reverse ATMs, those go down. I mean, there's sort of a joke, I don't know if it's relevant now, but if you're a longtime cannabis business, if you haven't been kicked out of like 2 or 3 banks in the course of your business, then you're not like a real business. But it's really, it's a real frustration. Insurance, getting and accessing insurance is a huge, very cost prohibitive, and especially when you get product liability insurance, that can be very expensive. And so everything is more expensive and more frustrating and more difficult in the cannabis industry. And I think having real and honest conversations with clients about this, even before they go into it, I think is essential for managing their expectations. I think the previous speaker said, like, the cannabis industry is not profitable. And for many people, that is true. It's going to take a while to get to a place where, because you have a 50 or 60% tax burden, because you're paying $1,000 a month on your bank account, because you're paying 2 or 3 times what you would otherwise would for insurance, getting to profitability, I think, in the long term is a process. And so a lot of my day-to-day is sort of managing expectations, helping to figure out how we get through these problems, and just having honest conversations with clients about what they're facing. I hate to be so doom and gloom. It's also, as Tim and Dave said, a fun thing, because we're creating it. And also in Vermont, we get an opportunity to change it. And that's the exciting thing. Every year, we get an opportunity to make tweaks to the law. We get an opportunity to have rulemaking that changes and to have input. And the businesses and our clients can have real impact on all of these. So
we're all patiently waiting for 280E to get repealed.
And the safe bank, that's the other thing. And like around banking, I mean, we're very close last year to passing legislation. The Safe Banking Act is a bipartisan, it's like one of the only bipartisan pieces of legislation in the entire Congress. It passed the House 5 times. The Senate had bipartisan support for safe banking. Would have made a massive difference for especially small operators, but all operators on all levels, and yet just didn't happen for a variety of political reasons last year in Washington. So.
Well, thank you. I think we don't have too much time for questions, but if we have 1 or 2 from the audience, sorry, I lost track of time. So enjoying the conversation. Oh, yeah, in the back there.
First of all, thank you all for hosting this panel. Very informative. You know, obviously Vermont being the first state to legalize recreational cannabis through the legislature, it's a big deal. But you mentioned, and I completely agree, that we are still building the plane as we fly it, which is kind of contradictory. I mean, you know, the government set themselves up theoretically enough time to build a market that should work. So, you know, looking back, every other state that has done it through ballot initiative, you know, I don't know, it's a big question, but like, what went wrong? What is the right way to do it? Is it through ballot initiative, or is it through the legislature? And what would have changed? Is there more resources? Is there more time? You know, it's because it doesn't really add up.
Pluses and minuses. You know, I'll take it real quick, and then with David. You know, there's pluses and minuses to the ballot initiatives. There's pluses and minuses to the legislative passage. Ballot initiatives are often written by special interest groups who can afford to get enough signatures to place a ballot initiative on. What you see is generally a lot of the ballot initiatives, while claiming to be grassroots, are generally funded by people who are not grassroots. I don't want to say, you know, corporations or MSOs, but moneyed interests in a lot of cases. They're also often not written by legislators. So that can create problems in and of itself. Legislatively, you have compromise. Legislatively enacted, you have, you know, prohibitionists at the table with legalization advocates.
and you hash out a compromise. And by its very definition, compromise means accepting things you might not want to accept, like a 60% cap on concentrates. That made absolutely no sense whatsoever. But this is what you need to do in order to get to yes. So, you know, I think in some ways, and I think technically we were the second. I think Illinois was the first to do it legislatively, Vermont being the second. But, you know, ultimately, what we've seen with some ballot initiatives is the legislature then steps in and tries to screw the whole thing up because they don't like power being taken from them. So that can create political issues in and of itself as well. I think legislatively is the way to do it. I just think legislators need to be educated and informed properly and not with propaganda and fear tactics, which unfortunately when a law enforcement officer shows up to testify in full combat gear, you know, talking about how marijuana is as dangerous as heroin, that does not help the process.
Just a quick chime in on that. So just to clarify the comment I made about Vermont passing it first legislatively, we did pass it first through the legislature, but we passed home grow and legal possession.
Yep,
so
right.
Illinois was the first to pass it through a tax and regulate. I'm actually really proud that we did that because some states had, and through their ballot initiatives didn't even allow home grow. So the nice thing about what we did is that we've created this industry, but we've also created an opportunity for Vermonters to remove themselves from all of this. If they want to stick a pot in their backyard and plant a plant that grows without even doing anything, they can do that legally, which I think is great. But to the point around ballot initiative versus, I think ballot initiatives are the path, in some ways, the path of least resistance, although we just saw Oklahoma's ballot initiative fail miserably. But I agree with Tim. I think there's a lot of flexibility in having it through our legislature. We always have an opportunity to come back and revisit. With ballot initiatives, some of those things are locked in, and that makes it a lot harder. California's market has been, I don't know, sadly, I think a bit of a disaster and is crumbling. I think you're seeing many California businesses going out of business, and they try through the legislature to reform things, but I think ballot initiatives lock people in, even though it's easier in part to get it through. But we're seeing legislatures all over the country. I think Delaware is likely, I think, to go through the legislative process this year. I think Hawaii, yep. So we're up to 21 states, and with I think 37 or 38 with medical, and the Kentucky legislature passed a bill, the Senate passed a bill for medical just a couple of days ago. So I think the legislative route is going to become more and more, accepted. But
yeah, I think also worth noting, Vermont doesn't have ballot initiatives, so like we had no such choice.
We have constitutional amendment process, which we just saw two pass in our last election, which are very difficult. It's about a 4-year process to change our constitution, and we did successfully pass 2 constitutional amendments this past election, but again, it's very difficult, and it goes through the legislature to even get on the ballot. So
Ballot initiatives served a good purpose in the very beginning of legalization because legislatures wouldn't touch this. You know, drug policy was the third rail. You talked about legalizing pot. You were a joke. You know, you weren't going to get reelected. Your opponents were all over you about it. So I think that ballot initiatives did serve their purpose in the beginning to get the ball rolling. At this point in time, it is no longer the third rail. We have massive popular acceptance of this. You know, and I do agree that as we see more and more states legalize, I think it will be through the legislative process. Legislators aren't scared anymore of not doing this, but I think they are scared of ballot initiatives, which again take the power away from them. So I think that has shifted, and I think we'll see legislative enactment from this point on.
And anything you like about Vermont's cannabis law, you can thank David and myself. And anything you don't like, you can blame Phil Scott.
Well, on that note, I think we do need a little bit of a break before the next speech. But thank you so much to Tim, Dave, and David. Yes.
Thank you all.
And please stick around. Or take a break, but then come back. pleasure. Yeah, I wish we could talk more. But
Okay, we're going to take a quick 5-minute break, and then our next lecturer will be joining us online.
Sorry, everybody, for the minor technical difficulties that we had there. I'm happy to introduce you all to Lisa Brunner. She's the chair of the Medicinal Cannabis Control Commission for the White Earth Band of Ojibwe, and she's going to talk to us a little bit about tribal regulations, what that looks like, the medicinal cannabis space, and just things on indigenous lands. So without further ado, Lisa Brunner.
Bonjour. Miigwech, Clara, here before the invitation, and Samantha, and to Brian for helping with IT issues. So I just want to extend a warm handshake to everybody there. And I'll introduce myself in my cultural way. Minugi Shigan. It's a good day. Maingan Ludam. I'm Wolf Clan. Gao Babi Gao. I am from the White Earth Ojibwe Nation. Wasi Wagakwe Indigenous Cuts. I am a woman. So I was asked to present on how the impacts on tribal nations when it comes to cannabis and the law. So if you could go to the next slide, please. I just want to briefly capture that the session provides the opportunity to understand the complexities of federal Indian law and the impact that it has on our tribal communities, our health, and our well-being. Also, what the implications of the laws are on tribal nations and the cannabis industry, and to also engage in conversations regarding the necessity for required federal Indian law courses taught at law and graduate schools in the United States. Next slide, please. So I'm going to just briefly cover some of the basics, because federal Indian law takes a long time to understand. There are treaties with the United States. There's actually 500. There are currently 574 tribal nations in the country. And so I just wanted to just briefly capture a little of the cornerstone to have an understanding of what federal Indian law is, how it came to be, and its impacts on us today. So in the United States Constitution, they have what's called the Supremacy Clause. And basically, when it comes to the treaties that the United States signed with our tribal nations, according to their own Supremacy Clause, treaties made, or which shall be under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound to it. Well, there's a second aspect to this, where it says, since the very text of the Constitution conclusively demonstrates that the people of the United States did not include Indian tribes or their citizens, the document had no power whatsoever to limit tribal authority or to assure federal supremacy over tribal authority. So what we deal with in tribal nations is this constant duality of what the United States was trying to do and how they overstepped their authorities, or how treaties were made and what was the intent of those treaties. But then when you look at the crux and the actual meat of, like, the United States Constitutions, we're not even in it. Actually, the only message, only in the Declaration of the United States, we're actually referred to as merciless Indian savages. We're not even considered humans. So then if you look from the 1778 to the 1800s, the United States entered into more than 500 treaties with tribes. And all of these treaties have been violated in some way or just outright broken by the United States government, in which we're still exercising and still fighting for our treaty rights today when it comes to the protection of our people, when it comes to our environmental protections of the land, the water, the animals, the trees, the plants. And I just want to note that we as tribal nations, our tribal nations, have acted with integrity, and the United States has not. We have not violated our treaties. We've only been trying to protect them and to exercise them. And so the United States does not go into treaties with other sovereign nations right? Unless they're actually sovereign nations. Next slide, please. Okay. So with treaty rights, so treaties formalize the nation-to-nation relationship with the United States. So it's a government-to-government relationship, and it's between the federal government and the tribes. And a common misconception is that the United States via treaties granted special rights to Indian tribes. We didn't. Those treaties were negotiations of land base. And like with the land base, it was Indian House Services, it was supposed to be education and all these particular pieces. Those weren't given to us. Those were in concessions to the millions upon millions of acres that were negotiated with treaties, all of which that put our tribes on Indian reservations that we still reside on today. And so, and a lot of people have a lot of misconceptions that we have free college education. We don't. I currently pay for my graduate program. I wrote for scholarships and those types of things, just as you all are writing for scholarships or are finding a way and paying out of pocket. So there's a lot of misconceptions around what our treaties did. Indian Health Services were a part of that negotiation. We do not have the best health care. We're often met with racism, and by the time our relatives are being diagnosed with cancer, for example, they're already stage 4. So they're going from a diagnosis to hospice, and then they're dead within weeks. Because when our people go in and they're complaining about bodies, something occurring, we're just going through this garage, right? Just get them in, get them out, get them in, get them out. And not all the time do we get the best health care. Treaties detailed what lands would be relinquished, how much the tribe would be compensated, and specifies the treaty area of remaining Indian land. There's a whole history of allotment acts and all of these different types of things where the United States and the state said, oh, wait, they didn't pay taxes on it, so now we're going to take it. Oh, they have excess land, we're going to take it. And so our tribal nations of what we negotiated in our treaties have been encroached upon. And quite honestly, 80% of the world's diversity, of the lands in the world resides within indigenous people's lands. And so we're really fighting hard to protect our waterways and those types of things from those continuation of those encroachments. Next slide, please. So trust responsibility. So in the treaties, when tribes relinquish those certain rights in exchange for promises from the federal government, trust responsibility is the government's obligation. It's a legal obligation to honor the trust inherent to those promises, which then, as I was stating, include healthcare, which is the basis for federal funding. That includes educational programs. Now, that means we have Bureau of Indian Affairs schools, not an awful lot of them, and again, not the best. The United States Constitution recognizes Indian tribes as distinct governments. It also authorized Congress to regulate commerce with foreign nations among several states and with Indian tribes. Next slide, please. So during this, there's an awful lot of federal laws and acts and Supreme Court rulings that have occurred. So there's an awful lot, and I'm only just skimming just the key pieces as it pertains to the tribes exercising its sovereign authority, especially in the cannabis industry. So the Right to Self-Determination and Education Act was in 1975, and what it basically is the right to freely determine their political status in regards to our tribes and to freely pursue their economic, social, and cultural development. The act also allowed for tribes to have greater autonomy and to have the opportunity to assume the responsibility for programs and services administered to them on behalf of the Secretary of Interior through contractual agreements. Those are called Contract 638s. But I won't talk about any of those at this moment. But I just want to set the tone that our tribes have the right to self-determination and the right to self-governance. Next slide, please. So this here is just a screenshot of White Earth Reservation. This is where my land, I'm actually here in Mahnomen. And our land was much bigger than this. And currently, even though what's currently present, because they encroached, you see the Tamarack Wildlife Refuge and things like that, the state come in and basically plowed down our relatives' homes in that area, forced our relatives out of there, and turned it into a national wildlife refuge. And so this is 1,300 square miles. And because of the Allotment Act era, our tribes own less than 7%. Our tribe does currently. So the impact then, when we look at all of the 574 tribal nations and Alaska Native villages in the United States, there's a jurisdictional maze of understanding tribal law, federal law, and state law. And then it comes down to civil jurisdiction. So tribes have civil jurisdiction over non-natives on tribal lands, just as they do natives. And then under criminal jurisdiction, we do not have criminal jurisdiction over non-natives, but we do over natives. And there's all kinds of laws that included encompassing natives because they were trying to say that tribes only had criminal jurisdiction over its own members. So granted, the Violence Against Women Act, and that's a lot of the work that I've done in the past on public policy, was addressing the criminal jurisdiction aspect because we as Native people are victims of crimes 2.5 times higher than any other population in the country. 88% of those perpetrators are non-natives. And Native women are victims of sexual assault. We are more than, we're 1 in 3 to be victims of sexual assault. And that's not included in Indian country, that's off reservation. And 67% of perpetrators of sexual violence against Native women are not Native. So then of all of the tribes in the country, the 574, they're split up. And so you have 300 and plus tribes are what's called under Public Law 280. The state of Minnesota is a Public Law 280 state. California, Wisconsin, Alaska, Nebraska, and Oregon. And then that was done without the tribe's consent because it was during the termination era where the United States was trying to get rid of tribal nations. So 300 and some, this was a like melting pot of America moment. Nobody should or would want to be in the melting pot of America because we are diverse as peoples in the country. Collectively, we have beautiful diversities, we have beautiful cultures, beautiful languages, beautiful everything. So that should be celebrated versus wanting people in this melting pot because that's what's called assimilation. And then the other 200 plus are in non-public law 280, which is strictly under federal jurisdiction. So like in the instances of criminal investigations or criminal responses to criminal offenses committed against our people by non-Native people, majority of those criminal offenses, especially sexual assault, like of Indian children by non-Native offenders, the federal courts have declined up to 72% of those cases. So what happens then in these instances, it creates the perfect predatory hunting ground, our tribal lands do, and it sends 2 messages. One, to victims, don't bother reporting because we're not going to do anything. And then to the perpetrators who are the serial rapists and serial abusers and serial traffickers and killers and gangs and everything else, is go ahead and rape with impunity because we're not going to touch you. So in essence, in federal Indian law, when it comes to criminal jurisdiction, the United States essentially created kind of like diplomatic immunity for non-natives. And that alone is just, I mean, a whole course can be taught just on this. So I know this is really a fast introduction, but it's so complex. So I just wanted to kind of lay out that particular framework. Next slide, please. So then it comes to the impact of safety. So also in 2010, President Obama at the time signed in what's called the Tribal Law and Order Act. And the Tribal Law and Order Act was allowing the tribes in public law 280 states to do a reassumption of concurrent jurisdiction back to the federal government to be under their criminal jurisdiction. Our tribe was the first tribe in the country to do so. And so that creates another layer of complexity as to who's responding to what on a federal basis, state and tribal. Because remember now, a lot of tribes, even though the Violence Against Women Act passed in 2022, that basically created a bigger Oliphant fix, if you will, because in 1975, white tribes lost their criminal jurisdictions over non-natives. Was a court case called Oliphant. And so we worked to get like a mini Oliphant fix. But the problem is a lot of tribal courts don't have the infrastructure or the resources to be able to build that infrastructure to respond to criminal offenses in Indian country. And this is significant when we think about cannabis and gangs and all of these particular pieces. So the Tribal Law and Order Commission, these were some of their findings. Due to these legal restrictions imposed by the United States federal government on Indian nations, criminal jurisdiction on Indian lands is divided among the federal, tribal, and state governments. Which government has jurisdiction depends on the location of the crime, the type and severity of the crime, and the Indian status of the perpetrator and the Indian status of the victim. In no other jurisdiction within the United States does a government lack the legal authority to prosecute violent criminal offenses illegal under its law. So when we talk about homeland security in the United States, it's not really necessarily so, because they're not responding. And there's nothing in federal law that states they can respond. Federal law states what we can respond to and what they'll respond to, but it doesn't state they have to. And they don't. Next slide, please. So then the health impacts. The American Indian and Alaska Native people have long experienced lower health status when compared with other Americans. We have the lower life expectancy, and the disproportionate disease burden exists perhaps because of the inadequate education, disproportionate poverty, discrimination in the delivery of health services, and cultural differences. These are broad quality of life issues rooted in economic adversity and poor social conditions. Now keep that in mind now as we talk about cannabis and the health impact that it has on anybody in the country and the world, but then the economic adversity, but also the diversity that our tribes could be making to support the response to some of these issues, right? And so, again, when you think of trauma and you're victims of violence consistently, and there's no response to that, that contributes to mental health, behavior health, and all of these other aspects. These social determinants that stem from that, unfortunately. Next slide, please. So the economic impact. The cannabis industry presents a bountiful economic opportunity to Native American nations and their members, but who, by and large, have not benefited from the broader U.S. economic recovery, which has led to historic low unemployment. So when we think about that cannabis industry, with Colorado, they're sitting in the billions. And those billions of dollars coming into that state is going to their education, it's going to their health, it's going to their roads, it's going to all of these other aspects that normally that state would not have. But how that works is that it's for the state. It doesn't include us. It does not include tribal nations, because even though we live in the state, we are members of the state, we are not treated in accordance as rest of the state. Even though we do pay taxes, because people say you don't pay taxes. Well, that was in the Constitution. They make us pay federal tax, but state tax is subject to whether you're enrolled and live on your tribal lands. But for many of us, we still pay taxes. We pay taxes on our gas, we pay taxes on our food. I just went and got my tax. I paid that to the state. I have state license. My home is not on tribal land. I pay taxes on that land. So we are contributing to the tax base of the state, but yet we are not recipients. So that's really important to understand here. So when we think about the economic opportunity then for tribes to be able to also provide medicinal cannabis and potentially the state of Minnesota maybe going recreational, to be able to have that economic boon on top of it will support the economics and the health of the tribe to be able to now contribute to, we have the highest homelessness, right? To contribute to the educational aspect, to contribute to these particular pieces that would, offset the health and the economic impacts that we face. So then it says in Western states that have already legalized marijuana, Native tribes that operate as sovereign nations have found the marijuana industry to be a path to the creation of new jobs, a generation of tax revenues, and redevelopment of communities that often suffered economic hardships. Because again, keep in mind, there's this misconception that we get all of these handouts from the government. We don't. First and foremost, they're not handouts. We paid for that. And what we have paid for is a very, very drop in a bucket, very empty drop in a bucket of inequities. Next slide, please. So some of the legal barriers now that come into the cannabis industry for tribal nations is, first and foremost, as states, we're moving forward to legalize medicinal cannabis, and like Colorado and California, different ones going to recreational. A Cole memorandum came out, and the Cole memorandum essentially deprioritized spending federal funds to prosecute state-approved medical cannabis programs. So keep in mind that sometimes when these legal determinations and things come out, that when we're not included, it's sometimes we're just an afterthought, or they don't recognize that we're sovereign and we're tribal nations here, or it's by intention. Okay, so with the Cole memorandum, they have 8 priority areas that they want to ensure states or those that are doing the medicinal cannabis adhere to. Prevent distribution to minors, right? But yet some states are open to providing medicinal cannabis for children that have cerebral palsy or having, that it can be beneficial for them in different capacities. Prevent the medicinal cannabis to going to gangs, cartels, and criminal industries. Drug driving, so that you're not driving while under the influence of medicinal cannabis. Diversion of cannabis from one state to another. So that can be problematic for us tribes, because we go over, we don't have, some of our land bases aren't necessarily state. So if you look at the 4 corners in like New Mexico, Arizona, or the other 2, that they share this common land base. So sometimes these state lines are imaginary when it comes to tribal lands. So this here will be a challenge, and I'll talk about this as we get further. It says the memos, which officials later rescinded, also open the discussion on tribal sovereignty as pertaining to cannabis legalization and the federal government's non-interference policies on Indian reservations. So essentially, the DOJ, the Department of Justice, told Native American tribes that they could. Okay, one, we don't need their approval to grow, because again, this comes to our sovereign authority. Because did the states get get Congress's or Department of Justice or the federal government's approval to grow? No. So, but the language is really important. And so, but anyway, stating that we could grow and sell marijuana on their lands as long as they follow the same federal conditions laid out for the states that have legalized the drug. So I can tell you within our cannabis code for our tribe, the 8 priority areas for the Cole memorandum are listed. So then it goes on to say, however, then a Wilkinson memo comes out, maintaining that the federal government had the authority to prosecute a tribe or tribal members criminally for cannabis. So again, we are treated very differently than the rest of the country, than the states. And there's really no difference other than ensuring that, if we're going to do this, we want to make sure that we are following the compliance to ensure that these 8 priorities are met. We want to make sure that our products are tested We want to make sure that our patients see their medical provider to ensure that there's no conflicting, interactions between the potential prescriptions they currently may be on, or whatever their health care may be. Or if someone's presenting with pain, we don't want to just give something to take care of the pain, like oxycodones, right? Oxycontins, or fentanyl that the pharmaceutical industry and doctors do prescribe, but instead making sure that, if something's you're having constant massive headaches, we should check that out. Making sure that they don't have a brain tumor, right? So we want to ensure the integrity of the cannabis itself, the regulations, but also, most importantly, the health of those that are seeking it. So then, all right. And then at the bottom, it says, nothing in the Cole Memorandum alters the authority or jurisdiction of the United States to enforce federal law in Indian country. So keep in mind that within the FBI, we do have an Indian country division. They don't necessarily respond to the horrific crimes that our people are facing. They actually made it clear to us that's not their priority. So it's like high collar or white collar crimes, those types of things. Next slide, please. So now we're going to get into the legal barriers within Minnesota State, or within the state of Minnesota. Sorry, my header's not right, and the Indian Health Services. And so this is currently in my capacity as the chairwoman of the White Earth Medicinal Cannabis Control Commission. Our role is to license a tribal medicinal program to grow and to cultivate and to make the edibles or all the outcomes of that value-added agriculture, because that's essentially what's happening. You're taking a plant and you're making it to other things like the oils and edibles, for example. Then that becomes a value-added agriculture. And so we are faced with complexities because the state of Minnesota legalized medicinal cannabis. They're currently in progress, and the governor has made a commitment that medicinal cannabis will be recreational in the state of Minnesota. All right. Well, then White Earth Ojibwe Nation, my tribe, legalized medicinal cannabis, via our medicinal cannabis code. And then from that code, we have our regulations, and within this code is what created our commission. And then we're the ones that regulate the growing facility. But the barrier is now Minnesota will not allow their state testing facilities to test our tribally grown cannabis for the analytes, which is heavy metals, pesticide residues, microbiological contaminants, solvents, cannabinoid profile, right? What is that THC content? And they have not agreed that they will not arrest. I mean, that that we don't want them to arrest us, because they will arrest us if we leave our tribal lands to try to transfer medicinal cannabis to a testing facility that's off reservation. So if our people are transporting medicinal cannabis to a testing facility, should we find one that would do it for us, the state of Minnesota and the state troopers and whatever county we may be in can arrest us for it. Not anybody else in the state, but us. They'll do that for us. They will arrest us. So currently, because there's two major testing facilities in the state of Minnesota, they are part of the state medicinal cannabis program. So they're not allowed to test our cannabis, because you see, the state wants to have a compact agreement. But typically what happens in these compact agreements is then there's an erosion of our tribal sovereignty, and they want our money. They're already asking about the taxes. So they're states, unfortunately, are quite greedy, and they want our money, even though this is a multi-million, billion-dollar industry for them, especially when they go recreational, like Colorado. But and granted, not all states are like this. Unfortunately, Minnesota at this moment, this is what we're faced with. And so it's about, encroaching on our tribal sovereignty. It's not respecting our tribal sovereignty. It's not being in good relationship with each other. And it's not about ensuring that our tribes that face the highest homelessness and poverty and everything else under the sun, that we too can have a piece of the pie, if you will, to sustain and grow our own economic development so that we don't have to be facing all of these consistent disparities from 500 years ago. So that that's the crux for us at this moment. So the thing is that, remember, we are members of the tribe, but we're also members of the state, because I have my Minnesota driver's license. I am a resident of Minnesota. I am a member of the state. I can vote in all of the state court, for the state elections. I can vote in the county sheriff, elections and county prosecutors. So I'm still a member of the state. But when it comes to our health needs being factored in, where are the health? When is our health being factored in compared to other non-native members in the state? We have non-native relatives that live here on our tribal lands, so this would also benefit them. They don't have to drive long distances to be able to have access to medicinal cannabis. So the other piece to this then is we have health, IHS, Indian Health Services, that are on our tribal lands, right? That's within our treaties. But they will not provide the recommendations for medicinal cannabis to our people because they are federal. So what do you do when you have a community that's highly impoverished? They don't have health insurance. Oftentimes they don't have transportation to be able to get to a physician for that initial consultation visit with them to go over your health and well-being, make sure that you're a candidate for medicinal cannabis, right? And you can't pay for it. I did the research for our area as to what clinics can provide that type of visit for medicinal cannabis. One is 2.5-hour round trip from us. The other one is a 4-hour round trip from us. So if you're already impoverished, you don't have transportation, then how do you gain access to this? Indian Health Services won't provide it, and no other clinic around us, no other clinic. Wait, there's only one clinic here on the reservation outside of Indian Health Services that will not provide it either. So then the accessibility of physicians that provide these recommendations are unattainable. So then again, this comes back then to our health needs and the disparities that we face. And now we're not allowed to even take care of our own people in this capacity. Next slide, please. So I bring up the Indian Game and Regulatory Act because, again, there was nothing in federal law that stated that our tribes, like all other states in the country, can do gaming. Oh, but lo and behold, should Indian tribes do this? And should Indian tribes actually create an economic base that can help grow their community, help mediate the poverty and the jobs and the health and wellness and education and all of these pieces so that we can be self-sustaining? No, we need to regulate them. So this was in 1988. The United States federal law establishes the jurisdictional framework that governs Indian gaming. There was no federal gaming structure before this act. So they're targeting tribal nations, but they were not targeting the states, which too are sovereign, right? With the federal government and states, just as we do. We're actually the ones with treaties. So under the findings, and I only took out of one out of 5 findings, and if you look up Indian gaming, it's quite huge. But basically, the Congress finds that Indian tribes have the exclusive right to regulate gaming activity on Indian lands. And if the gaming activity is not specifically prohibited by federal law and is in conducted with a state, within a state, which does not, as a matter of criminal law and public policy, prohibit such gaming activities. So now when we think about cannabis, there's a tribe, the Santee Flandreau tribe in South Dakota. South Dakota is not medicinal. It is not regulatory. It's not open either for recreational. They were trying to do their own cannabis to grow, their exercise their sovereignty, but also meet the health needs of the people, and then to create the revenue to sustain it. And so they were threatened by the feds that they actually had to go and destroy their own crops at the time, but now they've been maintaining and exercising that and are doing that within the state. So the reason I bring up this particular regulatory gaming is because what I'm concerned about and why we don't want to be in compact agreements with the state, because this is where regulatory language starts coming in. And then it becomes a federal regulatory, where it's not regulatory for anybody else in the country. And unfortunately, what happens then, so like here for my tribe, of course, we have gaming. We have a casino. But say my tribe wants to do racehorse betting. Well, we can't unless the state's doing racehorse betting. So, we can't have a leg up, and we can't move forward and be productive in other capacities unless the state has the capacity. And then for some tribes and some states, the states take a chunk of their money. Okay, we're already impoverished, so why is the state taking our money, but yet the state does not, through their gaming, provide any resources into our communities? Do you see the unfairness here? Do you see? It's like like how the little cartels were. They go into all of the businesses in the town and take their cut. Well, that's no different than what the states are doing here. And so this is what we want to be careful of. We want to protect and maintain the sovereignty and the integrity of that sovereignty of a tribe to actually take care of their people. And this is not our people, because that's not how we think. We take care of everybody that's here. And on White Earth here, we're in the state of Minnesota, there are 6, of the Minnesota Chippewa tribe, we are 6 tribes within that. We are the largest right now. I think we're at 16 or 18,000 members. But on our reservation, there's only 4,000, roughly around 4,000 of us that actually live here on our lands. Although the population on our reservation is 10,000, which means more than us. There are 6,000 versus the 4,000 that live on our land that are non-native, that would benefit from better roads, healthcare access, educational opportunities, right? Infrastructures, all of these particular pieces. Next slide, please. So when it comes to the law regarding Indian country and Alaska Native Village, there are some critical questions that need to be asked. Whose law? Tribal law, state law, federal law? Then the next question we should think about is the law applicable to Indian country and or Alaska Native villages? Are we considering Public Law 280? Are we considering non-Public Law 280? Or is it broad and applied to all? What does this look like? How will the law be implemented? New federal acts such as the Indian Game and Regulatory Act, when it does not exist for the states, does this include Public Law 280 and non-PL 280 is inclusive to all? And then the other question is impact and implications of current Supreme Court cases. I don't know how many, anybody familiar with Oklahoma versus Castro Huerta? Anybody familiar? Just raise your hand because I can see you. Okay, anybody familiar with federal Indian law? No. Some of you, okay. Is it by choice? Are you required to take federal Indian law courses there at Vermont Law? Yeah, that's the problem. Okay, we'll get to that. So when it comes to the law, we always have to, you as law students, always please know that there's three arms to that. There's three arms to that law because there's three sovereigns: federal, state, tribal. So real quick, those of you that may not know what Oklahoma versus Castro Huerta is about, is basically a non-native who victimized a native child. He claimed that the state didn't have jurisdiction because he was convicted to 35 years in prison with a chance for parole. And then he claimed that the state did not have jurisdiction because before that, a previous case was Oklahoma versus McGirt, which determined what Indian country was, and then that falls under federal jurisdiction. So then it goes to the feds. You want to know what the feds charged him with for egregiously harming a little Indian child, a 5-year-old? 7 years in prison, and then has to be deported because he's an illegal immigrant. All right. And anyways, then the courts determined, and whatever, because unfortunately in Supreme Court cases, they cherry pick whatever previous cases to justify that. So all I can ask, and I say this in a good way, if you don't have a good heart, if you're biased, if you're racist, if you're discriminating, if you're violent, right, and nobody knows about, then you're going to be a disservice if you have a law degree. Because being a lawyer, being a judge, being in the Supreme Court, being a law clerk, being whatever, you need to shelve that, because it should be about the law and it should be about the people. And you should be there in servitude and do things in a good way. And when laws are not good, then challenge it. Because we have an awful lot of laws that are not good. Whatever your religious views, they have no place. Right? Just like doctors are supposed to be. They should be responding, but of course we all don't get that, correct? We all know the institutional racism of our system, of our court system, of our legal system, of our law enforcement. Why be in a place of exercising law if you're going to hurt people? That's not what law was created for. We all have our natural laws, right? In the Bible, you have your laws, your 10 commandments. Every population, every peoples around the world have their natural laws, and they're essentially the same. Be respectful. Don't hurt anybody, right? So I say that in a good way because we need to stop hurting each other. These laws are supposed to be protecting. Next slide, please. So then my question is, and you already answered that. No, Vermont Law School does not require federal Indian law courses to obtain a degree. So then my next question is, how do law schools or colleges that provide law degrees not ensure federal Indian law is offered and required to ensure students are adequately educated on all matters of law in the country? Wouldn't you want to know? Shouldn't this be part of your coursework? Because you're going to go into some area of law in some state, and there are tribes in those states. And this is where, by not teaching federal Indian law, hurts us. Because then we have people that aren't trained in it, who challenge our sovereign authority, bring it to the Supreme Court, which are not friendly to us to begin with, and then harm us even more. As it stands, the United States passed this law on blood quantum. How many of you are familiar with blood quantum? Okay. So this was part of the Allotment Act era. This was part of trying to take our land and basically breed us out. Of the 500 and some tribes in the country, and this was research that was done on the Bureau of Indian Affairs allocation of those COVID dollars that rolled out. So we got a little chunk of that for all of the tribes. And they had this formula in which this funding is rolled out. And unfortunately, they rolled out the most to the tribes that had the most, not just members, but the most employees, whether they were native or non-native. So it was to benefit all, right? And we should be thinking in that capacity. So the top 20 countries that received the most, one was my tribe, because my tribe is the largest employer in the state of in northern Minnesota. We have like around 800 or so employees. And then the lowest 20 was also on there, and it was shown by their population base. I can tell you in this year or the next, we have tribes that are going extinct. Because in order for us to be enrolled in tribes, and this was placed upon us by the Bureau of Indian Affairs, which is under the United States government, we have to be 1/4 Indian. Okay, what part of me is 1/4? Is it my arm is 1/4? Do you guys have to determine how much blood you are of being Norse, being Celtic, being German, being English, being Welsh? Do you have to do that? No. We do. We have to prove who we are all the time. And so when we have our laws that are and our sovereignty is not protected, and you don't know anything about federal law, and you start challenging these things without that knowledge, and your schools are setting you up to be very ignorant and to not be educated adequately on all laws that matter in this country. You should know federal Indian law. There's a whole chapter on it. We have 500 and some tribes in the country. It impacts land, it impacts water, it impacts environment, it impacts safety, it impacts health and wellness, it impacts education. Okay? So then it leads to my next question. How do we ensure the safety, health, education, environmental laws, and treaties between the United States and tribal nations are upheld and protected under the law if students obtaining law degrees are not educated on it? So I challenge you in a good way. How can you, as students, advocate that federal Indian law is a required course for your degrees and grad schools and colleges in the United States? But start in Vermont. Ask these questions. Be curious. See what they tell you. Ask your president. Ask your provost. Ask your instructors. Ask the regents or whoever's on the board. I don't know what they're called in your state. For the University of Minnesota, their board is called the regents. Be curious and ask those questions, because you should know. Because it only hurts us that you don't. And it's not fair to you that you're graduating with a law degree that's not giving you the full peripheral view of all laws in this country. And the United States has a federal trust responsibility and a legal obligation to our nations. That's law. Do you even know what that means? Do you know where that lies, right? And how will that be achieved when federal Indian law is not a required course? And then my last question. Is federal Indian law asked on state bar exams? Nope. If not, you should be asking why. There are 574 tribes in the country, and states reside within their territories. So it kind of would be prudent to know that. So next slide, please. So when we think about justice, right, how do you exercise that in your pursuit of degrees? How do you exercise that in the roles wherever you may want to go in whatever field that may be, if you don't even know what it is in its totality? So there's an elder's teaching that says that in every deliberation, the seventh generation must be considered. This isn't about just laws. It's not just about you being law students. It's about how do we coexist and live as human beings with respect with each other, to honor each other. What is your vision for your children and your grandchildren down the road, or your nieces and nephew down the road? Personally, I just want to make sure mine have a chance to exist. Because our tribe worked, the MCT, the Minnesota Chippewa Tribes, contracted with Wilder Research Foundation in 2013, and they did a population projection report. What they found that in 2053 or 58, so in the lifetime of my grandchildren, I have 6 grandchildren that range from 9 to 6 months old, that in their lifetime, and if I'm still here, because 2053 is 30 years from, not even 30 years, about 30 years, right? I'm currently 50, so if I'm blessed to be able to live that long, it would be in my lifetime, but the lifetime of my grandchildren, that our population base is going to go from 18,000 to just 2,000. So my grandchildren, like the other children, or I won't even say children, because with all of the other tribes that are facing actual extinction to this day, will be facing that. These laws should be there to protect, but they don't. The laws that are there exclude us from safety. They exclude the protection of our waters, our land base. They protect offenders, non-native offenders in particularly, because non-natives, remember, we can't touch them. If you think about the murdered and missing Indigenous women, in 2016, keep in mind the National Crime Information Center did not tabulate or calculate, because they don't keep this data, but because of how the reporting goes, which is a whole other complicated jurisdictional mess. When they finally started looking, they found that in 2016, over 5,716, I want to say, Native women had been murdered or missing. Native women we as Native women face murder 10 times higher than the national average in the United States. Our men are killed by law enforcement far greater than Black men, which is atrocious when we see all of the filming of the murders of Black men by cops. But when we live in geographically isolated areas and there's nobody around with phones to capture it all, it's invisible. I want my children to be able to exist. I hope I have great grandchildren someday, and that they're able to exist. So really think about the complex, just the how opposite that is, because you can project your future and your children's future, but we can only hope to. So I leave that with you, and I know it's heavy, but you're going to be you're going to have law degrees. You're going to be attorneys. You're going to be somewhere. So make sure you do that in a good way. Make sure you learn about federal Indian law. If this college is not offering it to you, then please seek it. Because we need help too. We need to be protected, and these treaties are legal and binding. Help ensure that we're here in the next generation outside, right? So with that, I say Chimigwich, thank you for your time, and thank you for being present and for listening to me today. And I don't know if anybody has questions. Thank you. You might be on mute because I can't hear. Oh, still not hearing you. Oh, there you are. I don't know if anybody's asking questions, but I can't hear.
Hold on.
Okay.
Okay. Thank you so much for being here, everybody who is here today in person. If you guys have any questions about like federal Indian, oh my gosh, I'm blanking out on the class, federal Indian law, please reach out to NALSA about resources that are at VLS. And if you have any questions for Lisa directly, you can also direct those to NALSA and they will be passed on. Thank you guys so much. Lisa, thank you. Seriously, it was an honor to have you here today.
Thank you. Appreciate it.
Just in the interest of time, I know it's getting late and we're a bit behind schedule. So thanks to all of you for sticking it out. I think this should be a really interesting panel discussion. As you probably all know, I'm Jared Carter on the faculty here. And we have some other swans joining us today. So we have James Pepper, who's the chair of the Vermont Cannabis Control Board, and Kyle Harris, who is the commissioner of the Vermont Cannabis Control Board, to talk with us a little bit about the lay of the land in Vermont, legislation, where we are, where we've been, and then we'll hopefully get some questions from you all. But I do want to welcome two swans back to the fold here. Welcome back, you two. And with that, I'll let you guys sort of introduce yourself and share any opening thoughts that you have.
Sure. Yeah. Thanks for that, and thanks for inviting us here. My name is James Pepper. I'm the chair of the Vermont Cannabis Control Board. I've held that role since April of 2021. Prior to that, I was a policy person and appellate attorney for the state's attorneys, the kind of 14 elected prosecutors in the state. Spent a lot of time in the legislature dealing with criminal justice reform efforts, and graduated Vermont Law in 2014, and here I am back in, is this Chase? Yeah, Chase.
Yeah.
Chase Center. It's great to be here.
Yeah, thanks, Pepper. Kyle Harris, JD Melp, class of 2015. I'm really excited to be back in South Royalton, although I do not live too far away, but I never make my way to South Royalton unless it's to go to Worthy Burger. So it's really awesome to be back, at Vermont Law School. Pepper and I are both part of the inaugural board of the Cannabis Control Board. We both started in these roles in April of 2021. I come to the board from the Agency of Agriculture, Food and Markets. I was an ag development specialist there. I helped put together the Food and Agriculture Strategic Plan 2021 to 2030 with the Agency of Agriculture. And before that, I was doing environmental law in DC. Pepper kind of alluded to, he's got the criminal justice reform background. I kind of bring the environmental agricultural experience to the board, and our other board member is not with us, but she brings a different level of experience than Pepper and I do to the industry, and I think we've really tried to utilize all of our backgrounds to kind of encompass as many different areas of the law as we can as relates to cannabis, because I'm sure everybody here has figured out today that it hits just about every area of the law that you could possibly imagine in one way or another.
Yeah, that's great. One of the things that we talked about earlier was ways that, where there are opportunities for VLS grads to get involved in this emerging issue of law. And I think one of the great things about having you all here is it really shows both the opportunity to get involved sort of on the regulatory, administrative side, and also we've had lawyers in who are in the industry side. So I think that's been really cool. Tough question. Chair, commissioner, what's the difference, and sort of what are your roles day to day in this regulatory process?
Sure, I'll start. The Cannabis Board, there was a lot of debate in the legislature about how to structure this new market, and it starts with what's the regulatory authority and where does it live. I had worked on a cannabis bill in a previous job when I worked for the former governor back in 2016 that was the first kind of cannabis-related bill to pass the Senate. And we had it structured very differently than this current Cannabis Control Board. We actually are going to kind of create a triumvirate between the Department of Public Safety, the Department of Health, and the Agency of Agriculture, and have those three commissioners or secretaries kind of rotate around to be the chair of this three-member committee. At the time, there was only 4 legal states, and we were operating under something called the Cole Memoranda because this is a federally illegal or controlled substance, I should say. We thought that we needed to have a law enforcement presence on that board. Subsequently, there was Governor Scott created a marijuana advisory committee to kind of dig into how this board should be structured, and they created an independent state agency in the executive branch, 3-member board. I think it was originally going to be 5 members, but really, the legislature did not want to spend $1 extra on regulating cannabis until the revenue started flowing from cannabis. They really stripped out a lot of the positions that were originally created, a lot of the funding streams that we originally were going to have access to, and they created a 3-member board appointed by the governor after kind of a long nominating process. And I am the chair of the board, but really there's very little distinction between what I do and what Kyle does, because there's only 3 of us on the board. We kind of, one of the interesting parts about the open meeting laws in Vermont is anytime more than half of a public body is in a room together, it's considered an open meeting. So we really can't talk to each other day to day. We can only talk in the context of an open meeting. And so what we've had to do is just kind of divide the work of the board into three, and we all kind of have our areas of specialty, and then we come, to announce public meetings and talk about them. We've had, I think, over 160 public meetings so far, and that's really the only chance that we have to kind of share ideas with one another. So.
Yeah, it's really interesting. It makes the workday certainly interesting when my office is not too far from James's, and we got to be very cautious of how we speak and interact to each other. As he alluded to, though, the initial authorizing legislation, I think, created 3 commissioners and 1, I don't think it was an executive director, it might have been an executive assistant, right? We now have a staff of over 20-ish, so we've been able to convince the legislature that we needed a robust enforcement division, a licensing division. We're hopeful we can get our own reference testing lab and some chemists to kind of help us out. But, and I think if I was looking at the agenda, it looked like tomorrow there's a conversation about the ways different states are structured, if I'm correct. And Pepper and I are part of an organization called the Cannabis Regulators Association, and every other states don't have an independent body like Vermont does. California, for instance, 3 different agencies, I think, are constantly trying to implement their program, and that makes it really challenging. I think there's a lot of states out there that are kind of envious of the setup afforded to Vermont and its ability to kind of work as one unit moving forward instead of stepping on each other's toes constantly.
Yeah, that's super interesting. You highlighted some of the challenges about a small board versus say a big state where there's all sorts of different agencies, and I think I can see drawbacks to both and pros to both. What do you two view, and I'm not sure if this is a question you feel comfortable answering, but are there legislative gaps? I mean, what's sort of the lay of the land in Vermont, and where could the legislature sort of address any gaps that you see as members of this board?
The vast majority of states, I think us in New York, maybe one other, the vast majority of states, with the exception of Vermont and New York, have the benefit of having a binding ballot initiative process, and that's what's really forced the hand of the legislature to create a cannabis program. We don't have that in Vermont, which means that our program had to be started through intensive advocacy at the General Assembly, convincing, at least half the legislature and the governor that this was a good idea. And it took, over a decade of advocacy to get to where we are today. Because we don't have a ballot initiative process, because this had to be blessed by, so many different people, this bill, Act 164, which created the Cannabis Board, went through at least 11 different committees. At least 4 more had the ability to add language to the bill. It really created, the camel is a horse made by committee. Like this, the bill that we got handed to us is the ultimate camel of a bill. It's internally inconsistent. It, for instance, it says support small farmers, try and encourage them to participate, but then it says, by the way, growing agriculture is a commercial product. It can't happen on a farm. It's got, we want tested, regulated products for people to consume tested, regulated products, and yet there's a whole list of products that are widely available on the illicit market and are prohibited on the adult use market. There's intensive environmental standards, and we have some of the worst packaging statutes in the country that just double the amount of single-use plastic that there are kind of consumer waste. So really, this isn't unique to Vermont. Every state, because of the pace that this market evolves, needs kind of good housekeeping legislation, just like our captive insurance industry has housekeeping legislation every year to maintain kind of our gold standard. We have a number of bills that are running through the legislature currently that are fine-tuning the market, and I'm happy to speak about the specifics of those, but I think that's just the state of affairs across the country, not just Vermont, that we need to stay ahead of kind of the not stay ahead of the innovation, but just kind of respond to the innovation that happens in the industry.
Gotcha.
Yeah, I don't really have all too much more to add. I think you just ran the gamut. I think cannabis is really interesting right now because business is drastically outpacing the regulatory process. And so we're constantly trying to play catch up with some issues. And how do you regulate when you're constantly chasing an issue, when you've got to go to the legislature and go through that long, arduous process of trying to get certain things updated?
Yeah, one of the things, I mean, obviously, we've seen recently in the media some of the difficulties of an emerging market like this. I'm thinking about, I think there was some issues around contaminated product getting into the market. Is that part of some of the regulatory changes that the legislature is looking at to try to deal with some of those things, or?
Absolutely. You know, this original bill that I worked on back in 2016, the Senate recognized the need to kind of not only just protect Vermont consumers from contamination, but also to protect the Vermont brand, this kind of made in Vermont brand that we have with our craft beer industry, with our maple industry, with our cheese industry. And, you know, cannabis could put a black eye on that if we're not careful. And yet also the legislature said, you know, you need to do your best, Cannabis Control Board, do your best to shift the current legacy market into the regulated market. You know, don't just hand out licenses to large multi-state operators. Don't just give it to the existing dispensaries. Really try to kind of let the people who have been suffering under prohibition, suffering the criminal consequences of prohibition, you know, be the early participants and really be able to kind of saturate the early demand for cannabis. You know, that has its ups and downs. I mean, a lot of the folks that we've invited in have never been subject to regulation before, let alone some of the most intensive regulations in any industry. And, you know, things like sourcing genetics from the illicit market. We've seen kind of pesticides that travel multi-generationally through mother plants. And, you know, I think this contamination event has led to some changes at the control board, and the legislature has once again reauthorized and put money aside for us to create our own reference lab, which will allow for much more robust testing at the regulation side, regulatory board.
Yeah, 100% agree. You know, it's been challenging. I think we, recognizing, as Pepper alluded to, that, you know, a lot of folks have not really been subject to regulation, at least the high level of regulation that goes with an adult use cannabis license. We really want to educate before we enforce. That takes a lot of bandwidth from the board, where other states or other enforcement agencies might be less willing to kind of work with somebody. We've also been building this plane as we've been flying it, literally, and trying to land it while building it. And we continue to try and build it and get it better. And you know, we're all about educating, you know, and I think, you know, coming from the agricultural world, I think the average consumer generally views an agricultural product through its bad actors too often, not through its good actors. And so one of the struggles that we have, or at least I have, as a board member and somebody who's responsible for this program, is if there is a product recall, if there is a bad actor, you know, whether or not it was intentional or not, people hear about it. And how do we make sure that we still have the public trust that we can do our job effectively and put a safe product onto a market shelf that has the backing of the state seal of Vermont?
Yeah, no, that's fascinating. Sort of in that same vein, you know, 5-10 years from now, right? What would be like the happy ending, the world in which this is running perfectly? What does that look like in 5 to 10 years from a regulatory perspective, do you think, or even a marketplace perspective?
Go ahead.
Sorry, I should ask each of you one instead of making you. But
it's interesting, and I think obviously that an easy answer there is federal legalization. I think federal legalization is kind of this weird paradox, though, as it relates to cannabis. There's obviously a lot of benefits to federal legalization, you know, from your taxes to your ability to get a bank account to insurance premiums. The list goes on and on. At the same time, agricultural industries, especially, you know, we're at the crux of pharmaceuticals, biotech, big ag. All of those are looking with high, you know, levels of interest to this industry agricultural industries consolidate and collapse very, very quickly. So how do you protect the small cultivator, the small farmer through federal legalization, even though it provides them some benefits to actually be a small business owner? So that's not a really answer to your question. It's kind of a philosophical question that I'm still working through, but I think it's an interesting issue. I know many people that are advocates for federal legalization. I know many people that are not advocates for federal legalization, maybe a federal decriminalization that will allow some of those benefits from a tax and banking and insurance perspective to actually be fleshed out. But full-blown, it'll be a race to the bottom.
Right.
As far as
could you see a world, and I mean, Vermont's obviously done very well, and maybe this isn't the perfect analog, but Vermont's done very well with like the craft beer industry, and people come up and you see the Boston beer tours, buses driving. I mean, is there a world in which that is
100%? My worry is the point of which federal legalization happens and the point with which we can actually get there, because I don't think that they actually run into each other overnight. I think that will take time to build that kind of, the craft beer industry is still relatively new in the grand scheme of how we view alcohol. Can we get there quickly with federal legalization? I think some of the things that the Cannabis Control Board has tried to do is prepare people to differentiate their products at the retail level, understanding that there's always going to be somebody who wants the Bud Light variety, who other people might pay a premium for a craft beverage. So yeah, I don't know. It's a question that I struggle with constantly.
Oh, that's really interesting. I don't know, James, if you have anything to add to that, or
yes, I mean, one thing that the kind of RAND organization who wrote our original kind of blueprint for cannabis legalization warned us about is just that, I should say 3 or 4 mega farms in New York or Oregon, if there were to be interstate commerce, could supply the entirety of the demand for cannabis in Vermont. So, just flipping the switch and allowing interstate commerce through descheduling or rescheduling cannabis really breaks apart everything that we've been trying to work on, trying to build this fledgling industry up. The legislature gave us a incredible regulatory mandate, just hundreds of pages of kind of, you need to regulate X, Y, and Z of every license type.
And there's how many of you?
There's 23 of us
Okay.
now, yeah, but it started out, year one with just the 3 of us and 2 staff members. And really, we need to allow this nascent industry in Vermont to flourish. We have some very unique features of our system. Every state, because of the federal illegality, gets to, design a system that's independent from one another. We, for instance, have an unlimited licensing structure. So we don't have a cap on licenses. It's a very common feature in many other states. This year, Cannabis Board is only going to release 50 cultivator licenses and 10 retail licenses, and they're all going to go to the existing medical dispensaries. We don't have that in Vermont. We have an opportunity for everyone to participate. There are, of course, barriers to entry to this market, unlike any others, but what we think that this kind of intensive competition will allow for is specialization, niche products, and kind of a real commitment to craft. I mean, we know in Vermont, and people that are traveling to Vermont, they like to know their grower, they like to know their brewer, they like to know their cheese maker, their sugarer, and we're finding that that's very much true in the cannabis industry as well. But we can't just kind of wipe it out overnight. Our Regulators Association, I think, has actually said, however the federal government approaches federal legalization, just do it cautiously and allow the states to have some control over their own markets and what they've built.
Yeah. I mean, you mentioned the federal sort of stance of things. Is there conversation in industry or among regulators at this point that there's concerns that the feds could go the other way at this point? I mean, I think sort of the odds-on consensus is that we're going to see legalization at some point at the federal level, maybe not. But is there a concern? I mean, there's a huge investment by the state. You all are involved, industry investments, that, a new administration comes in and says, no, we're going to start enforcing these laws around cannabis.
Yes, and there was a moment in 2018 when, Attorney General Jeff Sessions rescinded the kind of roadmap that almost every state was using to allow legal sales of cannabis and not have these DEA, take special interest in their cannabis industry. So we all had this moment when the Cole memoranda were rescinded that no one in the industry knew. We didn't have, we didn't have an adult use system in Vermont, but across the country, everyone kind of just stopped what they were doing for a minute. And then, this is a $30 billion industry annually. It's projected to grow to $60 billion in the next couple of years. It's really hard to just pump the brakes on that, even with rescinding the Cole memo or just having a kind of anti-cannabis federal administration come into play. And I think if we did see that at Congress, I think, when we're almost at the tipping point with respect to adult use states, we certainly are with medical, 37, 38 medical states, where you're seeing protections at the federal level for medical states. I think we're going to start to see those same protections for adult use states once we kind of get to maybe 30 states when we have a veto-proof majority in the Senate. Because the House has done it already.
Right.
The House has passed safe banking 7 or 8 times just to see it die in the Senate.
So on the banking, that's actually, so what is the lay of the land in terms of access to banking, access to insurance?
Yeah.
I know that I'm fairly certain many of the folks have to, it's cash only, right?
For the most part, yes. We have a number of state-chartered credit unions. The National Credit Union Association has been screaming from the rooftops, get into cannabis banking. There's no reason not to. We have this kind of financial crimes memo, FinCEN memo, about how to do it, and there's no reason not to, and this is a tremendous service to your industry. I mean, you think, part of the Cole memo is we're not supposed to try and give licenses to people that have ties to criminal organizations. Well, what better way to launder money than having a total cash industry? It's just a little contradictory. That FinCEN guidance, that memo, it's just guidance. It doesn't have the force of law, but it could apply to federally chartered banks as well. And no bank that has followed the FinCEN guidance has had their charter revoked. But the Federal Banking Association, Federal Banking Association has said the opposite message. Just don't get involved in this. This is, this is drug money. This is, and just don't do it. I've heard, we came very close to having a compromise on safe banking last year. It's a tripartisan effort. My understanding, what I'm hearing, is that the kind of ship has sailed on safe banking, and that the Biden administration is preparing a new Cole memo style document to kind of help direct the industry.
Interesting. So a couple more questions, then I want to open it up. I guess from sort of a VLS-centric perspective, what is, what's a day in the life like for you both, and what sort of opportunities do you see out there for folks graduating with a law degree or a master's degree or a dual degree in this space?
Yeah, what does our day-to-day look like? It's a really interesting question. I think the role that Pepper and I and our other board member, Julie, have played over the last, 2 years, it's crazy, has changed every month from, if I'm going back to the beginning, we all were very intentional of outreach to the cannabis community. We didn't put a pen to paper as far as rules for 3 or 4 months. We wanted to talk, we wanted to hear from folks. What did they want to see in this market? How do they want it to take shape? I think we broke the record with how fast we actually got through the administrative rulemaking process in the state of Vermont. And that's largely, I think, because of all the outreach that we did and public comments that we looked at and accepted as it related to how this market should function and how it should look. We were able to hire, and thanks to a lot of Pepper's efforts, convince the legislature to give us a lot of tools to kind of maintain the proper functioning of the market. Right now, the legislature's in session. Oftentimes, our bandwidth is taken by talking to the legislature. I'm working on a sustainability certification for our cultivators and manufacturers. So, I think the board right now, we don't always get involved in the day-to-day activities. We leave that up to our staff, and we kind of focus on the big picture, the programmatic changes that we want to see as we continue to move through iterations of, legal cannabis in Vermont. How can folks get involved? That's a really great question. And
I'll take that piece of it because, this regulation of cannabis has touched nearly every single one of the executive branch agencies. We have a very close partnership with the Department of Financial Regulation that regulates insurance. We didn't touch on insurance and banks. We have a very close relationship with the Attorney General's office, the Agency of Agriculture, the Public Service Department. This is one of those areas where every aspect of state government needs more lawyers to help them understand the roadmap of both the federal status and the kind of current Vermont status. Every one of our licensees could benefit from, we try to make our rules as user-friendly as possible and, use plain English and have guidance and support documents and have technical assistance for people, but honestly, everyone could benefit from the help of a lawyer, and so, but there's very few of them in the state right now. And so, as far as getting involved, if I were a 3L, I would want to do an internship with a cannabis company, or, call up any of the state agencies that intersect with cannabis regulation and just say, I'd like to be your cannabis person, because we're all trying to figure it out together, and it's new for everyone.
Yeah, it certainly seems like the growth, explosive growth, certainly pretends opportunities for lawyers. And I like that. For most time, you don't hear people say we need more lawyers, but we're out of law school, so hey, what the heck. All right, great. Well, thanks to both of you. We have about 15 minutes left, so happy to turn it over to questions from the crowd.
James is like staring me down. So I've made no secret of my feeling that I think the regulatory rollout has generally been quite good and smooth and on time, and give you guys a lot of kudos for doing what you've done. So just thank you again. But looking back at your regulatory decision making, I would love to get your thoughts on what is the one thing that you wish you could do over differently.
For me, I was advocating on behalf of the governor for tax and regulate in 2016. I mentioned that a few times now. That bill included a $500,000 appropriation to build a state reference lab so that we could do the kind of testing and compliance test, quality assurance testing that is necessary for any regulated market. I mean, the promise that we're offering people if you walk into a retail store is that the product that you're consuming is free from harmful contaminants. And while we have a compliance team that is out there and we've changed our sampling methodology, and every time we conduct a test, we have to use a private lab. Our state agriculture lab, they're not allowed to touch cannabis, and they don't have the capacity to do even if they were authorized. And so, every time that we test a product, we're skipping in line in front of a licensee that's, waiting 6 weeks for a pesticide test. And when we have a contamination event and we have to test 35 different samples, that can push that 6 weeks out even further. And really, some of these resource issues should have been worked out prior to the market coming online. We were appointed in the height of the COVID-19 pandemic. We were appointed late. We missed this legislative deadline to come to the legislature and tell them what kind of resources we needed in advance of the market opening. The legislature had left town by the time we had even really been seated. And so, we talk about building a plane while it's taking off. I mean, it really is kind of like building a fire truck on the way to a fire that's burning down, a town. And so, I think if we could go back in time and just know what we know now, I would have said, we need more staff and we need more resources on the front end before we open the door. They certainly would have, I think, hopefully avoided this contamination event at the very least.
Yeah, I agree with all that, and I'll save being too pointed, Dave, because a lot of the changes you'll see in our role updates coming in the next couple of months. I think in the rush to kind of meet deadlines, knowing that we were seated 6 months late, we started working as expeditiously as we possibly could. I think, and Pepper kind of alluded to this, we work with so many different state agencies. A lot of state agencies weigh in on what we do. It would have been really nice at the beginning to have more open and honest conversations with the leaders of a lot of those state agencies. I think, state agencies, they accept a lot of federal dollars. A lot of state agencies are a little skittish about working with the Cannabis Control Board because what does that mean and how does that impact their ability to continue to receive federal dollars? The Agency of Agriculture gets a lot of federal funding. There was at one point, we were thinking about doing our enforcement through the Agency of Agriculture. That took a lot of time and understanding whether or not it was a good idea. Same with the Department of Liquor and Lottery. It impacts our ability to use the Vail Lab, the Vermont Ag and Environmental Lab in Randolph, because folks are really conscientious about having something that's federally illegal in their possession, perhaps. And so I think, if we would have had some clearer messaging from the top down, so to speak, from the executive agency perspective about what are those concerns in actuality versus theoretically, a lot of even the stuff that Pepper is alluding to with a reference lab could have been avoided as well. But people are skittish. Their first reaction as it relates to cannabis is, how does this impact me from a regulatory perspective? And so that means we have to do the extra work to convince them that they should be comfortable. And as we've said, there was 3 of us and a staff person at first, and we just did not have the time to get everybody comfortable as we would have hoped to at the beginning.
Okay, in terms of need and want from the industry side of things, what were the biggest considerations you guys had in the rulemaking process?
We did certain things that the industry wanted, of course. We tried to keep all of our barriers to entry as low as possible. The biggest points of friction between the Cannabis Board and the industry are certainly around our plastic ban. That was not in the statute. We decided that was, we decided that it was a good thing for the health of this industry, and it's the direction the industry is moving in, but it does make Vermont a very challenging place to get compliant packaging when no other state is requiring kind of non-plastic materials. So, if California did this, then the packaging industry would respond very quickly. The other big points of contention are our insurance requirements and our banking requirements. Both the insurance requirement is statutory. It just, in the law, it says all licensees shall maintain commercially reasonable levels of insurance. So we didn't have much wiggle room on that. What we said is if you can demonstrate a hardship in getting insurance, you can apply for a regulatory waiver, but you have to set aside some amount of money so that if there is an incident, if there's a slip and fall, if there's an injury, that you have some pool to draw from to kind of, satisfy those claims. The banking, again, we require a bank account. We have the same regulatory waiver process. If there is a hardship, we're seeing astronomical fees in the banking side for, no one's lending, I should say. There's no financing. It's all just depository accounts, and $500 a month, or some percentage of your deposits. It really makes this market inaccessible to very kind of our tier 1 cultivators, especially these craft cultivators that just don't have an extra $500 a month to park money. So. I mean, those 3 areas, I think, are our biggest points of contention. There's a lot that we've done with the industry support and blessing. I mean, we really did try and listen. But, again, this is an iterative process. We are amending our rules and asking for new legislative authority to make this market more accessible, to make it more profitable for kind of small, local Vermonters.
Yeah, and just quickly bouncing off of that, I think one of the things that we've been really intentional about from the get-go is, a lot of folks want a lot of things. They want to be able to sell this product directly from their farm. We don't hold the authority to allow them to do that. That's a legislative statutory change that needs to happen. So educating a lot of folks about what we can do versus what you need to speak to your elected officials about is always a challenge. The difference between, a statute and a regulation, just as we've said, there's a lot of people that we've licensed that have never been regulated before.
Hi, thank you both for being here and for doing this panel. I really appreciate it. And
So I'm familiar with the accessory on farm business statutes. The legislature was intentional that this is a commercial product, not an agricultural product. I mean, Vermont agriculture enjoys 80 some odd exemptions from land use planning. I think, if I'm recalling concerns as to why this, they didn't want to consider this an agricultural product. I think there was concern that out-of-state companies would come into Vermont, buy up agriculturally designated land, and ruin that little craft market that we all wanted to see. And so they made it a commercial product to kind of help stave off the Philip Morrises of the world or other multi-state operators from coming in here and taking advantage of all of the exemptions that agriculture enjoys. Right now, there is a few exemptions from land use planning that cultivators can take advantage of. A lot of it's around taxes, how your land that you own is taxed at what rate based on its use. But a lot of that is only applicable to current farmers who are operating at our smallest tier. So it's really weird to regulate this plant that's growing out of the ground and it's not considered agriculture. I can see, I believe it is an agricultural product personally, but the more you dive into how we regulate agriculture as a state, there are concerns from a lot of folks in the agricultural community as to whether or not this should be considered agriculture. I don't know if that really answers your question.
This might not be in your purview, so I apologize. I'm from Minnesota, so I'm not super familiar with Vermont legislation yet, but how much do you deal with the hemp industry within the umbrella of cannabis, and how are you seeing the differences develop in the industry now that there's more legal elements for people to pursue hemp through as well?
Yeah, so I used to help the Agency of Agriculture with hemp. Hemp's really, really, really interesting, and I think it's honestly, right now at least, almost more challenging to regulate than high THC cannabis. And that's because there's so much innovation going on, and what you can derive from what's considered a federally legal hemp plant that wouldn't be considered federally legal on the high THC side of things. We have the authority to regulate hemp processors. There is no longer a state hemp, we don't regulate hemp growers at the state level anymore. We turned in our regulatory authority to USDA, so every hemp grower gets a license through USDA. The Cannabis Control Board is currently undergoing a regulatory process to regulate hemp processors. And as I've alluded to, folks are figuring out how to turn hemp into intoxicating products. And so are those still hemp? Are those derivatives hemp? Or if it's intoxicating, should it be regulated in a manner that an adult use high THC cannabis product should be regulated as? So hemp is really complicated. Let's put it that way. And I have empathy, The price per pound of hemp is $2 or something like that. The price per pound of high THC cannabis is a lot more, and hemp growers want opportunities to turn their product into something that could, yield them some type of net benefit. but there's not a lot of good science on these intoxicating hemp products as it relates to getting state agencies comfortable with being able to allow them to be sold in a convenience store or somewhere where you're not age gating who can actually buy these products.
With the recent DEA decision on Delta 8, how have you seen that play into the regulatory space in Vermont?
You know, it's the Delta 8 determination, it's just very difficult to really, you know, as Kyle said, figure out the path forward here. A lot of states in response have just banned Delta 8 statewide. You know, we see that happening more and more across the country, potentially Delta 10 as well. You know, we are gonna, you know, and there's a recent study, very little scientific literature, inhalation studies on these synthetically derived cannabinoids. And there was one out of Portland State University very recently that concentrated Delta 8 in vape cartridges when aerosolized and vaporized produces ketene gas, which is the same thing that led to the Avali crisis in 2019 and 2020. You know, we have a path forward for regulating Delta 8. You know, we've submitted a hemp-derived products report to the legislature when they gave us the authority to regulate hemp-derived products. But I think, just like we have been with cannabis, I think the legislature wants the Cannabis Board to be very cautious when it comes to these intoxicating products. And I think Delta 8 falls squarely within that and I think that, if we are to allow Delta 8, sometimes when you're creating concentrates, it's a natural byproduct. And so if we're going to allow it at all, I think it would be through our adult use cannabis retail establishments. Not through things like gas stations and, wherever else.
Do you, either as your official capacity as the board or personally, have any recommendations for the legislature of what to earmark the tax revenue for?
So it's a little bit unusual for a regulatory body to tell the, legislature, or the General Assembly, how to spend their money unless it's related to our budget. We were given an equity mandate. We were told to kind of support licensees that have been disproportionately harmed by the war on drugs or directly harmed by the war on drugs. And, fee waivers and expedited review is not enough to help those folks. We're talking about intergenerational poverty. The criminal convictions can do damage for well beyond just kind of getting a cannabis license. That's not going to help kind of address the harms that the war on drugs has perpetrated on communities of color and just individuals. So we have made a recommendation to the legislature that they need to dedicate a portion of the excise tax revenue towards both the Cannabis Business Development Fund, which is a fund that's set up to support social equity licensees. Also, we've asked the legislature to set aside a portion of the excise tax revenue for community reinvestment. We recognize that not everyone who's been harmed by the war on drugs wants to start a cannabis shop or be a cannabis cultivator. Some people might just want more access to health care or education or green spaces. We've made those recommendations. So far, 70% of the, 30% of the excise tax has been earmarked already for prevention and education. 70% is going to the general fund. And so really, there's an opportunity there. We'll see how the legislature deals with that. I think they're waiting really to see what the excise tax is going to look like, how much revenue there's actually going to be before they start appropriating it. But the recommendation's out there, and it really turns on people other than regulators, advocates, to make the really political case and the moral case as to why that money might belong somewhere else than the general funds.
Any more questions? All right, well, thank you very much, Kyle and James. Really appreciate it. Always great to have a couple of swans, and I will give you certainly a round of applause. Thank you. All right, I think that wraps it up, right? All right, I don't know if you guys have any closing remarks or anything, but okay.
I just want to thank everybody for coming out today. We will be back here at 9 a.m. tomorrow, kicking off with diving into what this kind of looks like on the grand scheme of the United States, diving into what the differences in states are, and then we'll move into equity later in the day. Also, if you have any interest in buying raffle tickets, we will be selling those and we'll be drawing the winner tomorrow.